with the role of external counsel in international arbitration. Allow me to introduce myself. I'm Florian Nițu. I'm a Romanian lawyer, international arbitration active. Together with me in the panel, and this distinguished panel, on my left, Stephen Finizio. Stephen is a partner with Wilmer Hale in international dispute resolution. He's also a renowned arbitrator, a member of various arbitration courts, including the LCIA, to give a name. He's also a teacher and teaching arbitration classes with academic institutions such as the SOAS University of London, and of course he's publishing intensely in the field. Welcome, Stephen. Thank you for being with us today. On my right, we're pleased to have Federica Bocci. Federica Bocci is a counsel with DLA Piper in Milan. She's highly experienced in international arbitration, but also does significant amount of cross-border complex litigations. She's an author in dispute resolution matters and a very active member of the arbitration community in Italy. Thank you, Federica, for being with us today. On the right is Felipe Cavalleros. Felipe is the global co-head of international arbitration practice with Simmons & Simmons. Is currently based in Paris. An arbitrator as well with significant wealth of experience. He's involved in numerous academic activities. He's lecturing often with universities such as the Trinity College in Dublin or the Hague Academy of International Law. So he's also publishing intensely. We're very happy to have him today with us. Welcome, Philip. And of course, the last but not the least, we have Philip Peters. Philip Peters is a founder and the managing partner of a international outfit based in Vienna, Peters Owner and Partners. He is widely recognized by most of international legal directories and publications in the sector as an expert in international arbitration, but he is also very much involved with structuring and negotiation of international project contracts. Glad to have you, Peter. Our main purpose today is to break down into fundamental pieces the role of external counsel in international arbitration. And we will be looking at the initial phase, the phase where a dispute resolution mechanism is effectively chosen, negotiation of an arbitration agreement, of arbitration clause, of alternative dispute resolution mechanisms, negotiation and the role of counsel in negotiation in setting the framework for negotiation of a dispute. At the time such a dispute is in crystallization, it only crystallizes. Then that is something that Federica will discuss. Then we will look at, together with Stephen, we will look at guidelines, the IBA guidelines on party representation. We'll take advantage of the fact that symbolically we're celebrating the 10-year anniversary this year of these guidelines, and discuss how effectively they have been used. They are used, to what extent they are sometimes getting in conflict with various deontological codes or the various bar rules applicable to the counsels involved in the disputes at the seat of the arbitration, and as well to what extent they require revision. In this context, Stephen will look at the guerrilla tactics and how to deal from a tribunal perspective as well based on his arbitrator experience, how to deal with such conduct and to what extent the tribunal is in the position to sanction the party and to what effect and in what scale. Then we'll have Philip Cavalieros looking at the conduct throughout the proceedings, from the appointment, from the arbitrator's appointment, composition, experts, relation between the parties, counsel to counsel, counsel to experts. The key elements that one must consider in relation to procedural order number 1 and so on. And in the overall context, we'll have Philip Peters looking at how to manage costs and expenses, actually in all these stages throughout the entire process. So this being said, Federica, you have the floor.
Thank you. Thank you. And this is, okay, this goes, okay. So thank you. I wish to thank the Romania Court of International Arbitration for inviting me to discuss the role of external counsel in international arbitration in this very prestigious conference. So I have been asked, as Florian introduced me, to address the role of external counsel in the pre-litigious phase between two or more parties. And although this topic might seem to lead to very obvious and simple conclusions, facts show the exact opposite. In my experiences, there are a number of issues that parties overlook when managing their contracts negotiations and execution phases. And this leads to disputes. Now, I'll be honest and candid, I'm a litigator, so the more disputes, the better. Sometimes I also see it as an arbitrator. But in the end, our duty of integrity and fairness that are recalled in the IVA guidelines on party representations finds their utmost expression, I think, in the end, in rendering an efficient service to the parties. So in my view, disputes should be the ultimate resort to protect parties' interests and rights. So external counsels should, having a role implies taking certain actions. I will not go into the definition of role by the Oxford Dictionary, but there are certain actions that should be pointed in the direction of efficiency. And in my view, an efficient service is given when it provides a solution that is stable over time. So dispute resolution clauses should be tenable over time. Or if, for example, you negotiate a settlement agreement, that settlement agreement should be stable over time. Otherwise, it's not going to be efficient. Quality goes hands in hand with the stability. So you need to carefully draft dispute resolution clauses, select the applicable law, so to provide a tenable solution. And of course, efficiency is driven by cost and time effective solutions. Just keeping in mind this driver, efficiency, I think the role of external counsel in the pre-contentious phase goes through three main areas, which is the assistance to the parties and to, for example, transactional lawyers in the negotiations of dispute resolution clauses, the assistance in the management of pathological situations, and the assistance in the identification of the most adequate strategy to manage the pathological situation. Now, in the allotted time, I will not go into the details of each phase, but my aim was just to draw the attention on some aspects of, for example, negotiations of dispute resolution clauses. Because we all know that the negotiation of a contract or of a transaction is managed by commercial people, by corporate lawyers, and I don't have anything against corporate lawyers. I love them. My colleagues always revert to me, but they do that at the very latest stage. And in my view, when you deal with negotiating dispute resolution clauses, you should involve external counsel, especially litigators or arbitration specialists, before the dispute arises, not when the dispute arises. And I'm saying this because I apologize. I use the word that I perhaps would change now. I shouldn't say poorly drafted dispute resolution clauses, but I would say inadequate drafted dispute resolution clauses. That would lead to uncertainties. For example, if you don't specify what kind of disputes are covered by the arbitration agreement, are they only referred to contractual liability claims? Do they cover also tort liability claims? That would lead to uncertainties. And uncertainties lead inevitably to preliminary objections on jurisdiction, on admissibility of a claim. And that has an impact on the duration of the proceedings, because there are guerrilla tactics. We have all been there. And this has an impact on cost, on which I know that Philip will dig more into. And this ultimately lead to what I think is an inefficient service. So in my view, there are a number of questions that should be raised when negotiating a dispute resolution clauses. The first one is whether parties should opt for arbitration or state court litigation. There is not one size fits for all solution, and precisely because of that, there are a number of questions that the parties should be answering to select the most suitable solution for them, for the industry, for the specific sector in which they're operating, for the kind of transaction. So you need to understand whether the party you're assisting is either the vendor, the buyer, is it expected to be receiving money or paying money? And that makes a difference on what dispute resolution method you select. So usually arbitration, in my experience, when there are projects or transactions that have multi-jurisdictional points and elements, arbitration is the easiest compromise, because it's very difficult that parties would give in to the other party's jurisdiction, so they come in the middle and opt for arbitration. So once, and let's focus on that, otherwise I wouldn't be at this conference. So let's imagine the parties selected arbitration as a dispute resolution method. The second question that should be asked when negotiating dispute resolution clauses is whether the parties would opt for ad hoc arbitration or administered arbitration. And these are two very different animals and have very different consequences on the procedure, on the cost, on the development of how the evidence is collected. And I think, in my experience, parties are not always made aware of these consequences. So we all know that the dispute resolution clause is called the midnight clause not for nothing. They just often, corporate lawyers just cut and paste from previous transactions that maybe have nothing to do with the project that they are advising on the certain client. And I'm not expecting that clients would understand every tiny little technical issue, but they should be made aware of the basic consequences of their choices, and sometimes this doesn't happen. One important thing is the seat of arbitration, which is not a geographical concept, but it's a procedural concept, and parties do not often appreciate the difference of having an ICC arbitration seated in Zurich rather than Milan, for example, or Bucharest. The seat of arbitration, as we all know, pertains to some procedural issues or implies the definition of some procedural issues, and the most important of which is the challenging and the set-aside of the award. So the selection of a particular seat has an impact on the stability of that award, might have an impact on the stability of that award. And that should be made clear to the parties and selected in the dispute resolution clause with a certain degree of awareness, in my view. And finally, the famous escalation clauses, are they profitable, should be included. In most energy contracts, infrastructure projects, they are included in, sometimes in my experience, they're just, as I said, cut and paste from previous transactions. There are pros and cons, and sometimes parties do not appreciate what are they signing off to. So I don't have much time to go into the details of this distinction. This is just some very basic distinctions between ad hoc arbitration and administered arbitrations, but I, just wanted to make the point that choices that we as external counsel suggest to our clients have very important consequences, and I'll be happy to go over through the differences over the Q&A or over coffee afterwards. Same discussion about negotiating dispute resolution clauses that include escalation clauses. There might be pros and cons, and you need to, you kind of, as an external counsel, when advising on negotiating clauses, you need to work as of imagination. Because when you're negotiating clauses, dispute resolution clauses, you're doing that in a moment when the parties are friends, they are partners, they are developing a commercial relationship. But you have to imagine in that point in time that the relationship might get sour. The parties, it's inevitable. Otherwise we wouldn't be doing our job and working, but they will fight at a certain point. And you have to imagine that, and you have to imagine what is the likely position that your client is gonna be in. Going to the management of pathological situations, the same thing applies here. So when you manage pathological situations, again, I apologize, I should have written inadequate management of pathological situation, not poorly managed. But anyway, if you manage a pathological situation without truly understanding what the ultimate goal of your client is, it might lead to unnecessary tensions, which lead to unnecessary disputes, unnecessary costs, and thus conclude in an efficient service. Now, in my very first lesson of civil law at university, many, many years ago, a very famous Italian professor, Professor Trimarchi, started the lecture by saying a statement that really literally made my jaw drop. He was like, yeah, you think you're gonna study the law and the principle and the philosophical and ethical principles behind the rights and the justice, but in reality, you're not gonna study that, because in reality, it's all about the economic value of a right. And after many years of experience, I actually have to agree with Professor Trimarchi. I don't want to become too cynical, but I realized that the parties, the clients, ultimately want to run their business in a profitable and sustainable manner. And to be profitable, you need to be efficient and manage even the pathological situation in a cost-oriented manner. So now, these are my very few suggestions. In my view, external counsel should be involved in pathological situations as soon as possible. So if you have an infrastructure project or procurement contracts, claims arising for delays, price increases, in my view, external counsel should be involved as soon as possible. But in my view, they should be involved behind the scenes, because playing the card of external counsel at the outset might create more tensions rather than curing the tensions. It might actually bring up a flame that then it's going to be very hard to extinguish. So external counsel should actually review contracts with a fresh pair of eyes. Sometimes it happens that clients get too much into their own narrative of how the contract has been executed. And the role of external counsel should be the exact opposite. In my view, to manage a pathological situation in an effective manner, the client should invest the money to have a pre-contentious assessment. And I want to draw your attention to this term, invest the money. It's not spending money, so it's not an inefficient service. I think it's investing the money to understand whether or not there is a claim, whether or not that claim has a certain value and which value has that. An external counsel can do that job, and I'm referring to especially infrastructure projects, construction projects, with the help and the assistance of technical experts. And even in this respect, sometimes clients do not understand, do not appreciate the importance of involving technical experts sooner rather than later. Sometimes clients turn to me and say, yeah, but that assessment cost me 50 grand. It's too expensive, and let's see how it goes. And eventually, it has happened to me in one of the very first arbitration that I managed, that we relied only on the data that the client had collected. It was a geothermal power plant, precisely because the client didn't want to spend the money, didn't want to invest the money on a technical expert. So we relied on those data. And it turns out that in the middle of the arbitration, so in the middle, I'm saying after the statement of claim had been served and notified and submitted, that when we were forced to appoint the expert not only came up to the conclusion that the data were not reliable, the data collected from our client, but they were also incorrect. So that led to a reduction of the claim that we made on that specific technical point. It was a geothermal power plant, so it was about availability and production of the plant. And it doesn't look good when you have to reduce your claim, because you lose credibility. And eventually, you start an arbitration with a certain values, and values of the arbitration has an impact on cost. So why should you spend arbitration fees for a dispute that you claim to be in the range of 5 to 10 million, when perhaps it turns out it's a 3 million claim, and maybe you can access an expedite procedure under the most famous arbitral institutional rules. So my point is that the role of external counsel in managing pathological situations should be to play the devil's advocate and carry out a very precise and meticulous SWOT analysis of the case. I mean, as I know yesterday you discussed about third-party funders. Third-party funders do an extremely detailed due diligence. Why shouldn't the client do that? I mean, if the client is ready to invest the money on a third-party funder's due diligence, it should be ready to invest the money to do that in-house with the help of external counsel in cooperation with technical experts. So that's my proposition. And when it comes to the identification of the most adequate strategy, again, in my experience, it's not unlikely that the people working on a specific project, engineers and commercial people, get very emotional when it comes to a specific project, and then the relationship goes sour and it comes a dispute. And that emotions kind of impact the ability to identify the appropriate strategy. So I would like to give you an example, very recent. I cannot go into much details of this because it's ongoing, but I'm currently advising a client on, it's a logistic plant, I'm closing up. It's a logistic plant, so It's a, the contractor breached the contract, and so they wanted to have an assessment on whether they should terminate the contract or settle out of court. We managed to have the technical experts on board, and so we were doing the assessment, analyzing a lot of data, and the day before we had to access the plant, the board overnight resolved to terminate the contract. And we were informed the day after, and I was like, okay, but we haven't finished the assessment yet. And oh yeah, they resolved that, and we kicked out the contractor. And I was like, what? What did you do? Yeah, we cut off the badges, and so they can't get in. I was like, okay. And that is likely to have an impact on the evidence collected, because now we have the plant over there, and all the data that has been collected might actually be contested, because it's likely that the contractor will say, you had the plant, you kicked me out, we don't know what you did with that plant, we don't know what you did with those data, so these data are not reliable. It's very likely they will say that. So in this role, I think that the role of external counsel should actually help the clients to manage and preserve the evidence, identify the best strategy to actually bring forward only those disputes that are likely to succeed. And that's concluding my presentation for the time being. Thank you so much.
Thank you, Federica. Very interesting. I'm sure there are questions. I have a couple myself, but I suggest just writing them down, and we'll address them at the end of the session. I would move now to Steve. Thank you.
Thank you. So my topic, in a rough sense, is the IBA guidelines on party representation. And when Florian had proposed the topic and noted it was the 10th year anniversary, I thought this is terrific, in part because it took me back to a point in time, 10 years ago or so, where every conference we went to, its hot topic was the question of what was called at the time ethics, and ethics in international arbitration. So every single conference, and we do this in waves in international arbitration. We pick hot topics. The next 2 years, every conference will have an artificial intelligence component to it, and we can predict the topics. But it was ethics, and it was also at a time when we were seeing an explosion of soft law relating to international arbitration. And I think more broadly, and I think I'll come to this time permitting, the role of soft law in international arbitration is a very interesting area. And obviously something like the IBA guidelines is a perfect reason to discuss that. And Florian asked some questions like, let's examine their use and their popularity. How do they hold up today? Should we revise them? And then he wants me to tell war stories. I'm not sure I'll get to all that. At some point, we'll get there. But that first question, let's start with what are the IBA guidelines on party representation. I'm actually going to spend a little time on what they say, but let's start with what they are. They are the little sister or little brother of the more famous IBA rules. They're not nearly as famous as the IBA rules on the taking of evidence. And if we want to talk about soft law and its impact in international arbitration, obviously the IBA rules on the taking of evidence are the most influential, I think, set of rules. They're also the little sister or little brother of the IBA guidelines on conflicts of interest, which also are among the most influential soft law guidelines that have had a massive influence in the way people conduct arbitrations. So the first question was this question of examine their use and popularity. So I thought I'd ask you, has anyone in this room ever formally applied the IBA guidelines on party representation in an arbitration? One person? Two people? Once, okay. So maybe that in part, only in part answers the question, because like other soft law guidelines, like these other IBA guidelines, they're obviously not law. They're not mandatory. They have to be adopted. So do they have value if no one, or two people once? How many times have you used them? Once. So in the 10 years, or three, another hand, so we've got a handful of one-time examples, right? So are they important? What do they do? Let's talk about that. And then we'll get to the question of whether that means they're useless, valuable, and whether they should be revised. And let's start by reminding ourselves, what are they? Who made them? The IBA, International Bar Association. How many people in the room are members of the International Bar Association? It's a voluntary group of lawyers, only a couple of us, but you could just send an application and every single one of you can be a member of the IBA. The IBA then has a committee. It's not as easy to get on their committees, but a committee at the IBA, a voluntary association of lawyers, wrote these guidelines. It's a mixture of, if you look at who wrote these particular guidelines, very familiar names, people from various jurisdictions, but it is, let's remind ourselves in the soft law context, it is a group of volunteers, right? That's what this is. So I think that's always important when we talk about these things. So what was the IBA guidelines? What motivated the IBA guidelines? Well, they did a survey at the time, and the survey results came back saying that there was a high degree of uncertainty about what rules govern party representation in international arbitration. And that's because, and Florian already hinted at this, there are lots of potential rules that can apply to the conduct of party representatives. And by party representatives, we mainly mean the lawyers representing parties in arbitration, but in many places, most places, that doesn't have to be a lawyer, which complicates things a little bit, which hence the phrase party representative rather than counsel or lawyer. But there are multiple rules. The rules governing the lawyer from their home jurisdiction, their bar association, whatever the licensing or other regulatory authority that may govern that lawyer's conduct is where they're qualified, is one set of rules that may apply. It could be the law of the arbitral seat. It could be the law of the place where a hearing physically takes place. It could be all of those things. And as the IBA observed at the time, it also gets super complicated in international arbitration when you have both parties coming from and lawyers coming from different jurisdictions. But many of the lawyers on a team on one side of a case may be qualified in multiple jurisdictions. There may be multiple offices in multiple jurisdictions, multiple lawyers. So you have this mess. And that's part of the reason why we had this turned into such a hot topic at the time, because everyone identified the problem, but no one could quite identify the solution. And so the IBA stepped in a bit to try to start to address some of those issues. Now, what did they come up with? They came up with a set of rules that ultimately conclude that party representatives should act with integrity and honesty and should not engage in activities designed to produce unnecessary delay or expense, including tactics aimed at obstructing the arbitration proceedings. I take it no one in the room has a huge quibble with the idea that the lawyer should act with honesty and integrity. And frankly, when we go through the rules quickly, they're interesting in two ways. One is that they pick up on some of the things that were interesting to people at the time in some settings, and otherwise operate on that level of saying you should act honestly and with integrity. So when we talk about the value, that's one of the things that we may talk about. But let me tell you what I think the real value in the rules, before I tell you the rules and talk a little bit about soft law. What the real value, I think, was at the time, what they did, and they're a mixture of best practice and I think more normative judgments, was to say, if you're going to do international arbitration, you can look at this set of rules and you can see that the other people involved in this arbitration may be doing these things. And I'll talk about these things in a second, what these things are, but other people may be doing these things and think they're proper. So you should go into an arbitration with your eyes open. And in particular, when we talk about document disclosure, when we talk about preparing witnesses to testify, these rules said, lots of people are going to do it this way. We, as an international organization of lawyers, think these things are okay. So if you A, need to know that the other side may be doing this, and B, you may need to talk about it if you don't think this is proper. So I think that really, in the end, is the ultimate benefit of the IBA rules, is to say out loud to the world, these are the way some people are doing these things, and these are things that we as a group think are okay. So that's I think, the general background. So what did the rules do in particular? The first set of rules deals with an issue that was hot at the time, which is the possibility that a party could bring a representative in who would conflict out an arbitrator. And so that's what the first set of rules deal with. So that if a representative comes into a case and that they may have a conflict of interest because of a relationship with an arbitrator, the idea was that was potentially improper, and that would give, and the reason for saying that out loud was it would give the tribunal in the case the opportunity to keep the lawyer out of the case, to keep the integrity of the proceedings. And there were some instances at the time, particularly one particularly well-known one in a treaty case in which that had happened, and so this was trying to pick up on that. The second thing the rules address are ex-parte communications between representatives and arbitrators, and it didn't say anything particularly interesting or out of common practice, other than to say you can't do it, except in certain limited circumstances around the discussion of appointing a presiding arbitrator. And so it really did just capture something at the time, which I think is common practice, and there are other guidelines out there that deal with the same thing. Then it got into the really sexy stuff, like saying, in dealing with submissions to the tribunal, that lawyers or representatives should not make any knowingly false submission of fact to the tribunal. And a lawyer should not put in witness evidence or expert evidence that they know to be false. What, again, should not be hugely controversial. What it did do is set out some rules saying, if you know this, you should fix it or tell your client to fix it. And if you can't fix it, you should withdraw. Now, again, I think that's probably common practice globally, but if it isn't, there it is. The IBA has told you that you shouldn't sponsor false evidence. Then I think this is where it got more interesting. In dealing with the issues of document disclosure, and some of the things that were being discussed yesterday were interesting on this. First, and this is where I think we start getting into some normative judgments, and I haven't said this before, but a fairly Anglo-American approach to some of this, which I think the IBA is often guilty of. In the guise of harmonization, we tilt towards common law and Anglo-American approaches sometime. But the first principle in Article 12 of the rules is that where an arbitral proceeding does or is likely to involve document production, the party representative should inform their client of the need to preserve documents. And then that's an issue that is addressed very differently across different jurisdictions. I'm an American lawyer. We have a duty to do that. But in lots of jurisdictions, there's no duty to tell clients. So here we're making a normative judgment on how we should approach things. And then it goes on to have various other ways to regulate the document production process in terms of the lawyer's role, which includes not to use document productions for an improper purpose, to harass or cause unnecessary delay, and this starts to walk a fine line, explain to the party the necessity of producing documents that have been ordered to be produced or are required to be produced, including if those documents are discovered later. Again, advising the party that they should take reasonable steps to ensure they've done reasonable searches when required to produce documents, not suppressing or concealing or advising a party to suppress or conceal relevant documents that should be produced. And this is, again, I think where we had a cultural clash. And I think we still have a cultural clash, and we heard it again yesterday, because there are lawyers from jurisdictions who would tell you that their obligation, if they find negative evidence, to preserve their client's benefit, might be not to produce that. And this is saying that the international norm is that you have to produce that. But it's starting to make normative judgments about what we should do in those sort of potentially conflicting situations. And if we get to guerrilla tactics now rather than in questions, one of the things I would say is your guerrilla tactic is my ethical obligation, right? So I always find that an interesting area, because lots of lawyers from certain jurisdictions will say, yes, we get that we should produce documents, but if it's going to hurt my client, I have an overriding ethical obligation not to do that. And the IBA rules are trying to get at that. And let me quickly hit a couple of the other highlights, because I think probably the most interesting one was to say, A, if you're going to meet with witnesses or potential witnesses, you have to tell them you're a lawyer for a party and tell them that you're not their lawyer. Again, this is a very American rule. And that they're entitled to and may want to get their own lawyer, right? So give them a warning ahead of time of what your role is. And then, and in Articles 19, 20, 21, 23, they're dealing with expert witnesses and fact witnesses. And it says, again, dealing with this level playing field, it's a lawyer may assist a party in preparing their evidence. So a lawyer may assist a party in drafting their witness statements, and a lawyer may meet with and discuss with witnesses and experts preparation for their prospective testimony. So this is an area where the rules and practice, I do think, are pretty wide, and at least on paper. Let me say this differently. The rules are different on paper. In practice, I'm not sure they're so different in terms of preparing witnesses to testify and the role lawyers play in drafting witness statements. But here was the IBA saying to the world, it's okay for the lawyers effectively to write the witness statements, and it's okay for the lawyers to talk to witnesses before they testify about their testimony, about the substance of their testimony, and with an overarching principle that you shouldn't sponsor false evidence, that the evidence has to be, and the phrase they use is genuine. So the idea is that you can talk to them, but it has to be in the end the witness's or the expert's own account. So I think this is sort of fundamentally where the IBA guidelines were interesting in waving this flag to say, people do this differently. Here's what we think is okay. And then there's this note saying, if that's not the way it works in your home jurisdiction, if you think you have a problem with talking to witnesses, with preparing witness evidence, you should raise that in the arbitration. Has anyone ever raised that in arbitration? But this is the solution. It's identifying a problem and saying, talk about it, which I think is probably as far as the IBA could go. And then the last point, and then I'll quickly wrap up, is there were then what happens if there's a suspicion of misconduct, and the rules said a tribunal has certain authority to remedy misconduct. But let me tell you what the rules say. You can admonish the party representative. Don't commit misconduct. You can draw appropriate inferences. You can consider the conduct in apportioning costs. So all those things are things that tribunals always could do in any event. But it was saying on paper, we're going to make sure, we're going to try to give a little bit more oomph and a little more of a push to arbitrators to think you actually can do things if you see guerrilla tactics, if you see misconduct. And then last is, and the most important one, and the least used one, is take any other appropriate measures in order to preserve the fairness, integrity of the proceedings. So saying you can do much more. And maybe you can strike things, maybe you can disqualify lawyers, but we're not going to go that far to put any content in that, but we're going to give you this broad, vague statement. So that's what the rules did. And then there was also a whole cautionary list of be careful when you do these things. Consider whether it was done in good faith or bad faith. Consider differences between the party itself and the party representative. So we're going to give you some powers vaguely, and then we're going to tell you to be very careful about using them. And that's where we left it. So we have the soft law that 2 people in the room have used once. But I do think with a really powerful message in terms of identifying to everyone, here at least is what is happening, and start from the presumption that the other side is working with their witnesses to prepare their witness statements. Start with the assumption that the other side is talking to their witnesses about their testimony in a full way before they testify. And if that worries you, do something about it. Don't just do it differently. And let's level the playing field. I'm not going to spend a lot of time on soft law generally, but let me observe at the time 2 other things happened. Because this is soft law, there was discussions, well, do we make this harder? And how do we make this harder? And how would you ever regulate this? Almost immediately afterwards, the LCIA included in the LCIA rules its conduct rules that are very similar in a way with similar remedies. And that's not soft law, right? That's a mandatory, those are mandatory provisions if you choose the LCIA rules. So there is an effort to actually put a little bit more force in the idea of regulating the conduct of lawyers. And what happened immediately after the LCIA did this is that ASA, the Swiss Arbitration Association, said, no, that's horrible. We don't want arbitration institutions regulating conduct. What we want to do is we want to have, we should do it differently because there's a legitimacy question if you have institutions doing that. And so we should really figure out a way to do this in an international way. And come up with a truly transnational body to apply and enforce ethical principles, a truly transnational body. So the idea is we were going to create a new institution that was going to regulate all of you across all of your different jurisdictions, and it was going to be made up of the great and the good, the major associations of arbitration professionals in collaboration with major institutional arbitral bodies, together with a committee created of people who were, fantastic people who were going to decide transnationally what we all can and can't do. So 10 years on, we have the IBA guidelines, used twice by people in the room. We have the LCIA rules. We have no transnational body, happily, that's going to regulate all of us. And I'm happy to talk about guerrilla tactics and what we see, but I think we'll stop there and talk more generally about whether soft law is good or bad. But I do think soft law here has had a real impact, despite the fact that only 2 people have ever used them, because of the background norms and that identification of common practices that are, I think, embodied in the rules.
Thank you, Stephen. That's really thoughtful, and of course, by the use, they are apparently in decay, but their mere existence, I would say, would still have an influence and an effect. But we'll get to that in the question part. Thank you once again. We'll move into Philip Caballeros. Thank you.
Thank you very much, Florian, and good morning, everyone. I've been asked to discuss more specifically the role of external counsel in international arbitration settings, and particularly from the appointment of the tribunal and the selection of arbitrators onwards. Now, the difficulty here is perhaps to resist the temptation of telling you how important it is to have an external counsel, but all things equal, a bit like Oscar Wilde, I can resist anything except temptation, so forgive me in advance. This said, and I think it fits perfectly with the title of this conference, which is the stakeholders' role in international arbitration. I'm a firm believer, and perhaps because as some of you may know, I've started my career at the ICC, then moved to a general counsel position, and then to private practice and as an arbitrator. So I'm a firm believer in safeguarding the legitimacy of arbitration through cooperation by all stakeholders in one particular arbitration, and more largely as an institution as a whole. Now, this does not mean that there are no conflicting interests between the stakeholders, including in one particular arbitration. Obviously, as counsel, you want to win the case, and the other side also wants to win its case. As arbitrator, you are trying to do the best job possible. You market yourself. Similarly for institutions and so on and so forth. But I think if we want to make it work, there has to be some degree of cooperation and trust in the process. And that starts with, I think, a dialogue with the external counsel, with the in-house counsel that appointed you as an arbitrator, as a counsel or as an arbitrator. You want to set a dialogue of trust in selecting the right arbitrator. You may have, as counsel, a particular agenda in this respect, but you need to offer your client various possibilities. And I'd like to recall a speech by Emmanuel Gaillard some time ago, who said that invariably, if you want to reduce time and cost, you're better off appointing a sole arbitrator. But when you ask your client whether you want a sole arbitrator or 3 arbitrators, invariably your client would say, well, I want a 3-member arbitral tribunal, and I want the strongest, best, perhaps oldest arbitrator at my end. So there starts the dialogue. Perhaps you are well advised as counsel to say, well, for this particular case, or as an institution, for this particular case, a sole arbitrator would be more efficient. Then in selecting the right person, obviously, I think external counsel has a breadth of experience, of trust, of knowledge of certain people, perhaps more than in-house counsel, but you need to explain that, and you need to explain why such and such person is probably more suited than another. And if you can't agree, then you also may very well trust the institution to appoint the right candidate, including as president of the tribunal, if for some reason, although it's probably not the best solution, but if for some reason the co-arbitrators are unable to select a chair. Now, I've been asked also to say a few words on procedural order number 1 from an external counsel perspective. I think then there again, the role of external counsel is important. You probably know your case, or you should hopefully know your case better than the arbitral tribunal that has just been appointed, and the arbitral tribunals, arbitrators have a tendency to send you the POA they've been using for the last 15 years in every single case. You may wish to, with due respect, of course, but you may wish to influence the drafting of the POA in this respect to tailor the need of a particular case. And if you agree with counsel to the other side, I think that's an ideal world. But if you don't, you need not be shy to tell arbitrators that you wish to tailor the proceedings slightly differently to the very commonly used POA. Now, I'm not going to delve into how to file submissions or the role of external counsel during hearing. I think this is quite obvious, but there was one aspect that I was asked to consider is conflict of interest from the external counsel perspective, and we've heard Stephen on the IBA guidelines on party representations, but there is also the IBA guidelines, which he mentioned, on conflicts of interest in international arbitration. And allow me to give you, and forgive me for that, but allow me to give you a French perspective on a relatively controversial case law, whereby in France, the Civil Code of Procedure obliges arbitrators, but I think this is very common in other jurisdictions, to disclose, obviously, at the outset and also during the entirety of the proceedings, any facts or circumstances which would create a conflict of interest or need to be explained and told to parties. There is one sort of, not exception, but excuse of non-disclosure of what are called notorious facts. So if you appoint an arbitrator and everybody knows that that arbitrator has done this and that with such and such person, and this is a notorious fact, then the arbitrator can be excused for not disclosing this. So the flip side of this is, and this is where I'm answering your question, the flip side of this is there is a duty on counsel at the outset when appointing an arbitral tribunal at the beginning of a case to run a bit of an investigation. And this is called in French the duty of being curious. You have to be slightly curious. You have to investigate notorious facts. Now, the difficulty is what is notorious and what is not notorious. It has been ruled, for instance, in France, and some people may find this shocking, but that an article or an information in Global Arbitration Review, for instance, is a notorious fact. Now, not everyone has access to Global Arbitration Review, so this may create an imbalance between counsel. But once an arbitral tribunal is in place and the proceedings are running, the counsel do no longer have, at least theoretically, an obligation of curiosity, and the duty to disclose is entirely shifted on the arbitrators, whom at every point in time should disclose any relevant facts or circumstances. And the idea behind this is precisely what I was trying to explain at the outset, is that there is a duty, at least from the French perspective, of cooperation between all stakeholders in an arbitration. I mean, after all, is it really unfair, although it has its limits, but is it really unfair for counsel to run a bit of investigation and figure out whether there may be conflicts? Is it really unfair for an arbitrator to monitor at all times its duty to disclose? Is it really unfair for institutions to be made aware of difficulties in this regard? I don't think so. I think, again, this is part of the cooperation between all stakeholders. And with that, done. Thank you very much.
Thank you, Philippa. Thank you very much. Move on to Peter.
Well, thank you. First of all, thank you to the organizers for having me here. It's been a pleasure preparing. It's been a pleasure participating in the social events and the conference. And I hope to give back a little with that now. What I'll be talking about is the management of costs and expenses in international arbitration proceedings from an external counsel perspective. We have already heard quite a bit about how outside counsel should behave or should not behave, what its role can be. And of course, a lot of the things we heard also have implications on the cost of the proceedings. So forgive me if some of the things that I'll be covering will be follow-ups on things that have already been said. Now, that said, there's a brief overview of what I want to talk about. The first one, let me start by saying what I'm not going to talk about. I'm not going to tell you what it means to be a good boy or a bad boy in being an external counsel, that you should follow procedural deadlines, that you should follow what the arbitral tribunal tells you to do, that you should act in integrity, etc., etc. I think that has been covered, and I think a lot of these things are matters of course. I would like to focus on a few particular points where I think there is quite a potential of turning an arbitration into a cost-efficient one, or in the other direction, turning it into a financial catastrophe for the parties. The first topic there would be the opportunity of entering into ad hoc procedural agreements. That is something that, of course, requires the parties' consent, but most importantly, it requires reasonable counsel on both sides that assess the situation and determine whether it might make sense to, in deviation from the original arbitration clause, say, let's do something differently, let's try something else, and let's try saving costs in the process. Now, very briefly on a few, and this is really just a selection, I'm pretty certain there's a lot of other cases of application where this could come in handy and actually save some costs. But the one thing is, or the one agreement is, when at the outset of the arbitration, agreeing on the application of expedited rules or of an expedited procedure. I've tried this in the past. I've tried to agree with opposing counsel on this, and I managed to do it in two rather small disputes, and it turned out fine. But there were many more disputes where I tried to do it, where I proposed it, and where there was immediate opposition by opposing counsel, which was very hard to understand. Of course, expedited proceedings are not suitable for every case. Yeah? That is clear, and it's not sufficient to just focus on the amount in dispute. We all know that there are particular disputes which can be very complicated, irrespective of the amount in dispute. So naturally, that needs to be given thought to. And sometimes the standard rules or the standard time limits that are foreseen in expedited rules might also not be suitable to the particular dispute. But that is why we can enter into procedural agreements. That is why we can tune these rules a little bit within the confines permitted by these rules. But we should make use of that, and I'm pretty sure that there's a lot of cases where if both sides' counsel manage to talk about this, manage to identify the crucial issues, identify the particularities of the case, an agreement on expedited proceedings would make sense for both parties involved. What also should be considered there is that, of course, when you agree on expedited proceedings, on expedited rules, not every arbitrator will be a suitable arbitrator for the case. The second thing, and that's also been briefly covered here, is the composition of the arbitral tribunal, which is something that again needs to be agreed at the outset of the arbitration. And again, I have to say, I have been surprised repeatedly by how insistent some opposing counsel can be on a 3-member tribunal in a dispute that's for 280,000 euros. It borders on the absurd sometimes, the discussions that you have to have in that regard, and ultimately the result being that indeed a 3-member tribunal will decide this. But that's the way it is, obviously. Doesn't mean that we as counsel cannot try to change that. It's certainly for us to do it, and of course sometimes the client might have a few things to say on that, but managing the client will also be a topic that I'll be covering in a few minutes. Now, in general, I think what is quite clear here is that, of course, a sole arbitrator will come in cheaper than a 3-member tribunal. That's the one thing. The other thing that should be taken into account is whether it might make sense to actually agree on an arbitrator with a special qualification or special experience. That might really help along the case, and it might really help along the efficiency of the arbitration. And what should be considered in a dispute with, in particular in disputes with low amounts in dispute, is to maybe be a bit selective about the arbitrator's space of operation. I was involved in a rather small arbitration for a little more than 400,000 euros, sadly with a 3-member tribunal, and the opposing party appointed an arbitrator from Japan to the panel, which, as you can imagine, makes no sense at all with that amount in dispute, and with a hearing being held in person. Yeah, that's something to consider. And here again, I think it's mostly for external counsel to manage the process here. A third case that I've come up with is something that has also been covered, so I'll be breezing through this only, and that is the issue of negotiations and mediation, which is something that you can really do at any time and that you should steer towards at any time. And it should not just be something that you consider for the entirety of the case, because quite often that's just not possible. But even if you manage to just take out a part of the case, take out a few of the claims which are actually undisputed, and if the parties can find some common ground on that, that can help reduce the scope of the arbitration and thereby the effort and the cost required for handling it. And the fourth one is something that's become quite on vogue in recent times, and that's the early determination. That is also something that has been covered, or that was covered yesterday, to a certain degree in a slightly different manner with regard to the SEC express case assessment. I personally think that early determination, express case assessment, or any form of early objective assessment that gives the party an idea as to whether their positions are actually viable or tenable, can only contribute to, first of all, a more efficient conduct of the proceedings at a later stage, but most importantly, to the opportunity of the parties actually settling the case. Now, one thing that's very close to my heart is the question of whether or not it makes sense to bifurcate proceedings. Again, there's no answer that can always be yes or no, obviously. But quite honestly, I think there are cases where it would make a lot of sense and where it's not being done. And then on the other hand, there are cases where it makes no sense at all, and it is being done just because the arbitrators have not yet familiarized themselves sufficiently with the case. At least that's the case that I stumble across the most. In general, I think the issue of jurisdiction and questions of admissibility is an obvious choice for bifurcation. However, and that is where my criticism starts in overusing it, this makes sense, and by that I mean not just from the arbitrator's perspective, but also from the counsel's perspective, before agreeing or requesting any form of bifurcation regarding jurisdiction admissibility, you should take a very close look at how the chances are of the objections that are being raised. A bifurcation for rather spurious procedural objections does not make much sense at all. And also, you should consider the significance of the objections in the overall context of the dispute. So for example, if there are objections on admissibility or jurisdiction on a minor part of the claim, while the rest of the claim will certainly have to continue, it might not make much sense to actually have a bifurcation there, and it would be better to cover it in total. Now, something else that does make a lot of sense, in particular when it covers the entirety of the claims, is a bifurcation on the issues of the statute of limitations and issues of preclusion. Again, however, the measure here should be whether there is a certain chance of success of these objections actually being successful, because otherwise you're just going to waste time. Again, I have to say, it might make sense to go for this if it relates only to a part of the claim even, because it can certainly help to condensate the arbitration and boil the outstanding issues down to a few. Now comes the one where I see the most potential for cost savings, and that's the issue of bifurcation into a liability and a quantum phase. Just to tell you an example from my practice where it would probably have saved millions if a bifurcation had actually had taken place. It was a post-M&A dispute for a little more than $500 million, and it was for 5 distinct claims on account of a violation of representations and warranties. And we, on our side, as the respondent, requested a bifurcation into liability and quantum phases, and opposing counsel fought that request with everything they had. They just didn't want this to be bifurcated. And ultimately, the arbitral tribunal said, well, then we're not bifurcating, we're hearing everything at once. And the case turned out to be indeed an issue that ultimately led to the award of just one of these 5 distinct claims. And the other side was awarded some $40 million, so less than 10% of the amount in dispute. And the costs of both sides amounted to $15 million on the other side and $12 million on our side. And I'm pretty sure that on our side, at least, some $3 million could have been saved if we had actually bifurcated. And funny enough, the other side was awarded $40 million, but ultimately had to shoulder some $25 million in terms of costs, so that was quite a boomerang. Honestly, however, even if you're not on the receiving end on this and on the losing end of this, this does not make sense for anybody involved. And then another case with rather great potential for cost savings is a bifurcation or trifurcation or whatever it might be regarding certain preliminary factual or legal issues. In particular, if the case is dependent or could be an entirely different case if you go into the one direction than if you go into the other direction, it does make sense to clarify certain preliminary questions first, whether that is in an arbitral award, in a procedural order, or just as some form of early assessment. Bifurcating makes sense here in a lot of cases, or would make sense here in a lot of cases. Now that brings me to an issue that I will just breeze through very briefly because Friederike has already covered it mostly, and that's the issue of front-loading and whether it makes sense to hold back arguments, to hold back evidence, or to put everything on the table. Of course, I'm not saying that there might not be strategic considerations which in one case or the other might give you pause. But in general, I think front-loading the proceedings, putting all the relevant facts and arguments on the table, putting all the evidence on the table makes a lot of sense for everybody involved. It also makes a sense for you and your own party, because ultimately, if you come up with something very late in the proceedings, I don't think that any tribunal that's properly prepared and in their right mind are actually going to let you get too much of an advantage out of having submitted something late or having held something back. It will be very hard to actually surprise a counterparty or to steer them into a situation where they cannot say anything about a topic, where they cannot comment. So ultimately, I think the games of holding back information, of holding back evidence, or holding back arguments, it really does not make much sense for everybody, for anybody involved. What's most important and most close to my heart here is also something that Federica has raised, and that is identify relevant expert topics as soon as possible. That really can make a case go completely different if it's from the outset clear where you will need an expert, whether a technical one or a legal one or a financial one, and where you don't. Because if you start looking at the case immediately with an expert, you might make a different case, but the other side's reaction to what you are saying might also be a different one. A well-prepared expert report right at the outset, maybe even before the initiation of the dispute, might actually lead to the parties getting closer together and finding an amicable solution. Now, another topic that can save costs, logistics costs mostly, are remote hearings. We've come to love or hate them in the past 2 or 3 years, mostly. There are, of course, benefits, as I said, saving on logistics costs like travel expenses, facility expenses, and it can also help in terms of presentation of your case, because the tools available in online hearings are much more easily and much more readily available and usable than they might be in a personal hearing situation. So if you are working a lot with electronic presentations, if there is a lot of information that you need to convey by means of electronic presentations, an online hearing might actually help you. And in my experience, remote hearings are particularly effective in covering organizational matters where it's not about actually making arguments, assessing evidence, hearing witnesses, but about managing the proceedings. So I'm all in favor of them in the case of case management conferences. I see, however, quite a few drawbacks, and I think I'm not alone there. The one being something that's mentioned again and again, in particular, I have to say, by in-house counsel, and that is that if you have remote hearings exclusively, you might actually miss out on quite a few settlement opportunities. Getting the parties together, meeting in the hallway in front of the meeting room, meeting during lunch or whatever, can actually lead to a case being settled, to the parties getting closer together. That is something that you take away when having an exclusively remote hearing. Remote hearings can also decrease the overall time and cost efficiency. I think everybody, or I assume everybody, has experienced that the concentration span gets considerably shortened in an online hearing. It becomes more difficult to follow, and it becomes more easy not to follow. Yeah. And now my last point here, and I briefly announced it beforehand, is management of the client. And I think this is something that's very often not done correctly, or where we could all improve. Because, and maybe by show of hands here in the room, who has never heard the saying, the client is always right? So everybody's heard that. Who has never used the saying, the client is always right? Okay, so nobody, unless somebody's afraid to raise their hand. I have to say, I hear that again and again, and actually when I got into practicing law, I heard it quite a bit from the more senior lawyers, who ultimately said, well, it can't be helped, the client is always right. I don't think that's the case. I think we as counsel in an international arbitration are under the obligation to manage our client in several regards. And we owe it to our client to tell them the truth, to question their approach if we consider it hurtful to the process and hurtful to their own position, and to talk to them about the bigger picture. And there are 4 aspects which I think warrant increased management by external counsel of the client. The first one is fact-finding, which I think is the one that most external counsel are still rather familiar with. Here, however, again, I revert back to what I said earlier, that getting the client to give you all the information required as soon as possible will ultimately not just help the client's case, but it will help along the arbitration. I've seen it numerous times that clients say, oh, do we really have to do it now? This is so expensive. This takes such an amount of time. Let's just file the request for arbitration and then think about how we proceed. I personally have never seen that helping along the case. And I think doing a thorough fact and information gathering as soon as possible is certainly the way to go. That is something where you need to manage your client. The second is expectation management, and that means both with regard to what to expect from the procedure, but also what to expect in terms of outcome or potential outcome of the arbitration. I've had to plead cases where I thought it's absolutely unbelievable that the other side is making this case and that the other side is continuing to do this. Even having tried to approach them with settlement opportunities, and they just say, no, they're going through with it. And I had a rather small case. It was a distribution arbitration for barely above $1 million. And it was, when the client came to me, I said, okay, this is a rather clear-cut case. And we went for arbitration after having offered to the other side to settle, which they outright refused. And we had an arbitration that was rather complex, and we had arbitration costs of some 360,000 euros on our side. For 1 million in dispute, that's quite a bit, but that's what it was. And we won with 100%, and the other side had to pay a sizable amount of our costs as well. And then not opposing counsel, but opposing party contacted me and said they had fired their counsel because they had actually been told that this was a clear-cut case for them. Had they known that this is a potential outcome, they would have settled at the outset, and they now wanted to talk to us about how we could discuss leniency in enforcement. That's rather late, obviously, to come to the conclusion that a settlement would be good, but at least it's better than never. But ultimately, I think this is really where opposing counsel failed. If indeed the case assessment led to there being the opinion that this was a clear-cut case for them, something went definitely wrong. And the 2 other points that I have here are management of the client in terms of procedural behavior and the bigger picture. What I mean with procedural behavior is very often clients say, yes, we want an efficient, we want a cost-efficient arbitration, we want a cheap arbitration. But when it really comes down to disputed situations in an arbitration, very often the clients say, well, if they get that, I want that as well. Sometimes there's no reason for that, but still, the clients, first of all, want their day in court, and the client wants to be right. Not just right with regard to the case, but right with regard to every single step of the procedure. Of course, winning is nice, and winning smaller battles is nice as well, but it certainly does not help along the process if this is what you're insisting on. And that brings me to the very last point, which is seeing the bigger picture. It's not necessary to win every single battle, and I think it's important to impress this on the client as well. It's also very important to impress on the client that it does not make sense to do things just for the sake of making things difficult for the other side. So for example, even if you're in the right, I think the prime example here is if you have a dispute escalation mechanism like having obligatory negotiations or a mediation, and then having arbitration. I see a lot of jurisdictional objections in such cases. And I myself have had clients who said, of course we're going to raise this, but the question is who benefits from that? Who really benefits from there being a ruling that the arbitral tribunal does not have jurisdiction? I think it's also for us as counsel in such situations to tell the client, look, this might actually be a small victory now, but you will have to go through this arbitration again. So why not find another solution? And with that, I close, and I thank you for your attention.
Thank you, Philip. I see that we are already in delay, which means that I admit I failed to manage properly the time of this session. But it will be an even a bigger failure if I will cut the questions. So let us get some questions from the audience. Please, Ilana.
Hi, everyone. Thanks a lot for your speeches. It was extremely interesting to follow. And I have a question or a range of questions and observations. There's so many of them that I had to write them down. But the situation is concerns me and concerns other people. I practiced justice plea in Paris, so I'm in France. There are certain expectations of clients in that jurisdiction and certain deontological rules. I am a U.S. attorney in an American firm, and where the issues raised by Stephen and some by Philip are, for example, in the very famous document production phase. Whereas an American attorney, if I'm ordered by the tribunal, I need to produce all the documents responsive to the tribunal's order, whether they are favorable to my client's position or not. This is very difficult to explain to a French or a civil law, let's say, client. I'm coming from a civil law jurisdiction, but I do it. When I do it, obviously I have to manage my client and explain that we will fix it later, but we have to. That's one thing. However, while doing this, in large cases, we have to do the doc research, and you have like thousands of documents, thousands of hours, and fees. And here's where, like, I come, if I'm on the opposite side, if I have a smaller firm that doesn't necessarily see things as I do, and does not engage through this very voluminous process, I have a firm that comes with their legal costs of like X, and I come with triple X because of my me fulfilling the deontological duty, and by the way I read the IBA rules or the directions of the tribunal. And so what to do in this kind of situation? How do you explain it to the tribunal? Obviously, if the tribunal sees like 2 million in legal fees and 32 on the other side, my side, they're like, oh, that's completely disproportionate. So that is something that I personally deal with, and I'm turning to your wisdom to see how to solve this and whether there's a way to solve it or we just continue like this.
Thank you, Ilana. I think, Stephen, this goes to you first.
Well, I was thinking this is a place where you should be talking about the IBA guidelines on party representation in your case to remind the tribunal of the understanding of a lawyer's role in document production. The question of cost allocation around these issues is a whole different and long topic. I do regret to see an increasing approach by many lawyers in arguing about costs and tribunals in trying to not want to pay attention too much but make a cost decision to this idea that the lower fees on one side should somehow set the ceiling, which makes no sense and does a real disservice because parties are entitled to approach cases differently and parties are often obligated to approach cases differently. So I do think being more open about the fact that the choices you made were not just reasonable, but required, should be part of the discussion. Because otherwise you end up with an unfair outcome, which is putting aside the ethical issues around production that you raised at the beginning. On the cost side, you end up with an unfair outcome where a party that's done what it should have done doesn't get that recognized in the cost process. And I do think the whole issue of how we allocate costs, what standards are being applied, how much we talk about it is one of the issues we should be paying more attention to at these sorts of events, because that's something that people don't delve into enough. It's not sexy like AI or ethics, but it's actually a really important part, more important as all the conversations today and yesterday indicate. That's more important in a lot of ways to the way we do things. How much do things cost, and who bears the cost? So I don't have a great answer other than it is wrong to set the bar on the lower side, and it's particularly wrong when the lower side might be having set that bar because they're not behaving ethically or in a way that is reasonable.
Thank you, Stephen. Someone else? Different question, please.
Yes, I have a question. Thank you. Thank you. I have a question to Philip regarding, the early determination and, the express tool that was introduced by the SEC. I have a lot of sympathy for that. And in fact, VIAG was thinking of even implementing an early determination rule or sort of guidelines, but then eventually we shied away because there was concern from practitioners and clients and counsel that could create an avenue for biases or impartiality and independence issues for later proceedings. I just wanted to hear your view on that. Thank you.
Thank you, Elise. Well, I think the SEC express rules, the SEC express case determination is something that happens only if both parties agree, right? So I think that's something that must be considered here. And I think that in general, I do get what you're saying, and I agree there is a distinct danger, obviously, that doing this the tribunal doing this of its own volition without involving both parties might actually lead to more damage than this could actually save in terms of costs. So my approach, at present at least, with the general mindset that I experience in proceedings, is that it is for the arbitral tribunal to propose this to the parties if it's not being raised by the parties. And to make the parties see the reason behind it, see the potential benefits, and to then see whether the parties agree. And if there is really one party that absolutely objects to it, I would very much vote against going for an early determination. Absolutely, yes.
Thank you. So I think we'll have to stop here. I would dare to advance a conclusion. Definitely in terms of external counsel conduct, there are things that cannot be improved by the counsel themselves, or issues that can't be fixed. But there are also, like for example, if soft law does get effective and then by use it gets harder, so you get the benefit of it, in fact. Or if the arbitration agreement is properly negotiated by the transaction lawyers. So we keep complaining about that, but there is no effective change, and it's a matter that is not in the hands and in the powers of a dispute resolution external counsel. But there are things which can be fixed and which external counsel can get better of effectively. And I think that is in relation to the procedural order number 1, for example, which in my experience, and I'm happy that the idea was already expressed here and is shared, is in most of the cases not taken advantage of by the external counsel. So that would be the conclusion I suggest, and we thank you for being with us today. Bye.
Gentlemen, good morning again. The title of our section is Responding to the Challenges of the Future, the Modern Arbitration Practitioner. The underlying rationale for the selection of this topic has been the need to actually reflect the ever-changing world in which we are all practicing law nowadays, a world where there is undoubtedly substantial general progress, a new approach on environmental protection, new social values. Therefore, in this context, technology, green arbitration, diversity, smart contracts are all aspects that will have a substantial influence on the general process of arbitration and specifically on the profile of the arbitration practitioner. We will explore together all these issues with my fellow panelists here. I will start introducing them, obviously starting with the ladies. Catherine Dixon joined CIR as Director General in May 2020, and she spent time in Chief Executive Officer roles at the Law Society of England and Wales, a higher and further education college, and the NSH resolution. Catherine has also held Senior Executive Director and General Counsel roles at the NSPCC and BUPA, and in Canada and Vancouver Coastal Health Authority. Catherine is a solicitor and accredited mediator and holds an MBA. Catherine started her professional career in private practice as a solicitor at Evershed, Sutherland. The other lady that we have here is Helene Laufer. She is an associate in international arbitration and public international law at Van Bael and Bellis, and a PhD in law candidate at the University of Cambridge. In 2022, Helene was admitted as a solicitor advocate with higher rights of audience, civil advocacy in England and Wales. Helene specializes in international commercial and investment arbitration and public international law. She has represented clients in disputes in a range of jurisdictions and sectors, with a focus on the energy and natural resources sector in international arbitration proceedings under the LCIA, ICC, SIAC, UNCITRAL, and ICSID rules. Then we can move on to Carlos Carvalho. Carlos is a senior business development consultant and Opus 2 and a qualified lawyer in 3 jurisdictions, including England and Wales, where he has practiced in the international arbitration field since 2015. He is the lead teaching fellow at the School of International Arbitration at Queen Mary University of London and has extensive experience in dispute resolution. He also leads the Queen Mary Financial Inclusion Project, working with the banking and finance departments. Besides managing various businesses and complex projects, he worked in law firms, companies, and the public sector. More recently, Carlos set up and coordinated the International Advisory and Dispute Resolution Unit at the leading barristers' chambers, 3 Verlem buildings. Last but not least, we have Rupert Choate. Rupert has specialized since 1997 in construction engineering, PFI, PPP, energy, and similar dispute. He has considerable experience in related claims involving professional negligence, as well as bonds and guarantees. He has worked on disputes concerning projects in over 50 jurisdictions, with most of them governed by local law. He is an experienced advocate from the English Court of Appeal to arbitration venues around the world. He is a practicing arbitrator and has sat in ICC, LCIA, SCC, DIAC, and ad hoc arbitrations. Rupert teaches on the MSc in Construction Law and Dispute Resolution at King's College, London. Dalibor Valincic is a partner. I have to say that he used to be my partner for over 15 years. But currently, he is a partner in Croatia's, a successful law firm in Croatia. Dalibor heads the dispute resolution in his new firm. He focuses on investment and commercial arbitration and also has extensive experience in energy law. Dalibor combines an international perspective that comes from advising clients from several different countries with a very good local rapport. He has successfully represented investors in multi-million-dollar arbitrations under both ICSID and UNCITRAL rules. His commercial arbitration experience includes representing and advising clients in arbitrations under the VIAC rules, ICC rules, and local Zagreb rules. Dalibor is a visiting lecturer at the University of Osijek Law School and a regular speaker and panelist at conferences and seminars. And with that, I will invite Carlos to take the floor and start elaborating on the new challenges brought by new technologies in arbitrations.
Thank you, Ligia, and thank you for having me here. It's a pleasure to be in Bucharest for the first time. Really interesting city. And we have great arbitration lawyers from Bucharest in London, so I'm very pleased to finally see around. Although I have some experience in international arbitration, my day-to-day work for the last 2 years has been with legal technology. And of course, when we bring technology to a panel like this, you can imagine what I'm going to say, that we have to know how to deal with technology. That's the modern practitioner. But it's not so simple, because every time we mention technology, different people will think about different things. What is this technology that we're talking about? Because depending on your background, your age, the size of your law firm, you might be using different types of technology. So the way I try to distinguish this, well, there is first the more futuristic approach. Some people might think about holograms, very sophisticated artificial intelligence, virtual reality in the context of international arbitration, which is not quite there yet. Some people might think about legacy technology that we've been using for many, many years now, like email, Word, PDFs. Word has been around since the 80s. PDFs and digital documents have been around since the beginning of the 90s. So these are actually legacy technology that we've been trying to either improve or replace as we go with what I want to talk to you about, which is the current technology that has been used or gradually deployed in law firms, at least from what I see from my clients. And technology has been used in 3 main ways, and maybe someone will disagree with me here in the room. There is room for disagreement on this. I think the first way that technology has been used in disputes is to reduce the size of the data that you have to deal with to create a case, to find the relevant part of the case. You are given a big amount of information, a big amount of data, evidence, emails, documents, and you need to reduce that to the relevant part. And that exercise sometimes in civil law jurisdictions happens at the client environment. In common law jurisdictions, this will happen sometimes at the e-discovery phase, sometimes even at the document production phase. And we have a lot of very interesting tools being used by law firms with some rudimental forms of AI already, trying to identify the relevant documents and find what is relevant for a case, as well to comply sometimes with orders by arbitrators on what types of documents that they want to see in that case. So that's the first thing that we've been seeing technology being used in disputes now. It's to reduce the size of things. And then once you find the relevant part of the case, you start using technology to refine that relevant part of the case and to make it presentable to the decision makers, to make it, well, you want to highlight, of course, the part of the case that are more favorable to your side. You want to make it presentable, and you want to make a good case. So then you have a lot of tools being used in case preparation, in case management, and also in hearings. And we have a lot of technologies being deployed in hearings. Electronic presentation of evidence, e-bundles, and we should not mistake e-bundles with a digital bundle. They're two different things. They have different capacities, like different features. And in the context of the use of on this refinement of the evidence to be presented in a case, we haven't seen yet a lot of generative AI, at least, being used. So I think this is something that we are yet to see. And one third aspect of legal technology being used in law firms is not actually new. It's kind of on the legacy technology, but also in the current one, which is the part that concerns the legal research and knowledge databases. This is legacy technology because we've had those platforms to do legal research for a long time. We have in different ones in different jurisdictions. In England, we have the two main players are LexisNexis and Thomson Reuters, but at least from the time I arrived in London till now, I haven't seen any development on that. But we've seen already in the international arbitration field, where we lack a little bit of data, we've seen some new players trying to disrupt this market, trying to create a new form of conducting legal research, trying to bring closer the legal research with the drafting and auto-linkings and a lot of different new abilities that can be done thanks to new technology that we have nowadays. So those are the three main aspects in which I see legal technology being used at this point. Is that enough, Ligia, or do you want me to?
It's up to you. Up to you if you want to share more.
Yeah, well, I can share a little bit about, for example, one thing that we always mention also when we talk about technology in disputes is the cybersecurity threat that comes with it. I don't see this as a discussion anymore about using or not using technology for the sake of security. The fact that is that we already use a lot of legacy technology, emails, local services, local servers, and actually they are not as safe as the current technologies that we have. They are protected by cloud-based solutions. So I think the ship has sailed. If we wanted to stick to physical documents for the sake of security, we should have done many years ago. Now everything is already digital. The only problem is that we're creating copies of this everywhere by exchanging emails, and that is the least safe way of conducting a dispute that I know. And cloud-based solutions are proven now to be way more secure. I remember 10 years ago, there was a discussion, we had new companies providing software as a service, and discussion was that they were not as safe as having everything deployed on-premise in your local server, but we have seen that most hacks happening in law firms and barristers' chambers happened in the context of local servers. So cloud-based solutions are definitely the way to go, and becoming technology literate on those aspects it's very important for the modern practitioner to create a safe environment for their client's case. And also, I think one first point for this panel, I know we will talk about this a little bit more, is that we need to understand what technology is being used in the market, even if you don't use it in your law firm, because maybe your law firm is not big enough, maybe your practice doesn't require you to have such forms of technology being deployed, but you need to know what's going on in the market, because eventually you're going to be in a dispute and the other party will be using some of those things, and you need to be able to identify if some of that technology is being used inappropriately to interfere with the outcome of the dispute, for example, and you have to be able and prepared to defend your client against those threats, which are the real threats in my experience.
Thank you very much, Carlos. Indeed, cybercrime is one of the big challenges of economy these days, and also for us lawyers in dealing with these cases. There is also a very strong technological aspect involved, but also very complex legal issues. I will hand over now to Rupert, because technology and all the progress and advanced things that are engendered by it go hand in hand with an enhanced necessity to draft smart contracts. So, Rupert, please guide us through the smart drafting of contracts in the context of modern arbitration. Thank you.
Very well. The topic for today's panel, of course, is challenges of the future. And it seems to me that when one is talking about the future in the technology space, it makes more sense to look at the short to medium term, given that we're told that in the long term, all of us arbitration practitioners are going to be replaced by technology. And so some might say there will be no challenges in the future. There certainly won't be modern arbitration practitioners. So with an eye on the short to medium term, I thought it would be worth giving some consideration to smart contracts. And I should perhaps begin by attempting to define what smart contracts are. There are a number of definitions. Perhaps a fair one, I think, is to define them as computer code that automatically executes all or part of an agreement. So to come back to your point, Lydia, it's less about the drafting in the sense that we lawyers think of it. It's more about computer code that automatically executes all or part of an agreement or contract. So the answer is in the drafting of the code. I think it's fair to say, whilst there are few of these around at the moment, there's clearly going to be an increase in the use of smart contracts, and certainly in my area of construction and engineering, there are already signs of this use of this type of contract. In terms of construction, perhaps I could give an example of how this might work, and apologies for those of you who aren't familiar with construction contracts, but one of the things that's quite important in construction is you have a completion date and you have a mechanism for extending the time to complete the works. And the way in which a smart contract can be involved in dealing with extension of times, for example, but also other aspects of construction contracts is as follows, and it comes with really three parts. Let's take an example where you want to claim more time because of excessive wind, high wind. The first part would be you would have a detector at an appropriate measuring place designed to detect the wind at certain contractual levels. The second is you would have, and the technology is already available for that, of course. Second, you would have detectors on various pieces of equipment, for example, the tower crane on the site, which would tell you when it's inactive and also inoperative for whatever reason. And then thirdly, and again, the technology is there for that. Thirdly, you will have a computerized schedule or program which identifies critical activities, and therefore when you have delays to those, how it is the completion of the works gets delayed, and therefore why you might get an extension of time. That is already well used. It's been used for as long as I've been practicing, which is now over 25 years. Computerized programs and schedules, they are already there. Put those three things together, and when you have, for example, let's take a 1 day of excessive wind being measured at the first point, then being logged also at the tower crane, and then also being put into the schedule or program, you can see that the smart contract, as I defined it, would automatically give you an answer. And that is an answer in which, in principle, no arbitration practitioners need to be involved. So whether the wind was excessive is decided by the technology on the first detector. Whether the wind caused the tower crane to be inactive and inoperative, again, will be decided by the technology. And whether that then, that 1 day of delay to the tower crane, whether it caused delay to the completion of the works, would also be answered by the technology, the computerized schedule. Now that all sounds well and good, and that all sounds like we can have a nice holiday and sit out in the sunshine in glorious Bucharest or wherever we might be. But of course, this all assumes that one has sufficient confidence in each of those three stages of the technology. We're all familiar with garbage in, garbage out. Let's take the wind detector. You're assuming it was measuring the wind correctly against the correct criteria. With the tower crane, you're assuming it wasn't already inactive for some other reason. And with the schedules, well, those of you who have the fun and games of looking at delay analysis in computerized schedules already know what a dark art computerized schedules are. Now, obviously, this is not to say one should second guess and can second guess what all the technology tells us, because obviously that would defeat the purpose of having the technology. But clearly, anyone who is involved in this very high-powered dispute that I've just been describing to you about 1 day of delay owing to excessive wind would have to consider these factors. For example, was the crane already broken? Now, in current old tech world, which most of us are still familiar with, the answer would be quite readily found, and it's just the sort of thing you would look for. But I think the risk with the new world technology, particularly with smart contracts, is it's perceived that you have the answer already given to you and there's no need to look at, for example, was the tower crane already inactive for some other reason. We're repeatedly being told by the tech giants and their leaders and their founders that the whole purpose of technology is so you don't have to worry about these things. Bill Gates, for example, is on record as saying the advance of technology is based on making it fit in so that you don't really even notice it, so that it's part of everyday life. Now, I don't think that applies to arbitration practitioners. I think it'll be a sad day if and when it does. For me, it's actually the reverse. It's about noticing the technology and seeing where it is when you might not otherwise see it. For example, in my rather simple example I've given you. And then moreover, as an arbitration practitioner, it's understanding how that technology works. One salutary example of this can be seen recently in the English criminal and civil courts. And this is a potted history of a very long-standing saga that goes back 20 years. I will try to summarize it for you in about 1 minute, or maybe 2 minutes, if you'll permit. In about 1999-2000, our post office, with the help of Fujitsu, rolled out to about 17,000 of its post office branches an IT system called Horizon. At that time, Horizon was the largest networked non-military IT system in Europe. Fast forward 20 years, and the High Court decided that there was a significant and material risk that branch accounts that had to be produced by each manager of each of these 17,000 branches, there was a significant and material risk that those accounts were affected by bugs, errors, and other defects. Now, this was only decided by the High Court in group litigation, which had the help of third-party funding, incidentally, referring back to some of the interesting stuff we heard yesterday. Litigation that was very robustly defended, including an attempt to have the judge recused because it was felt that his decisions had been adverse, which was unsurprisingly rejected. So very robustly defended. And the judge even commented at the end of the litigation that there was every prospect that these problems would not have seen the light of day, given the way the case had been brought. Now, why did this matter? You're asking yourselves. Why am I bothering you with this details about this Horizon case? Well, very sadly, over the 20 years it took to get to that point in time, hundreds, and it's estimated to be about 900 post office managers were convicted of false accounting or theft to the criminal standard. There was also at least one suicide by a post office manager who was being prosecuted or threatened with prosecution. This saga has been called the greatest miscarriage of justice to afflict the English criminal justice system. There were also civil proceedings in which money judgments were obtained against post office managers. And one can see from some of these cases that when they were being pursued, there was more than an appearance of a presumption that the IT was infallible. And indeed, it seemed to be almost assumed that the burden seemed to be on the accused to demonstrate the failings in the IT system, even though, of course, they didn't have all the information necessary to do that. Now, of course, no one's suggesting that the technology is dangerous per se and should be thrown out, but I would close with this comment. In the UK, there's a rather successful slogan that's used on the rail network for safety reasons regarding packages. This isn't meant to be IT packages, physical packages that are suspected of being dangerous. And that slogan is, see it, say it, sorted. Now, you get played this a lot, and it's incredibly annoying, but it's also very successful. I would suggest adjusting that slogan for current purposes as follows, which is see IT, understand IT, and then resolve. It's not quite as catchy, I accept. I suspect it doesn't quite have as much future as the technology that it's meant to talk about. But I think clearly in the future, we as arbitration practitioners are going to have to be careful to see IT, understand IT, and work with IT until we reach the stage where we are supposedly all made redundant in the far-flung future. That's all I had to say for now.
Thank you very much, Rupert. I really hope we will never be redundant in the sense that you're trying to suggest. And I think it's very useful to use case law in order to illustrate the realities of the challenges of drafting contracts or the concepts that go beyond the new structures and understanding of technology when dealing with contracts. So thank you very much, Rupert. Helene, you are belonging to a new generation of arbitrators and lawyers, and you have been growing up in a world which is increasingly concerned of environmental issues, if I may say so. Obviously, this is a very wide array of issues under the umbrella of environmental terminology. But you've been involved actively, actually, in this, and we will be very glad to listen to your expertise in this field and to what you would like to share with us.
Thank you for that kind introduction, Lydia. It's a great pleasure to be here today and to speak to you all, to be back in my home country and home city. And I'm delighted that we have the opportunity to show our dynamic city and arbitration community to our international colleagues as well. I should also mention that whilst I'm speaking today in my capacity as the head of the Europe subcommittee of the Campaign for Green Arbitrations, there are two very important persons here with us today, the representatives of Romania on the committee, Sorina Olaru from NNDKP, who's also been intimately involved in the organization of this conference, as well as Alexandru Stan from PNSA, who has been speaking to many of you and handing out stickers with the little plant logo of the Campaign for Green Arbitrations. So I thank them both very much for their support of the campaign in Romania and beyond, because they have been instrumental in raising awareness about the Campaign for Green Arbitrations in Eastern Europe more widely. And please do reach out to them as well in the coffee breaks and over lunch if you're interested in this matter. So on to speaking about the important topic of sustainability in arbitration. It's important to note that this entire movement is happening against the backdrop of the current climate crisis, which has had a ripple effect in all industries, of course in the legal industry as well. And as far as the arbitration community is concerned, everyone's been affected and everyone has a role to play in making a change, from counsel to arbitrators to arbitral institutions. There is something to learn for all of us, and all of us can take small steps to make a difference. I will speak to you first about the Campaign for Green Arbitrations, about which hopefully you will have heard. And if you will not have heard about the campaign before yesterday, I'm sure now you do know about it from Alex, who's been very enthusiastically speaking about it. The Campaign for Green Arbitrations has made great strides in promoting the achievement of environmental sustainability in international arbitration, including by publishing its green protocols. The Campaign for Green Arbitrations, or CGA, as I will be referring to it, was founded by Lucy Greenwood, an independent practitioner and arbitrator, in 2019, and it aims to raise awareness about the carbon footprint of international arbitration proceedings and about how to reduce the environmental impact. The tenet of the CGA is Lucy Greenwood's Green Pledge, which is a set of guiding principles that includes the creation of a workspace with a reduced environmental footprint, the use of electronic correspondence if hard copy correspondence is not needed, the use of video conferencing facilities as an alternative to travel, the avoidance of printing, and the avoidance of unnecessary travel and waste. I'm very happy to speak to you about the Green Pledge further. And there's also, just outside of the room, there's a QR code which you can scan, and it will take you straight to the website that contains the Green Pledge. And you will also have an option to sign it if you have not done so already. Since 2020, a special working group of the CGA has also developed a set of 6 protocols that target specific stakeholders in international arbitration, with a view to providing guidance on the adoption of more environmentally sustainable behaviors in arbitration. And these protocols are widely known as the Green Protocols, and they have attracted significant interest globally since their launch in early 2021, including as they have been translated into a variety of languages. And on this note, I should mention that when Romanian colleagues were asked if they'd be interested in a translation of the Green Protocols, the overarching response was no. They're fine in English, and obviously we all practice very competently in English, so I think it's something to note. The 6 Green Protocols comprise guidelines for the conduct of arbitral proceedings in general, as well as guidelines for law firms and other legal service providers, arbitrators, arbitration conference organizers, hearing venues, and arbitral institutions. So as I said at the start of my little presentation, they do target all stakeholders in international arbitration. And the Green Protocols identify 3 areas on which we should be focusing to reduce the carbon footprint of arbitrations. First, the adoption of clean forms of energy. Second, the reduction of long-haul travel. And third, the reduction of waste. The wording of the Green Protocols is flexible, making the Green Protocols non-binding as such, and providing arbitration parties and relevant stakeholders with the option to implement these principles on a case-by-case basis as appropriate to the disputes or situation in question. To understand the practical importance of adopting more sustainable behaviors, it is also useful to look at the available data sets that illustrate just how impactful an international arbitration can be on the environment. And I should first mention the first case study conducted in this area by the Campaign for Green Arbitrations at the outset of the campaign. This case study revealed that to offset the total carbon emissions resulting from just one arbitration, just under 20,000 trees would be required. And this is the equivalent of all the trees in Central Park in New York, 4 times the number of trees in Hyde Park in London, or based on my own modest calculations, it's also the equivalent of 4 times the number of trees in the Herestro Park in Bucharest. The second set of data, which is relevant in this situation, pertains to a case study carried out by Herbert Smith Freehills in London in 2021, in which I also had the pleasure of participating. This case study analyzed the carbon footprint of a London-based medium-sized arbitration based on real-life case data. And it found that the total emissions amounted to nearly 40 tons of carbon dioxide equivalent, and the vast majority of these emissions were owed to council's energy usage and to travel, and especially to flights. And finally, Herbert Smith Freehills spearheaded case studies in this area by launching another one in 2022, which looked at the carbon footprint of in-person hearings against virtual hearings. And in this case study, we identified that the carbon footprint of an in-person hearing in a medium-sized London-seated arbitration was estimated to be 19 times that of a virtual hearing, with virtual hearings giving rise to emissions amounting to about 6 tons of CO2 equivalent. That difference is the equivalent of the average amount of CO2 generated by 15 people in the EU in an entire year. And again, the biggest contributing factors to the carbon footprint of in-person hearings were flights to and from the hearing, generating 93% of the carbon footprint of the entire arbitration. If you also find these figures striking, the good news is that there are steps that we can each take to minimize the carbon footprint of arbitrations. And such steps do require some behavioral change, but they are readily identifiable, and they could ease the impact of international arbitration on the environment, which, as we have seen from the data presented just now, is significant. I encourage you to read the green protocols on the website as they go into greater detail about the potential measures to be taken. But a few examples include minimizing printing and the use of paper, using shared technology platforms or case management systems for the receipt and organization of correspondence and pleadings in a case, consulting and conferring with witnesses and experts by way of video conferencing instead of in-person methods wherever that's possible and appropriate, and traveling responsibly. And it is at this juncture that I should also mention that the CGA or the green protocols do not discourage traveling. Rather, they promote savvy traveling. Our recommendation is that practitioners travel responsibly by considering when they need to travel, and should travel be required, ideally that travel will be combined for multiple purposes. So if you attend a conference somewhere abroad, hopefully you'll also be able to schedule some catch-ups with your contacts in that region, so you don't have to come again to the same city, take another flight just a few weeks later. I think that is all I wanted to say at this point, but both me and the 2 Romanian representatives on the campaign stand ready to speak to you about this more, but I will yield the floor back to Ligia now.
Ligia, can I just share a personal note on this?
Absolutely, please.
Just because to say that when the campaign for green arbitration was launched, I remember seeing it and I was very skeptical about it and even thought it was a little bit silly. And with time, they managed to convert me into a member, and I'm pretty much a fan of the campaign, and I work with it a lot. But also, just this year, we started receiving a lot of questionnaires from our clients, working with international clients, who are now analyzing the supply chain impact of their providers, including law firms. And I can only see this growing more and more. So observing the impact of our practice and addressing it, we do it because it's the right thing, but we should also do because it's going to be a requirement more and more for the modern practitioner in that regard. Just sharing this as a personal note.
And if I may add to that, that completely agreed. In a sense, it's a luxury for us right now that we are able to engage with these issues from a citizenship perspective, but it may not be an option in the future. And certainly our clients care about this. In the context of the pandemic, obviously making changes was necessary, but we increasingly, I'm sure that you will have also received similar questions, we increasingly receive questions from clients as to what it is that we can do to help them reduce the impact of the arbitrations in which they're involved, because ultimately the carbon footprint of an arbitration will be attributable to a particular entity or a company, and that will form part of their wider carbon footprint. So certainly from a business perspective as well, this is definitely something to think about, and we need to stand ready to answer questions from clients when these arise.
Thank you. Catherine, I think the time has come for you to analyze in more depth the future of arbitration practitioners, so focusing on the actual issue that is mentioned in the title of our section. How are we going to be shaped up by all these challenges and realities that we have been discussing until now?
Oh, brilliant, thanks. So thank you for inviting me along today. I'm delighted to be here, and it's really great to hear everybody's views. So I think it's safe to say that we're in a world facing some significant challenges. We've heard about some of them already from the panelists, but we've got, in addition to climate change, we've got cost of living issues, we've got conflict and unrest, and we're seeing massive changes in technology. As the leader of CIARB, I'm confident that arbitration and the use of effective dispute resolution has a crucial role to play in a sustainable future. But I do think some of the skills and expertise that will be needed from practitioners will need to change and be adapted to meet the needs of clients, which I think will look different in the future. Many of you will be familiar with CIARB, but please indulge me a little bit while I just tell you about it in terms of the context setting for the bit that I'm going to explore around those skills that will be needed from practitioners. So I think, as many of you know, I'm hoping that most of you are members, CIARB's a global membership and professional body for people dedicated to effective dispute resolution. I've tried to approach this from a global context, and the reason being is that CIARB has over 18,000 members in over 150 jurisdictions, so we do get a really good view of what is happening sort of globally. We've also got 43 branches, which are run effectively by practitioners, so by our members, for our members. And our aims are to globally promote the constructive resolution of disputes, be a global inclusive thought leader, and to develop and support an inclusive global community of diverse dispute resolvers. And certainly that last aim, I think, fits in around the skills that will be needed in the future. So again, as many as you know, we do train people, and once you've done our training, you get awarded what we call post-nominal, so letters after your name. And those are recognized sort of globally, so by many arbitral institutions and mediation panels around the world. And what we've done recently is we've developed what we call a competence framework. And that competence framework sets out the skills, knowledge, and attributes that we believe are needed for someone to operate as a competent neutral. And they've been developed not only considering the sort of knowledge or practice that you may need, but also some of those softer skills and some of those attributes. And what I mean by attributes, thinking about things like ethics, professionalism, integrity, and the adaptability that which, you know, we all know are vital part of practice. We also, as many of you know and will have been involved with, we do issue professional practice guidance and guidelines. We recently launched one on technology, so technology and arbitration, which is obviously relevant today. And we have expert groups, so we bring together experts from around the world to talk about ADR disciplines, but also we have a group that looks at technology and that looks at sustainability. And we participate on UCITS trial working groups 2 and 3, and so we get quite a global view of thinking, you know, particularly in that thought-leading thinking around the world. So, I mean, I mention all of this, obviously, apart from promoting CR, but also to try to link that to what I see as some of the future skills that practitioners are going to need. And this is my list, and some of this has already been touched on. I mean, we've talked about technology, but I think increasingly we're going to see the use of technology and the need for arbitration practitioners to have a really good understanding of the latest tools and software used in the field. And this includes discovery of, knowledge of e-discovery, online dispute resolution platforms, and data analytics. And sort of building on this, online dispute resolution, we're all familiar with it. We had to adapt and change at the start of the pandemic. It's certainly here to stay, and I think will be increasingly used. So it's emerging from the pandemic. You know, certainly what we haven't seen is a reversion back to purely face-to-face arbitrations, or indeed mediations for that matter. Data analytics. So increasingly, the amount of data available, practitioners are going to have to learn how to use data analytic tools to gain insights. And this will help with informed decision-making. But again, it's going to be crucial, and it's going to be an expectation, I believe, of clients that you're able to use some of those tools. And we've touched on artificial intelligence and you know, certainly machine-based learning. Obviously, increasingly, we will see AI-powered tools that can assist practitioners in tasks, and often those tasks are sometimes when I was chief executive of the Law Society of England and Wales, we'd sometimes talk about the commoditization of law, and there was a separation between some of those more routine tasks of searching through documents for change of control clauses or whatever else it may be, compared to some of that really analytical thinking and judgment needed by practitioners. But I think increasingly we will see AI being used for document review, for certain aspects of legal research, for aspects of legal drafting, and increasingly this will be the case. And obviously, as those tools get more sophisticated, the more they will be used. But there's some things that we just need to be mindful of with those tools. I mean, first of all, and I think we've touched on it already, certainly Carlos touched on this, but the lack of human judgment which goes into the use of those tools, because, you know, they are programmed based on data and algorithms, which may not, and certainly currently don't, always take into account the nuances of human behavior and emotions. And this can lead to certainly unjust, and, you know, I think certainly the case of that we talked about in relation to Horizon is perhaps a very stark example of that. Bias as well. If AI systems are used, they're only based on the data and the algorithms that, you know, so you're going to potentially build some bias into the system, and I think we need to be aware of that, because you can end up with decisions which can be discriminatory or unfair. There's a bit of lack of transparency sometimes in terms of how they operate. They're complex and difficult to understand, and we need to be aware of that. And there's some issues around security, which again we've touched on in terms of cyber attacks. So we need to be aware of the risks of AI, but the reality is that they will be used in the future, and therefore we need to, as practitioners, get ourselves up to speed with how they operate and the consequences of that too. Some additional things, blockchain and blockchain technology, again, we've touched on that in this panel, and cybersecurity. So thinking about, as more arbitral proceedings move online, practitioners need to be aware of cybersecurity risks and take steps to make sure that information is protected. But I don't think the future's just about technology. I think there's a number of additional things that I would add in terms of practitioners' skills in the future. Increasingly, cross-cultural communication skills in a globalized world and an increased globalized world. As arbitration becomes ever more global, practitioners need to be able to communicate with parties from different cultural backgrounds. And this includes understanding some of those cultural differences and being able to adapt communication styles accordingly. And we see that all the time at CIARB when you've got practitioners in 150 jurisdictions. Guess what? Culture is a big thing to take into account. And what might be the norm in England and Wales, which is the jurisdiction I'm from, will not be the cultural norm in other jurisdictions, and quite rightly too. Industry-specific knowledge. So again, increasingly, we're seeing arbitration practitioners need to have an in-depth understanding of the industries that they're working in, understand the relevant laws and the regulations in relation to those business practices, but also stay up to date with industry trends and developments. Mediation skills. So I've mentioned mediation, but I think it's actually broader than mediation. We're increasingly seeing that need for complementarity. And what I mean by that is having the right tools in your toolbox to effectively resolve a dispute on behalf of your clients, and how mediation can be used with arbitration, but also with other tools in order to do that. And at what time do you pull out the right tool based on how the case is developing and what the client's needs are at a particular time. And so I think the days of just thinking about maybe one method of resolving the dispute are probably gone. And we're seeing increasingly, ARB med ARB and various other sort of hybrid type models. And also sustainability. I mean, we've talked about the Green Pledge, and CIARB supports that. In fact, Lucy Greenwood's on our board and is simply brilliant. But it's also worth, particularly in the global north, thinking about the United Nations Sustainability Goals. We did a survey actually of our members, and it was really interesting to see that those from more emerging and developing economies were much more familiar with some of these sustainability goals from the United Nations than many of the practitioners who sort of practice in global north. So I think increasingly those goals are going to be expected and demanded, and we're going to have to produce evidence for our clients to demonstrate that what we're doing to move towards those things. So just in addition to some of those things, and then I will hand over, I think there'll be a greater focus on client experience. So I think developing some of those softer skills, ever more important. Clients are expecting their services to be more accessible, more transparent, and cost effective. And having that relationship with the client, I think, and being open and transparent and cost effective is going to be increasingly important. I think we'll also see more interdisciplinary collaboration. So probably most of us in the room are lawyers, but certainly if we look across CARB membership, it's actually, it's slightly more than 50% lawyers, but we've got a lot of other disciplines in the chartered surveyors, accountants, architects, that will contribute to resolving disputes. And I think lawyers will be increasingly working with other professional disciplines, data scientists, engineers, business strategists around the work that they do. Greater complexity. You know, with globalization comes greater complexity, so complexity of regulation, how it applies, particularly in a multiple jurisdiction setting. And as the law becomes ever more complex, which it is, that becomes ever more complex. Emerging markets. So I think, again, you know, traditionally there's been certain preferred seats for arbitration. We're seeing some, some people call the market disruptors coming in. I think that will continue. We will see, the obvious one is Singapore and the rise of Singapore, and obviously that's been going for some time. But, you know, as China, India, some of these other countries develop, we will see certainly emerging seats. More in-house counsel. When I was at the Law Society of England and Wales, around 30% of the solicitors in England and Wales are in-house. And with in-house, and we've heard about it from the first panel, becomes a more sophisticated purchaser of services, a more sophisticated client, and certainly from a legal perspective. And that will be increasingly the case, because with that complexity of law, more organisations want their in-house resource, and a greater emphasis on diversity and inclusion. So we do need to think carefully about how to ensure that the arbitration profession actually reflects the society and the clients that it's serving. And finally, I will finish on emphasising sustainability and sustainable practices. I think understanding that and understanding the contribution that we all have to make to that is a skill and the sort of experience that all practitioners will need in the future. So thank you.
Thank you very much, Catherine. Dalibor, it's your turn. The topic is not simple. It's quite complex. It's quite philosophical. And I'm sure that you will be able to analyze it and to summarize it in a very comprehensive way.
Thank you. Thank you, Ligia, and thank you everybody for taking the time to be present at this panel. And I agree with you, it's a very complex topic of diversity, equity and inclusion. And we all know that this is the topic that always attracts a lot of attention. And there's little time to do it, but I'll try to look at it from the perspective of the future, because the name of this panel is the Arbitration Practitioner of the Future. And so first of all, with respect to diversity, I just want to point out my perspective of looking at it is that very often the issue of diversity is looked at very narrowly. But I think in general, the diversity issue may be understood as referring to almost all forms of human difference. So it's not just gender, sex, but it's also the origin, the nationality, the cultural background. So it's much wider than people or many of the people actually look at it. So we have to, and when we speak about diversity in international arbitration, we have to ask ourselves, why is it important? And I think at least for three reasons. And the first argument is that it promotes party autonomy. And if we boil down this first argument to very basic elements, it's the argument states that the parties are entitled to arbitrators of their choice. And if they cannot make or find an appropriate arbitrator because the pool of arbitrators is not sufficiently diversified and it lacks diversity, then their party autonomy is affected. I think the second reason is for better decision making. And in that respect, there have been empirical evidence about how a group, like in our case, a tribunal that lacks diversity, they have like the common good sides, but they also share the common blind spots. And therefore, the tribunal that lacks diversity may not be able to comprehend all the relevant issues put before it. So, and then this is I think that the technical term for this is groupthink. And so the best way, so it's suggested, to avoid or to resolve the groupthink problem is to disrupt the group by ensuring that it includes at least one individual who does not belong to the same background, age, and all these other characteristics. And this individual is supposed to bring a different perspective to the thinking of the tribunal and therefore help the tribunal to render a better decision. And I think the third argument is for the legitimacy of international arbitration system, because we have all seen that I think that a big part of criticism of the ISDS system has been that it was dominated by a group of arbitrators that come from a certain region, age group, and ethnicity. And so I think, therefore, the issue of diversity is not, the point is to make the system better, to make the arbitration system function in a better way. And it should not be understood, and as a tool to include diverse professionals only for the sake of including them, but the point should be to how to make the system better. And so I think moving on to how the diversity will or might affect arbitration in future, I think having said all of that I have said already, I think biased attitudes in behaviors, and they do not have to be biased in an intentional way. They can be subconscious, they can be naive and not deliberate, but they can have deeply negative impact on fairness and equality. So, and having in mind the diverse cultural backgrounds of parties to arbitration, this is something that Catherine just mentioned, which is one of the, I think, important points on the Chartered Institute of Arbitrators agenda, is to comprehend all the different aspects of different cultural backgrounds. So I think while the differences in legal systems can be relatively easily discernible by obviously looking into the laws and making the analysis, the subtleties of cultural issues are very complex and complicated. They are way less tangible. They are very often invisible. However, they can have a fundamental impact on the outcome of the international arbitration process. I think, therefore, a modern arbitration practitioner will have to be someone who will have developed sensitivities for the subtleties of different cultures and traditions, and somebody who will be able to look at things from various dimensions of international and inevitably cross-cultural relationships. We have seen that the diversity issue has attracted a lot of attention. We have had panels yesterday, and I think once the diversity point was touched upon, there were a lot of questions for the audience, and that's quite natural. And I have just come, and there are other people here in the room. On Wednesday, there was a launch event of the ARBCE Association, which is the Association of the Arbitration Practitioners of Central and Eastern Europe. And I think there, at that meeting, there was, at least it was my impression, that there was a very strong sentiment that, for example, arbitration practitioners from the Central Eastern Europe have been underrepresented in the overall global context of international arbitration. So there is obviously a lot of interest on this topic, and I think that what the future will bring is cohesion in that sense. And of course, I would like to just to point out that the point should not be that we all need to homogenize and that we dehumanize individuality. It should be quite the opposite, that we all are able to understand each other cultural differences and take them into consideration while we conduct ourselves in arbitration. So that's very short and very brief on topic, and I'm happy to hear others' thoughts on this.
Thank you very much, Dalibor. I think now we can take some questions from the public, please. Oh, okay. Starting democratically with the first row and then progressing. Florian.
Thank you, Dalibor, for that presentation. I have a comment to make. I'm not denying that when we talk about diversity, many aspects are relevant, but I would say that the most pressing issue at the moment is gender diversity. And when we talk about that, I mean, we're talking about diversity of arbitrator appointments, but coming from a law firm where more than 50% of the partners are female, I can tell you that the key to many of these issues is diversity in law firms, gender diversity in law firms, and that will then resolve many other issues such as arbitrator appointments, because I think that generally the female partners tend to consider female arbitrators more, and even male lawyers tend to consider female arbitrators when they are working in a team with roughly 50% female arbitrators.
Yeah, thank you so much for this comment, and I absolutely agree with everything that you said. I would just like to add here that I think that the change is coming with this respect. And, I have to say that when we sat down at this panel, I could say that, the panel is actually quite diverse as well. And so in every respect, not just the gender diversity, but in every respect. But I agree with you, that the change needs to come also from the echelons of law firms, but I think that the change there is happening already. But I think we will have a different perspective here. So yeah.
Not sure I agree fully.
Yeah.
If maybe we had the same discussion like 10, 15 years ago.
Okay. Yeah.
Thank you.
I can comment on that.
Please do.
Do I need a mic? Maybe for the So I had two questions, but let's start from the last panel, the last speaker, so Dalibor. Actually, I echo your comment on gender diversity. I couldn't agree more, but I think you're right, Dalibor, that we are moving in the right direction, because if I'm not mistaken, for example, the Swedish Arbitration Center has now registered over 50% of appointments as female arbitrators. So it's encouraging, but I agree that there should be more to be done. But as a chair of one of the Racial Equality for Arbitration Lawyers Committee, I also think that there is important work to be done on ethnic diversity in appointments of arbitrators coming from different backgrounds. And in this respect, I wanted to ask you, Dalibor, and the other panelists, the experience and the example, let's say, of the Scottish Arbitration Centre that has recently introduced this article that makes explicit reference to the Equal Representation Pledge and to REAL when appointing arbitrators. Do you think it works? Of course, we don't have data yet because it's very recent, but do you see this initiative as a lobby activity, so to persuade the general perception of, you know, these issues, or do you see it as an effective instrument that so might be replicated by other institutions? So that's the first question.
Okay, should I answer this first? Well, it's a good question, whether it's a kind of a lobbying activity or is it just kind of, or is this going to be very direct, have a very direct effect? I'm not sure. I have to say I'm not sure. But the point is that it at the end of the day it has to produce the results that that wants to be achieved. So however we classify it, and I would say it's probably closer to, in my mind at least, it's probably closer to kind of the lobbying part of the spectrum as opposed to like a very hard rule. But the only important point is that that we get there where we want to be, and as you said rightfully, the data is not available yet, but we'll see how what progress will be made by this. Yeah.
I had another question on artificial intelligence, but I don't want to steal time or spots for anybody else. But if you allow me, just very quickly, a question for Carlos and Rupert. There are a number of studies on neuroscience and how the decision-making process works in our brains for arbitrators. And some studies have concluded that there might not be actually a completely unbiased decision when arbitrators decide. And so my question is whether you see that artificial intelligence will actually fill those gaps, because of course, lack of a complete unbiased decision tackles into the legitimacy of arbitration, might tackle legitimacy of arbitration. So I would be curious to see your point of views in the future. Do you see artificial intelligence trying to fill that gap?
So artificial intelligence trying to help arbitrators to fight their own biases, you think?
Help or substitute.
Yeah. I can't see that happening at least not in a simple way. Maybe if together with the tribunal secretary, if the tribunal can run the case past a very intelligent machine that could maybe give them some things to think about that maybe they haven't thought before, that could help. But so far, I think the best way to fight and like the implicit biases that we have, it's to talk about them and to acknowledge that you will have them, that everyone will have them. I think so far that's been the most effective way to deal with the implicit biases that so far. I can't see yet artificial intelligence helping with that, but maybe Rupert will think differently.
No, I'd agree. It feels to me that's part of human decision making, isn't it? And the question is, where do you draw the line anyway? And for example, if someone says the check's in the post, most people think, well, it's probably not, is it? And that's based upon experience and hearing plenty of other people say that when it isn't. Is that bias to assume that the check actually isn't in the post? I can't help feeling it's part of human decision making, and that's part and parcel of the process we currently have. But I can see in the future, when we're all replaced by machines, that will be excluded, but we might find there are other biases hidden in the code.
I just wanted to come in on it as well. I think what we perhaps have seen is the opposite of that, in the sense that there are certainly machine-based learning, AI tools, which, for example, analyze judges' language and decision-making and look for some of the areas where which that can be exploited. So, for example, if they prefer certain language, certain words, certain, that can then be used and played back to them which is going to be more persuasive. So I suppose that's just taking the opposite view of it. I don't think it's necessarily, from what I've seen, sophisticated enough to do what you said, but it can be used to exploit biases of people that, in terms of how they communicate, and that's been used now. I mean, that's you know, a piece of software that's been available for a number of years in the States, for example, analysing what, you know, judgments and then giving that to the party to say, this is the sort of language you should be using, these are the sort of words that resonate with these particular individuals. So when you're presenting your case, think about using that language.
Thank you very much. I think we have time for a very short question.
I will not open a new topic.
Okay,
Sorry.
That's duly noted. 3 short questions. Sorina, do we have permission to trespass into your time? Okay.
Sorry.
Thank you.
My name is Wojciech Sadowski. I actually wanted to comment on the last topic because I have a view on this. And I think that currently with AI models such as GPT-4, and which we all probably know and use as ChatGPT, which is an instrument based on that model. Those are statistical artificial intelligence models. So I think it's conceivable to imagine a situation in which a tribunal would ask a chatbot, ChatGPT, how would you resolve this case? And you would get an answer. You would get a draft reasoned award. Now, from the perspective of the tribunal, this could be very opportunistic. And it could be very easy, including easy money and speedy resolution of dispute. But I think it's more to that. Those models are statistical, which means that they are predicting how the majority of people would resolve a particular case. Now, we will have a tribunal, a sole arbitrator, or a trio with their human niceties, as Catherine said, their own personal biases. Now, I think I see the potential of the tribunal using that draft award as a mirror in which it wants to see the reflection of its own decision. The tribunal need not necessarily agree with that, but I think the tribunal may benefit from the fact that someone else looked at the record, identified possibly the relevant pieces of evidence. The tribunal may double check whether they have not overlooked anything on the record, and then make their own decision. And my question there, if you think that it's possible, do you think that would be conducive to a better administration of justice?
So who wants to?
I think it would be inappropriate because the parties did not appoint ChatGPT to render an enforceable award. That said, as I said, like it could be, it's a possibility, but I don't see, I cannot see it being used. But that's just my opinion. Catherine?
Yeah, I mean, I think I can absolutely see it happening in the sense of people testing it out. In fact, we did an event with one of our branches. It was actually in Brazil, Carlos, where they did a sort of a competition against the chat box, and fortunately won for the time being. I think that the risk with it is the data that goes into it and the algorithms which is generating that decision, because depending on what goes in, as we were saying before, that will depend what comes out. So if the nature of the data and the algorithms is set in a way that does exploit bias, then that will be the result. So I think I can absolutely see practitioners sitting down and plugging something in and testing, but and that by itself creates bias, because they are seeing then the answer that the chatbot would give them, and I think if some of those inherent biases are already in the system, then it becomes self-perpetuating, and that's some of the difficulties I think that we will see, and that's some of the risks around AI that have been in the headline news around the world, certainly in the last few weeks, about how that data and how those algorithms can be manipulated, and the consequences of that, which has broader reaching concerns, not just in arbitration, but but for other things.
Actually, why are the inherent biases
Well, I think that because if we become over reliant on those biases, and those biases just become ingrained into the system, then there isn't that opportunity to maybe step back and recognize some of those biases, because all we're doing is just perpetuating them. I guess that's my point. So what you would want to try and do is build some of that bias out of the system. So, you know, we all have different biases. Everybody has bias. But it will be different based on our own lived experience, but if you start sort of almost commoditizing that, then you start building in some inherent biases into the system, depending on the nature of the algorithm and the data that's fueling it. And so, you know, without that sort of human stepping back and questioning some of those things, then I would be concerned about that. And that's been the concern about AI, isn't it? I mean, that's the bigger concern. We're referring to it as an extinction event, and along with all the other extinction events that are going on around climate change. But that is the concern, because we believe it as the truth, the absolute truth, when actually it's only based on the data and the algorithm in terms of how to produce the information in the first place. But
Okay,
that's my take on it.
Thank you.
Hi, good afternoon. Lubinica Popa from Bucharest. So we're speaking about the modern arbitration practitioner. And we're speaking about diversity. And it took about 25, 30 years for the playground to get more leveled from all perspectives because of access to information, internet, access to education. And I'm not speaking only about the division between Western Europe and Eastern Europe. I'm speaking now about the diversity and inclusion in arbitration more widely, and also about the progress of arbitration, which was made also based on the decreased cost in many jurisdictions, the access of more users to the arbitration. And now we're discussing about the AI technologies, or the more advanced technologies, generally speaking. So not discussing only about the AI and the implication of AI into arbitration. And this means costs. Those are costly technologies. My question to the panel, and generally maybe to the audience, would be, how can we avoid getting back to a more polarized arbitration community as practitioners, but also arbitration generally as users, since the access to these more costly technologies is not available to the majority of arbitration practitioners all over the world, which are not belonging to the major law firms or are not belonging to the Western countries, to the more developed countries. How do you see the development, and how do you see we can keep up with diversity from all points of view, as Dalibor was rightly indicating, not only gender, but cultural, but different continents, different backgrounds? How can we keep up with the increasing pace on diversity while confronting the AI and the costly technologies, not from the perspective of biases or how we use them in arbitration, but from the perspective of their increased costs to arbitration generally, and also to the education and formation of arbitration practitioners? Thank you.
If I may make a comment on costs, I appreciate that most of the things that we've discussed today, the instinct would be to say that they involve costs, and the reality is they do involve costs. But I think your experience probably reflects this as well. Certain things are becoming cheaper, more widespread, definitely more widespread in some parts of the world than in others. But in terms of what I was discussing earlier, in-person hearings against virtual hearings, we've actually found in the case study that we've done on that it's cheaper to conduct virtual hearings, slightly cheaper, but cheaper. And when we talk about cheaper in arbitration, we're talking about tens of thousands of euros and pounds. So every little counts. And I think there is an issue with the spread of these technologies and who has access to them, but also hopefully the fact that there are many stakeholders beyond the legal world working on solutions. Hopefully this means that in the future we'll also see a reduction in costs.
Thank you very much. Elena, a very short one, please.
I have an answer for a question, because it's already happening, and I think that it's important for you, the organizers, to invite next year Use Mundi, whose base is a research platform based on artificial intelligence, and it is possible for the RICAD to detect biases. They are already doing in the field of investor-state arbitration. Their filters, screening people or arbitrators on the way they decide, pro-claimant, pro-respondent, views on the use of MFN, and all sorts of arguments. It is possible to do that, so artificial intelligence is used. And recently in the press, in the arbitration press, there was a case where they applied algorithms to a famous award to understand whether it was drafted by the arbitrators or the secretary, and based on the language used by all of them, they detected that most of it was drafted by the secretary, which of course entailed various considerations. So it's possible, it's coming. But
Thank you very much. Thank you very much, Ilana. Thank you very much, the public, the panelists. Thank you, Sorina, for the understanding. I think the take from this is that arbitration and arbitration practitioners cannot be immune to progress and technological development in particular.
Tremendous honor for me to introduce to you our investment state arbitration keynote speaker, Mrs. Martina Polaszek. Currently online, there are 700 viewers, individual users, that are waiting for the keynote address, and that by itself speaks about the magnitude of your presence here in Romania and about the magnitude of the interest that we have in your speech. Mrs. Martina Polaszek is the Deputy Secretary General of the International Center for Settlement of Investment Dispute. She has served as Secretary of Tribunals in many arbitrations under ICSID Convention, Mikula case brother being one of them, as I learned last evening. She served also in many arbitration under the ICSID Additionally Facility rules and UNCITRAL rules. She has also acted as ad hoc committee secretary in numerous annulment proceedings. She is recognized by arbitrators, parties, and counsels for her expertise in ICSID process. Ms. Polaszek has led several key ICSID projects, most recently the revision of the ICSID rules and regulations. She has also represented ICSID before state delegation, judges, and private sector, including before UNCITRAL. She has spoken at major conferences and has authored papers on ICSID procedure and jurisprudence. Prior to joining ICSID, Mrs. Polaszek worked as an attorney with law firm Janté in Paris and White & Case LLP in Prague, focusing on international arbitration and international law. She holds a degree in George Washington University Law School and an LLM, in George Washington University Law School, University of Paris Descartes, and University of Göteborg, Master of Law. Thank you so much for accepting our invitation, and we are honored to have you as our guest here. Without further ado, Mrs. Martina Polaszek.
Thank you very much for that kind introduction. And thank you to the organizers, the Romanian Chamber of Commerce and Industry. Mr. Diacono, thank you very much for the invitation. Ms. Crina Beltag and Cosmin Vasile, thank you for having me here. This is ICSID's first Bucharest Arbitration Day, and we're very, very pleased to be part of this high-level program and to be supporting Romania in general. Romania is a very valuable member state of the ICSID Convention, and I'm very pleased to be here again. I was here a few years ago. Now, we've heard very thought-provoking panels about shareholders' role in international arbitration these two past days. And Bucharest Arbitration Days has put the emphasis on the word role, which I really liked. It's rightly so. We each have a role to ensure that international arbitration, whether it's commercial arbitration or investor-state arbitration, that it's serving its purpose. It's important that we develop and adapt or reform, if you will, these dispute resolution systems to a changing world and to adapt them and respond to user needs. But it is good to remind ourselves of what those user needs are to make changes that have positive impacts. Now, the ultimate goal, and I think we all agree on that, is to offer a forum for neutral dispute resolution that is suitable for cross-border transactions. And that helps to create a favorable business and investment environment, and that's what business needs. More specifically, users need a stable, an effective, and predictable regime that's perceived as neutral and fair, and under which they can eventually enforce their result. And we know that arbitration and ADR present advantages that respond to these needs. And we know also from empirical research that a majority of stakeholders prefer international arbitration for resolving these cross-border disputes, either on a standalone basis or in conjunction with ADR. The alternative, domestic remedies, may often seem unfamiliar, too complex, or challenging to navigate. And there is a concern about national bias and, of course, also delay in domestic proceedings. Now, when it comes to investment disputes involving states, there are additional challenges. Historically, apart from the concern about national bias, foreign investors often faced the invocation of immunity from suit by a state. So essentially, they could not even initiate a claim because of state immunity from jurisdiction. And sometimes domestic courts in the host state had no jurisdiction to adjudicate international wrongs, much less the ability to ensure enforceable awards. And at the same time, there were also significant challenges with international remedies. So most notably, a non-state claimant that wanted adjudication of an international wrong had to ask its own state, its home state, to espouse their claim. And we know that home states rarely wanted to take that responsibility on. And this was the politically charged arena. In other words, it would have left the investor without access to justice. Now, we should not underestimate the effect the lack of adequate remedies have on business decisions. These risks are real, and they are being considered when investors choose where to invest and consider the particular situation in a particular country. This is confirmed by the World Bank Group Global Investment Competitiveness Report, which surveyed over 2,400 global business executives. And it shows that a country's legal and regulatory framework, including access to effective dispute resolution mechanisms, is one of the most important factors when deciding to invest. And the study also shows that investor confidence and foreign direct investment flows increase with regulatory transparency, investment protection, and effective recourse. Now, this is not only about the private sector. States play an important role in creating such an environment that favors business and that promotes foreign direct investment. And this is really why ICSID was established in 1966 through the ICSID Convention. It was meant to address some of these risks and obstacles that foreign investors faced when operating in a foreign state, in particular with regard to disputes with the host state. It allows investors and states to bring their dispute before ICSID, before an international organization, so a neutral forum that both parties can have confidence in and that will render an effective result. States that become part of ICSID, that become member states, send a signal to foreign investors that they are prepared to allow access to justice before ICSID to foreign investors, and that they waive immunity from jurisdiction, and that they commit to comply with and enforce the outcomes. Now, many states have signed on to this system as part of their investment policies. ICSID now has 158 member states. And as part of these policies, since the 1990s, states have also entered into investment treaties and adopted laws promising to treat foreign investors in accordance with certain standards of treatment. Today, there are about 2,600 such treaties in force, and most of them provide for dispute settlement referring to ICSID. Roughly 178 states have at least one, if not more, of these treaties. And so it's not surprising that the increase in foreign direct investment, an increase in the number of treaties, creates more opportunities for investment disputes to occur. And that has driven the demand for ISDS, investor-state dispute settlement. But what's more important, though, is that the number of studies have found that the availability of ISDS and the adoption of international investment treaties do attract and retain foreign investment in the states that are part of this system. So access to justice should be viewed as a positive feature, and the increase in cases during the past 20 years should not be a critique, but a natural consequence of more cross-border transactions. Now, ISDS is not an easy success story to tell because disputes are never good news. But disputes will always arise, no matter the discipline. The focus should be on having a forum to resolve them and the means of resolving them, not on the disputes themselves. And that's our role as stakeholders of the system, to ensure that there is a forum to resolve them and that the parties have confidence in the dispute resolution system. And that's what needs to drive any reform proposal. But we know that that's not always the case. The increase in cases focused the attention of the media, government, and civil society in a way that is unheard of in this discipline, or in any discipline, really. And it garnered a critique from some observers. Some of this critique is based on perceptions and might be termed as ISDS urban myths. Among the myths were statements that states always lose, that only developing states are named as respondents, that only big foreign corporations are claimants, and that investors see ISDS as a profitable venture. Basically, they sue governments for profits only. Now, frustratingly, these myths endure despite consistent empirical evidence to the contrary. For example, ICSID produces biannual statistics showing that respondents prevail in 52% of the cases that lead to awards. So they win more than investors. And at the same time, it is true that with the increase in investor-state cases at ICSID and elsewhere, we have gained more practical experience and seen considerable development in case law, both with regard to procedure and substance. And the increase in cases also meant that more states and more investors got involved. And all of these stakeholders had different perspectives on how the system is working, and they have their own views on how the system should be improved. Now, today my remarks will focus on the procedural aspects. As ICSID is an institution entirely devoted to ISDS, we've always seen it as our role to ensure that the procedure is fit for purpose, and we've taken the lead on advancing improvement. Already in 1984, we took the first step to introduce transparency provisions in our arbitration rules, long before the discussions that ultimately led to the Mauritius Convention on Transparency. And we were the first institutions that adopted an early dismissal of claims provisions in our rules to eliminate or to help eliminate frivolous claims on an expedited basis early on in the process. And as many of you know, ICSID recently adopted the 2022 ICSID rules, which entered into force on July 1st of last year, and which addressed many of the stakeholder concerns. That latest amendment project started in 2016, before the discussions at UNCITRAL Working Group 3, We first initiated an extensive consultations with our member states and the public, and that helped identify topics for amendment. But we also had identified ourselves changes from our own best practices and lessons learned in case administration. Now, given the many suggestions and our own wish lists, we quickly realized that we were heading for a comprehensive amendment of our rules. But the overall objective was to maintain the strengths of the system and to build on those strengths. It was also very important for us to achieve a balance between the interests of claimants and respondents so that both parties continue to have confidence that the rules provide for a fair process. Since investors most often act as claimants and states most often act as respondents, it's key to have a balanced set of rules that treat both parties equally. Otherwise, there is a risk that the parties, or at least one party, will not want to apply them and will choose a different kind of rule set. Again, user confidence is key when driving for change. In the end, we went through 6 working papers and had 3 in-person state consultations that resulted in amendments that were voted on by our membership last year with 85% approval and no objections. So more than the votes needed to pass them. And this degree of consensus bodes well for legitimacy of the reform and as a result for compliance with the new ICSID rules. Now, UNCITRAL Working Group 3 has been undertaking work on ISDS reform since 2017, also focusing on procedural matters. Some of these overlap with the work that ICSID has done, but the general scope is broader. The working group is also looking at various reform options that go to the structure of ISDS. For instance, the establishment of a multilateral investment court and an appellate body for ISDS awards. Now, some of the main concerns that have been driving these efforts address the legitimacy of the process, transparency, consistency, and correctness of decisions. Now, there is a spectrum of reform options on the table in the discussions before the working group. Some seek to preserve the current system with some smaller changes to the procedure. Others that wish to implement more significant structural reform, possibly through a multilateral instrument on ISDS. Now, these discussions are taking more time than anticipated, and some of the topics that were described as low-hanging fruit proved to be not so low-hanging. The code of conduct is an example of that. ICSID has been working with UNCITRAL on a code of conduct for arbitrators and for judges on a potential multilateral investment court, which showed that consensus may be difficult to reach on matters such as arbitrators acting in multiple roles as counsel and arbitrator. But now the work on the code is concluded and ready for adoption in July before the UNCITRAL Commission with a last-minute compromise on double heading. And yes, there will be a somewhat limited prohibition. I invite you to have a look at it. The working group also concluded work on mediation provisions and guidelines on investment mediation. This is another area where ICSID already moved forward as it adopted our own mediation rules in 2022. And at the same time, it's been supporting the work of UNCITRAL. So the UNCITRAL draft provisions on mediation, those are intended to be used in investment treaties, but they don't regulate the actual conduct of the mediation. And so the thought is that the ICSID mediation rules or other similar rule sets will be selected by the parties. So the work of ICSID and UNCITRAL has been complementary in these areas. Next on the UNCITRAL agenda, there are discussions about a potential multilateral investment court and an appellate body, the establishment of an advisory center, and work on procedural provisions, in particular provisions on third-party funding, security for costs, early dismissal of claims, and counterclaims. Now, ICSID already addressed these topics in the 2022 rules, so you might be thinking, why reinvent the wheel? And do we even need to adopt similar provisions at Working Group 3? Now, one thing that is true is that the UNCITRAL arbitration rules currently do not contain this type of provisions. So the working group may wish to consider how to better align the UNCITRAL arbitration rules for use in investor-state arbitration with the ICSID rules. Now there's another working group 2, that was considering, for instance, early dismissal of claims as a change of the UNCITRAL arbitration rules. But this working group has a different mandate, which is not concerned with ISDS, but instead focused on dispute settlement in general. And it opted not to include a specific rule on this topic. Instead, there will be a guidance note to assist the parties and the tribunal, and the matter will be left to the tribunal's discretion. And the guidance note itself shows that there is a different approach to early dismissal in the guidance, the ICSID rules and the proposal before Working Group 3. And of course, there's no requirement for parties to disclose third-party funding in the UNCITRAL arbitration rules, as in the ICSID rules. So there is a real need to amend the UNCITRAL arbitration rules for ISDS, not to focus on changing ICSID again. Now this brings me to what I really wanted to tell you about, ICSID's most recent contributions to advancing reform, the 2022 ICSID rules. Now they bring about improvements that have been welcomed by all stakeholders, and that will hopefully address some of the concerns raised in the public discussions. Let me give you an overview of the main changes that can broadly be grouped under these 4 headings. First, we wanted to decrease the time and cost of proceedings. Second, we wanted to address what we call the reform issues. The ones that I just mentioned are before Working Group 3. Third, we addressed various concerns about conflict of interest, many of which were later also covered by the Code of Conduct that we worked together on with UNCITRAL. And fourth, we sought to broaden the dispute resolution options available to parties. So for instance, the new mediation rules. Now, I'd like to address each of these, starting with the time and cost of proceedings. And this is a complex issue. Users expect efficiency in international arbitration, and they are frustrated when the process takes longer and is more costly than they anticipate. This is true in all types of arbitration, but the concern is especially acute in ISDS. And it's perhaps not surprising. We have complex issues of public international law being applied, complex fact situations, and we're dealing with governments who have to coordinate with multiple internal and external stakeholders. It's hard to say what is the right amount of time, but everybody agrees that investor-state cases take too long and are too costly. Often, counsel blame the arbitrators for taking too long to issue decisions. And arbitrators blame counsel for taking too long, filing too many motions, too many documents, and too long briefs. Now, while everyone wants a faster process, we also heard a number of pleas for more time, and we not infrequently see both parties asking for long periods to file submissions. Now, there's a tough balance to be struck, but it's time to recognize that we all have a responsibility here. And that's why we address time and cost with a multi-track approach that really involves all participants in the process. And that cumulatively, I think, should make a real difference. It starts with the basic principle that both parties and arbitrators have an obligation to conduct the proceedings in an expeditious and cost-effective manner. And this is reinforced by an availability commitment by arbitrators at the appointment stage. Basically, they certify that they have sufficient availability and that they will respect time limits in the arbitration rules. And we do have quite a few time limits for the tribunals, and you can find them summarized on our website. The longest one is for an award on the merits, and is 240 days after the last submission, so roughly 8 months. Now, these are best effort obligations, but tribunals must notify if they are late and indicate the reasons. Otherwise, we as the institution might postpone payment of arbitrator claims, and we will also be tracking the time and publishing that data. Now, for those of you in ISDS, I think you will recognize that the 8 months is an ambitious target. So everyone will need to make an effort to enable the tribunal to meet those deadlines. And to do so, the rules encourage proactivity by arbitrators to use the tools at their disposal. For instance, proposing page limits and hold case management conferences to identify uncontested facts and narrow the issues in dispute. We've also introduced and reduced certain party time limits. For example, a challenge to an arbitrator must be raised within 21 days of the relevant facts. Now, at the same time, the rules maintain flexibility. Ultimately, the procedural schedule will depend on the agreement of the parties and on the arbitrators that they appoint. Therefore, we will need users' support to make a difference. You can all play a role here. For example, parties should avoid appointing arbitrators who are too busy or who have a track record of taking too long. Please do instead consider the large pool of arbitrators who have yet to receive their first appointment in ISDS, but who would be terrific in that role. Romania has many such candidates, both men and women, but I dare say in particular women, and I see some of you in this room. Second, parties should consider the length of submissions and the number of supporting documents. It is not unusual that we see submissions of 500 pages or more, and thousands of exhibits and legal authorities. Long submissions means a long time to prepare the award, and that leads to delay. So please do take advantage of the case management tools available in the 2022 rules. One of the more revolutionary tools is the option to use expedited arbitration. It's the last chapter in the arbitration rules, and you can add it to your convention case or your additional facility case. If followed, the procedure would reduce the time for a case to about 1.5 years. It's nothing like a fast-track procedure in commercial arbitration, but it's specifically designed for investor-state disputes. And we recognize that it's not for every case, but it could be useful, in particular for investment disputes based on contracts, maybe involving state agencies, or cases involving small and medium-sized enterprises, which often translates to small value claims. So be open-minded about that for your cases. Even if you do not opt to apply the entire chapter, you can adopt some of the cost and time-saving provisions to your regular arbitration proceeding, for instance, about tribunal constitution. Now, finally, with regard to time and cost, we've provided for electronic filing of all documents. No more hard copies at exit. And we also provided for the availability of remote hearings. We did more than 500 remote hearings and sessions during the pandemic, and we've gotten really good at it. Now, although many hearings are back in person, I think it's important that we remember the cost and carbon footprint savings inherent in the remote hearings, and not to abandon them fully. Now, moving on to the reform issues, we've introduced new rules concerning third-party funding, security for cost, and developed the rules on manifest lack of legal merit and transparency. Third-party funding has been much discussed, and there is no clear consensus on the extent to which it needs to be regulated. The way we approached it is that it's relevant for conflict of interest purposes. So we do require a disclosure by the party getting third-party funding. It must disclose then the name and address of the funder immediately after registration. And if the funder is a juridical person, then the disclosure must also include the name of those who own and control the funder. This includes counsel getting contingency fees or a parent company funding its subsidiary, which is the claimant in the proceeding. The parties are not required to provide the third-party funding agreement, though, or the terms of the agreement, only the name and the address and ownership details if applicable. If the other party requires information about the third-party funding agreement for whatever reason beyond conflict of interest, it can request that the tribunal order further information under the rules concerning the production of documents or other evidence. Now, the Rule 41.5 manifest lack of legal merit now has its own provision. It's Rule 41, coincidentally. The main addition is that the rule clarifies that the objection can relate to jurisdiction. This was not specified in the previous rules, but it has since been clarified in jurisprudence, and so it's now codified in our rules. And another new rule is that there is a presumption that the prevailing party is awarded its reasonable costs unless there are special circumstances that justify a different allocation. And this also reflects case law. If there is manifest lack of legal merit of a claim, then the respondent is often awarded its costs if the whole claim was dismissed. Now, we also have a new rule on security for cost, which essentially provides that a party may be asked to post security in advance of the outcome of a case to ensure that it is able to comply with an award of costs in favor of the other party. Now, this was a concern for many states, in particular in a few cases where the investor was ordered to pay costs, yet at the end of the day had no assets to do so. And sometimes the complaint was that the claimant had done that on purpose, set up a shell company so that it was judgment-proof. Now, under the 2006 rules, there was no provision specifically dealing with security for costs, so it was dealt with like provisional measures, which are recommendations in the exit system. Under the new provision, the tribunal may order security for cost in certain circumstances, which are listed in the rule. The party's ability and willingness to comply with an adverse decision on cost, but also the effect that security for costs may have on that party's ability to pursue its claim. That's the access to justice argument, as well as the conduct of the parties. And if that order is not complied with, then the tribunal can eventually terminate the proceeding. Now, there was a lot of debate about third-party funding in this context and to what extent it is relevant for security for cost. A few states wanted security for cost to be automatic upon the disclosure of third-party funding, but others didn't find it relevant in and of itself. So there is a compromise in the rule, in the fourth paragraph, that the tribunal must consider all evidence adduced in favor or in relation to the circumstances, including the existence of third-party funding. And all that means is that tribunals must consider all evidence in favor of or against security for costs. Now, transparency was also a key issue in the reform discussions. Many stakeholders are in favor of greater transparency in cases, but the level of transparency was debated. Now, we wanted to increase the level of transparency where it would most affect the creation of a stable and consistent jurisprudence. So the focus have been to making awards, orders, and decisions publicly available. The parties can still agree on the level of transparency and confidentiality that they want in their exit case, but the default rule is that awards will be published with consent of the parties. That's the convention article. And orders and decisions will be published unless the parties agree not to publish. So the default is publishing orders and decisions. And the parties can agree on the redactions, of course. If they don't agree, that decision goes to the tribunal. And we, ICSID, will publish the decision on order with the redactions decided by the tribunal. Now, third, we did various changes going to the theme of conflict of interest. I mentioned the work we did with UNCITRAL on the code of conduct, but ICSID already took a number of proactive steps to address conflict of interest and arbitrator conduct in its amendment process. And many of the rules that we adopted are aligned with or overlap with the code and really set high standards for ICSID arbitrators. Most importantly, we adopted a new arbitrator declaration, which with several key components, including a broad disclosure requirement and confirmation that the arbitrator has sufficient time for a case. Now, the code of conduct will not be part of the ICSID rules at this time. It will apply as soft law, but it will reaffirm and complement the ICSID rules. So it will be helpful for parties to rely on. Finally, I'm pleased to say that we also expanded the options for dispute resolution in the 2022 ICSID rules. And I wanted to bring two of these to your attention. The first is the expansion of jurisdiction under the additional facility rules in cases where you can't use the ICSID convention because one of the parties is not a member state or an investor from a member state of the convention. So you can, for instance, now have a regional economic integration organization acting as a party under the additional facility rules, and you can have investors and states both coming from non-ICSID member states. So this is a good option when the convention is not available and a good alternative to the UNCITRAL arbitration rules, which also benefits from the similar changes that we did to the ICSID Convention rulebook. Now, the second and most widely anticipated dispute resolution option is the mediation rules that I mentioned previously. And that really responds to requests, the great interest of states and investors to provide this capacity at ICSID. And we do hope to encourage more mediations with this effort and to emulate the success that we've seen in commercial arbitration. The ICSID mediation rules allow also a broad access to, as long as you have a state involved or a regional economic integration organization, and the parties have submitted, consented to mediation, we can administer the case. And the final feature that is also worthy of mention is that it has been aligned with the formal requirements of the Singapore Convention on Mediation, meaning that the mediated outcome settlement agreement could become enforceable. Now, as mentioned, the 2022 rules have entered into force and we have started applying them to new cases. Our priority is now to monitor how they work in practice. And we will need our stakeholder support to apply them and to comply with them to guarantee their success. As mentioned in the beginning, we all have a role to play. Our role as an institution is to ensure that the system is now operating well. And at the same time, we will continue to be part of the ongoing reform discussions at UNCITRAL and elsewhere. Clearly, there are some difficult discussions that may further shape ISDS. For example, the intra-EU objection to jurisdiction and how that will affect states' obligations, international obligations under treaties such as the ICSID Convention. There is a debate about the future of the ECT and its modernization, and the desirability of a multilateral investment court and an appellate body, and what impact it might have on the current system. But as we figure out the path forward in ISDS, we should not lose sight of its purpose. It was meant as a tool to promote investment, and any reform should ensure that it continues to do so. This is even the more important in a world where private sector investment has become crucial to address global problems. So we should be thinking about each of our roles in advancing reform and making sure that the impact is a positive one. Thank you.
Thank you for this enlightened speech. And now I would invite our colleagues from the panel to join us. I'm sorry to say we will not have a break because we are very late and the original schedule is exceeded. It is a privilege for me to be moderating this panel with such distinguished practitioners in the field of international arbitration and particularly in the field of investment state arbitration. Thank you. Our panel is supposed to tackle the issues of cost and time and use of technology as tools for diminishing cost and times in a world where cost and time is heavily impacting state investment arbitration, as we already heard. It is my pleasure to introduce Mrs. Hannah Ambrose. Mrs. Ambrose is a partner with Herbert Smith Ferry Hills in London. She has acted as counsel in ad hoc commercial arbitration and proceedings under the auspices of major arbitral institutions. She has advised on a number of investment treaty arbitration matters and issues. She has acted as counsel on a number of investment treaty claims. She has also experience in advising in a wide range of matters in public international law, including state immunity and immunity of international organizations. She's a member of the steering committee of Herbert Smith Free Hills Pro Bono International Development Project Fair Deal Sierra Leone. She is a trustee of the International Lawyers Project and a leading charitable organization advancing economic justice and the rule of law through provision of pro bono legal expertise to civil society, parliaments, and community. Welcome, and we are very honored to have you here. On my right, we have Mrs. Sara Vassani. She is co-head of International Arbitration, CMS Cameron McKenna Nabarro Olsvalg LLP, based in London, covering UK, Central Eastern Europe, UAE, Singapore, Turkey, China, Brazil, and Mexico. She is a seasoned international arbitration lawyer specializing in both international commercial arbitration and investor state dispute, representing clients before all key arbitral institution, LCIA, ICC, SIAC, SCC, and ICSID. She has dual qualification in England and Wales and the US, Texas and Washington, and she is a solicitor advocate to the higher courts of England and Wales. Thank you very much for coming to us. It is an honor to have you here. Then I will turn my attention to Mr. Nick Lon, partner in Van Bael and Bellis, Nicholas Lon, leads the Van Bael and Bellis London-based international dispute resolution team, and he specializes in international arbitration and litigation with a particular focus on investment arbitration and public international law. Over the course of nearly 20 years now, he has advised various range of clients, company, individuals, and governments before international international arbitration panels sitting under ICSID, UNCITRAL, ICC, and LCIA arbitration rules. And we are very, very happy to have you here with us. And I would not go last but not least. I turn my attention to Mr. Peter Polacek, and we are very happy to have you here. Peter Polacek focuses on investment treaty arbitration, international commercial arbitration, public international law, and the protection of foreign investment. Has a successful track record in advising clients in complex international disputes, in particular those in Central and Eastern Europe, Latin America, World Bank International Center for Settlement of Investment Disputes. He has his pro bono work includes asylum veteran benefits, so thank you very much for sharing that with us. Peter was educated in Czech Republic and in United States. He started his practice in Prague, and then in 2018 he moves to Washington. He is a New York State Bar member, District of Columbia Bar member, and US Supreme Court qualified lawyer. Thank you very much for coming and for being here with us as well. Without further ado, we heard from our distinguished speaker earlier that costs and time are heavily impacting state investment arbitration, and they are concern, an increasing concern for both the stakeholders, or all three of the stakeholders, because if we are to consider also the arbitral institutions in general as stakeholders in the international state investment settlement dispute procedures, we have to consider all three of them. The previous panels of the conference addressed the role of arbitral institution in commercial arbitration, counsels in commercial arbitrations. The role of state and investors was not addressed, and that's our job to do during this panel. Now, earlier we have discussed about costs and about tools for diminishing those costs. And use of technology was one of the issues that came along, and I'm happy to say that although it was at length debated in the panel before us, there are many issues that entailed discussions, and I think that it will be very, very important for us to continue those discussions. So one of the questions that I would have following the use of technology in arbitral proceedings is how soon in an arbitral proceeding you would welcome the use of technology. I mean, is it in the phase of preparing an arbitration case? Is it in the phase of, I don't know, selecting the arbitral tribunal? How would you do it? Who would like to take the floor? Nick?
So firstly, I'd like to thank Serena and the other organisers of the Bucharest Arbitration Day for the invitation. It's a very kind invitation. Now, I think everyone can agree that one of the key benefits of international arbitration, whether commercial or investment arbitration, is the ability of the parties to select, nominate their own adjudicator. And that doesn't mean that they pick a partisan or partial arbitrator, but it means picking the right arbitrator. Selecting the right arbitrator is very, very important in international arbitration, and it's something that parties invest a lot of money, time, energy, and money in trying to get the right arbitrator. Now, so how do we select arbitrators? Now, in the investor-state context, I think the approach is slightly hybrid. So there's often a distinction between an intuitive approach and a data-driven approach. And I think possibly within the commercial context, the traditional approach was very much an intuitive approach. Arbitrators were researched and selected based on intuition. In the investor-state context, there's a much more hybrid approach. It's always been a mixture of both intuition and data analysis. Now, what do I mean by intuition? I mean that you pick up the telephone, you speak to your colleagues, you speak to your friends, you ask them about the arbitrator. Have they appeared before the arbitrator? Have they sat before the arbitrator? That's partly how you judge whether an arbitrator is going to be right for your case. But that's just one element, and that's a very, very subjective element. And in investor-state arbitration, there's always been an approach based on data, because in ISDS cases, the awards are, for the most part, public. So you can see the style of the arbitrator's reasoning. You can see how long it took the arbitrator to issue the award after the date of the hearing. And so in investor-state arbitration, there's always been this mixture of both the intuitive, the picking up the telephone, and also the data-driven. Now, in investor-state arbitrations, there is obviously a limited pool of arbitrators, and there are some arbitrators that have issued a hell of a lot of awards. And it is a time-consuming process to review each of those awards and to consider the pertinent elements of each of those awards. You know, in an investor-state arbitration, it may be a bet the company or bet the country case, and it may be worth the investment to review all of those awards. But it's very time-consuming and it's very costly. And so that's where technology is starting to play a role. More and more, we're seeing the use of arbitrator databases. And there are various products on the market. We don't need to plug them, but there's Arbitrator Intelligence. GAR also has its own arbitrator selection database. And these are databases that basically rely on pooling data from public sources and from other sources. So they take all publicly available and not publicly available awards, and they run data analysis on these awards. The result is that they produce arbitrator reports. You can purchase an arbitrator report, which sets out everything from the arbitrator's procedural preferences to the arbitrator's approach on substantive issues. So no longer necessarily do you need to wade through hundreds of awards that an arbitrator has published. you can theoretically rely on some of these technology-driven approaches and simply look at the reports that benchmark the data across the whole of available data. So I think that's just to really start the discussion that there are now these technology-driven tools which make the process of arbitrator research much, much easier. Now, there may be some reasons why, and there have been criticisms as to whether one should be using these tools, whether they are just as subjective as picking up the phone to one partner and getting that partner's opinion on a particular arbitrator. But these are certainly tools that are out there and can make the process much, much easier.
I have a question. Have you used already this type of tools in selecting your arbitrators? Is it a preferred tool for you? What are your concerns in using it?
So I think, so yes, in the appropriate, so it's inexpensive. It's not a cheap option. So these are quite expensive products. To purchase the reports can be quite costly. So you wouldn't necessarily purchase a report in all cases. It would have to be worth it. And I think, they still need to be taken and read with some care and caution.
Have you seen them, Nick?
So I've seen a couple, actually. Yeah. I've seen a couple. And I think that one of the issues is that, so one of the problems with relying just on word of mouth, picking up the phone to your partner, is you don't know how representative it is. I mean, we've probably all experienced this where you ring one partner, what's your view on arbitrator X? Arbitrator X is fantastic. You ring second partner, and their view on arbitrator X is that he wasn't great, right? He or she wasn't great. So there's always this question as to whether these subjective views are representative and how representative they are. And with the arbitrator reports that come out of products such as arbitrator intelligence, there is some question as to the source of the underlying material, because as I understand it, parties are invited to submit arbitrator intelligence questionnaires where they fill out basically like a feedback form on their feedback on the arbitrator arising out of their interaction with the arbitrator during a case. But these questionnaires are not available to the purchasers of the reports. So you're slightly blind as to the source of the opinions that you are then relying upon. So I think that can be problematic. It's also not clear as to how many questionnaires were submitted in relation to a particular arbitrator. So you may just be relying on the views of one person.
Do you think it is a matter of ethics, or it involves a matter of ethics in, I don't know, managing those tools and managing those criteria? Maybe if anyone would like to.
I think one must exercise a lot of caution when using these tools, just because, as we mentioned, we don't know where the feedback is coming from. I know my favorite arbitrators are the ones that, voted in my favor or my client's favor. Exactly. What I'm saying is, you might not necessarily be reflecting, if you get feedback that's negative, it might be from a party who lost and a party who should have lost, frankly. So I think you have to be a little bit careful about where that feedback is coming from. Personally, I haven't used a lot of those tools. I usually do the old-fashioned send out a firm-wide email about, who has experience with this person. Usually, given the size of my firm, there's quite a few people who will have had experiences, and then we pick up the phone and we talk through it, and we talk through different procedural issues, or, how was this individual on managing the procedures? How were they on timeliness? How was their availability? How are they on responsiveness? How into the details were they on this particular aspect of the industry or quantum, et cetera? Really what you're interested in, because also the same arbitrator might not be the right person for all of your cases. So I think you must be going into this with an idea of what you want for this dispute. I personally have a lot of respect for arbitrators who are progressive, who are procedurally very efficient. But I know if, you're representing a respondent who wants this to take forever, maybe that's not who you want as a chair. And I'm just saying that because I think we assume that there's one characteristic that everybody wants, and I think that's not true. I think it depends on your client and the issues that your client has before it. That's why I think the old blind arbitrator and just choose on the basis of not knowing who the arbitrator is, I don't think that would ever work, because my clients personally want to know who I'm appointing and why am I appointing them for this particular case.
And do you think it is cheaper, it will save costs, to use these traditional methods?
I think there's
at least at this moment in time, I mean.
I think there's a huge amount, I think there's a big distinction between commercial arbitrations and investor-state disputes just because of the volume of information available. So the instinctive approach that Nick mentioned, I think, is usually used in the commercial context. On the other hand, if I am going to appoint someone in an investor-state case, both because of the expense of that case, and it's likely that my client, this is a big case for them, it's a bet the company case, I need to make sure that I've done my due diligence and really looked through those awards. And the last thing I would want to have is my client come up to me and say, well, this person actually, decided this particular issue this way in this case, and I hadn't caught that. So I think when you're appointing an investor-state tribunal, it's going to cost more money. I think you need to do that due diligence to service your client. And I don't know if I would rely, I mean, I've not used those reports, so I don't have a real view as to their, how comprehensive they are and if they'd pick everything up, but I would want to know from, the associate who's doing this, what have they gone through, what sources have we looked at, what cases have we looked at, and really made sure we've covered the basis so that I can feel confident. And usually there's a memo in cases of investor-state arbitrations that go through different decisions, how we think the arbitrator might approach different procedural issues, and feedback as well from people that have had experience with that particular arbitrator.
Nevertheless, that involves a lot of data analysis. So here it may be that, I don't know, an artificial intelligence tool or simply an algorithm, not something self-evolving, but simple algorithm, may be useful. What do you say?
I mean, we tend to do exactly the same thing as Sarah's just described, especially in our investor-state cases, but to some degree in our commercial cases as well. And on top of that, once we've narrowed down a shortlist, we've gone through all of the awards on the key issues in the case ahead of us, then we would consider whether we would want to interview those arbitrators as well. Because whilst I benefit, like Sarah does, from an extensive internal network across the firm, there's still something to be said for having sat down with the arbitrator within the bounds of the ethical limitations, of course, but to interact with that arbitrator at that time. Sometimes your colleagues' recollections are historic, sometimes they're quite nuanced. So in a big important case, whether it's on the investor side or the state side, we tend to go that extra mile. So we've not used those tools. One of the audience picked up on the end of the last session a question about accessibility and essentially making sure that we don't find that technology means that the playing field becomes unfortunately lacking in sort of equal levels. And I think these arbitrator intelligence type tools can work both ways. If you don't have an extensive internal network that you can rely on, it could be a useful way to get started on your arbitrator due diligence and to get additional intelligence that you wouldn't be able to otherwise get. I don't think even in those cases it would be the be-all and end-all, but again, they are now monetization of data, and that monetization brings a barrier to some clients and to some firms in terms of their access as well.
I might just add, not only internal referrals from firms, but also I think we have a very special community, the arbitration community, who is very open to sharing views and data with each other. So sometimes I might look at a particular case that the arbitrator in question was on, and I might call counsel from those cases and just, walk me through what their experiences were and what were they impressed with, what were they not impressed with. And so I think that's, as long as it's on a no-names basis and a oral discussion as opposed to anything in writing. I think most people are quite happy to discuss their experiences with different professionals.
And so let me just add to that. I think these tools are all helpful, and we use them, maybe not all of them, but a number of them. But I would caution against over-reliance on them, because there is a human element to international arbitration that will always be there, I think. And that is something that cannot be replaced with a technological tool like this. And what you want as an advocate is to be in front of somebody who you know will hear your argument, will be receptive to it, will be paying attention to you. And for that, you need to have this, human connection, or whatever we would call it. And that's not something that you can identify through an AI tool like that. So I think, maybe the traditional word of mouth and experiences that we've had in the past, and that colleagues have had, and that others in the arbitration community have had, that is actually still a very important part of it. And maybe until the day comes that we will be replaced by chatbots who will be arguing with one another, this will be still a key element of appointing the right person.
Thank you. So with 3-1, we are in the phase of not using intelligence, artificial intelligence in selecting arbitration yet, but yet we are not far advanced in this discussion. Would you use artificial intelligence for something different, or document management, or I don't know, in investment state arbitration, and how?
Okay, so let me take this one. And I was not here for the discussion earlier, so apologies if I'm repeating some of the points that were made previously. But just to summarize what these tools are, I will focus specifically on large language models, such as ChatGPT. And these are basically algorithms that use a lot of data, large volumes of data, to analyze context and to come up with new content. And one crucial thing about them is that they learn in the process, and the algorithm itself is adapted as it works through the data. And I think we all are familiar with ChatGPT, so I will say a couple of things about that, but let me preface that by saying that investment treaty arbitration, I think, is a really fertile ground for artificial intelligence and large language models specifically. And that's because there are hundreds, if not thousands, of awards publicly available, procedural orders, pleadings that lay out parties' arguments in investment treaty cases, and a lot of scholarship that is publicly available, and it is not, you can basically access it for free. So all of that can be pulled into a model like this, and in fact, it has been in the case of ChatGPT. And so the purposes for which this can be used are really wide-ranging. It can be anything from drafting procedural orders, perhaps portions of awards, legal research, pleadings, preparing for oral argument. Basically anything that you can think of that is part of an investment arbitration case can be to some extent run through a model or a tool like this, and it might help. So, and just to give an example, you all probably have given it a try with ChatGPT, but if you haven't, you might ask it to do something like write a 20-paragraph analysis of whether actual expectations are a necessary element of making your case for a breach of legitimate expectations under the fair and equitable treatment obligation under an investment treaty. And you will see that it will give you a fairly good result with fairly accurate citations. In my case, it has not made up any cases. And it's something that is close enough to what one would get from a first-year associate or maybe a junior associate. I think the important implication here is that it can really jumpstart research. It can really give you ideas. It can identify cases that are relevant way, way more quickly than a human would. And so that has implications for us as advocates that are really far-reaching. including ethical obligations. So, for example, under the ABA rules, the American Bar Rule, American Bar Association rules, as counsel, you must provide competent representation to counsel. That's not surprising, but specifically according to the commentary to the ABA rules, you must stay abreast of the risks and benefits associated with technology. So if you are a US admitted lawyer, you must know about GPT, ChatGPT, and AI tools like that. You are required to know what the risks and benefits are. And that might mean maybe that we are reaching a point where we will be ethically obliged to use them because they can save our clients a lot of money. It also means that we need to be aware of the limitations. So as we know, ChatGPT is not designed to be accurate. It's basically simulating what a human might do, but not in a way that has safeguards built into it so that the information that you are getting is actually correct. So whatever a tool like this generates, as an attorney, one needs to verify that it is it is accurate. Another consideration might be confidentiality of client data. If you feed client confidential tools to an AI online tool like this, you might have a problem. And that's because you are disclosing it at a minimum to the employees within whoever it is who is running a tool like that. Also, there has been a leak of the headlines of searches from ChatGPT, and so some users got to see what other users were searching for. So if you run a search for using client confidential information, you might be breaching your obligations of confidentiality towards the client. And finally, I think in the context of international arbitration, we might have interesting issues if there are conflicts of ethics rules, let's say, in terms of how AI is handled in different countries. We might have a situation where counsel in different locations are subjected to different rules, and that has an impact on what they can do with respect to AI and how they use it in a particular case. So I will stop there. Maybe also another point, the point was made that some of these tools are very expensive. And I think this will be the case also for AI as it develops into like a more commercially based solution. ChatGPT is free. You can subscribe to a better version for a small fee, but I'm sure there will be tools that will emerge soon that will be tailored to arbitration, investment treaty arbitration. Those are not going to be cheap. So I think we might have an accessibility issue there, whether there is a level playing field among states and maybe claimants. We can envision a situation perhaps where there will be a state that is not doing so well economically. Will they be willing to invest in something like this? Same thing for claimants who sometimes are on the brink of bankruptcy and might not be able to afford to pay for something like this. So is this creating potentially due process issues in international arbitration with respect to accessibility to this powerful tool? And maybe just quickly on another topic for arbitrators. I think we will need to face questions pretty soon whether arbitrators are allowed to use large language models and under what conditions. So, for example, is this something that is already permitted, or is it not permitted under the rules that we currently have? Is there a duty for the tribunal to disclose that it is using a tool like this to the parties? Does the tribunal need to obtain consent by the parties for the use of AI tools? And is this akin to having a tribunal assistant or secretary? That's something that we are all familiar with. The rules require, or the standard procedure is to get party consent. So is this something like that, where the parties will need to give consent for the tribunal to use a particular AI tool in the case? And is there maybe the need to regulate this in the code of conduct that we have for arbitrators to deal with it expressly? Same thing, by the way, for arbitral institutions. I think we will reach a point soon where this will need to be addressed one way or the other. Maybe this is an area where arbitral institutions might cooperate together to come up with a solution that will be applied universally, so that we don't have different regimes under different arbitration rules and before different arbitral institutions.
Thank you so much, Peter. Do you think that it would be the use of artificial intelligence, and that's open for all the speakers, the use of artificial intelligence would lead to the disappearance of certain actors in the field of arbitration, international arbitration and or investment arbitration? For example, recently in Paris it was discussed what would be the first actor that would disappear, and everybody said that the secretary of the arbitral tribunals would disappear because it is very easy to use these tools, including in hearings, and I will turn to you thereafter for this, for aiding the arbitral tribunals to have a percourse of the arbitration and prepare the procedural history. And we learned a lot yesterday about how praised the secretaries in the ICSID are for doing this procedural history of the case. They are the best, actually, from what we learn. So what do you think? How do you see this happening in the next 10, 15 to 20 years?
I don't really see it replacing tribunal secretaries. I think they're a lot more substantive, actually, than just a chat GPT. I mean, they really, at least in most of the hearings I've been in where there's a tribunal secretary, they're an integral part of controlling the proceedings, timing the proceedings, updating the parties, facilitating whatever goes wrong, whether that be the vegetarian plate hasn't arrived to the vegetarian client or whatever. They pretty much are all on hands on deck to do whatever needs to be done. I do agree, though. I think probably chat GPT and some of the AI will kind of facilitate just in the same way that tribunal secretaries did in the past. There used to be a huge amount of controversy about having tribunal secretaries, but I think if you're clear with the parties of the scope of what you will be using this for, and that's clear from the procedural order number 1. I mean, a lot of institutional rules already require the tribunal to input the role of the tribunal, who the tribunal will be, and what the duties will be. And so I think similarly, if there were to be use of ChatGPT, I think that should be disclosed to the parties. They should consent to that. And it should only be used if the parties actually do in fact consent to it, and then there's parameters around that. I suspect that the institutions or technology companies or CIR will put together something soon, because all of these issues we've been talking about, there are really good guidelines from various institutions on how to proceed and how to make sure that the procedural order number 1 addresses these key issues for clients.
Thank you so much. If you would like to add something. Yes, please, Nick.
Just to be slightly controversial, I sort of query whether there is really that much difference between using ChatGPT and using other electronic databases like case research tools, LexisNexis, IS, Investor State Law Guide. I mean, how different is that? I mean, you're using an electronic tool to produce, some basic research, which then needs to be checked against the hard law. I mean, so we don't require tribunals to disclose that they're using LexisNexis in their research. So that's
I think.
But isn't that the LexisNexis and other databases have, let's say, traceability of the information?
For me, it would be more about the writing of the award. Yeah. How I want to know that the arbitrator considered the case, considered the facts, the witnesses, etc., and that there was a decision, a meeting of the minds amongst the tribunal, and then that was what was concluded. I think it's about not delegating that important role of decision making to something else. That, although I will say there are now, I think, already on the market technologies that you can use to decide smaller value disputes. Mm-hmm. So if they're run-of-the-mill contract claims, you can kind of put all that data in, and you're likely to get a percentage of your likelihood of success, which then will hopefully facilitate companies to just settle those cases or not, as the case may be. So some of this, again, these are for simple cases. I don't think this is going to take the place. I don't think our arbitrators are in jeopardy of losing their positions on ISDS tribunals.
I think clients, investors, or states are still seeing this as a very human process.
Yes.
And I find it difficult to see if you said to a client, is it okay if the tribunal, do a sense check on their thinking through use of ChatGPT? I don't see many clients being comfortable, certainly not now, but possibly not in the future, with that idea. That's not what they're paying for. That's why you've done the diligence that you put together to appoint that arbitrator to constitute that tribunal. I see it being very different from use of ISLG or use of LexisNexis, which will give you information responsive to a search, but it doesn't tell you the answer. It just says, well, here's all the things we think are relevant, but it doesn't do that extra step. So I think even if you went to a client now and say, can we use ChatGPT to start our research? I think a lot of clients would raise their eyebrows at that, on whether they're investors or states, because they're paying for your legal expertise and to consider those issues in the context of that tribunal with the nuances of that dispute. So I think we're a while away from just general comfort levels with use of that technology when it comes to issues so significant as investor-state disputes.
Yeah, I think the main difference is that what these language models can do already, including ChatGPT, is that it basically simulates what goes to the heart of the decision-making process, and that's the deliberation, and taking the amount of argument and facts that go into these cases, and coming up with a solution with a reasoned award. And what you can get from these tools already at this point, at least as it relates to the legal issues, is something that pretty well simulates what an arbitrator might produce. So you wouldn't necessarily know as a party whether a certain chunk of the award was written by ChatGPT because the arbitrator put it in, and it spit out something that they kind of agreed with, so they put it into the award, which hopefully nobody does, but it could happen, and we would not be able to maybe distinguish that from something that the arbitrator would produce after deliberation and their own thinking. So maybe there's nothing wrong with that. I think we can have a debate about that, whether ultimately these tools will advance to a point where they actually will be able to replace what I think we all consider as the heart of this process, which is like a deliberation and reasoned process that the arbitrators go through to get to a result.
And here it was a very interesting question addressed to the earlier panel, whether that would be indeed appropriate to have those tools in place to take a decision, and would it be at the same time seen as justice, would be justice and perceived as justice? Those are three questions, very important, and I would like to know what your views are in this respect.
At this stage, I can't see any of my clients agreeing to this. However, I think the fundamental of arbitration comes down to party consent. So if perhaps there are more technology-driven clients who feel that that is a reasonable way to resolve their disputes, I mean, they can agree to do that. But I think it has to be transparent, and it has to be agreed by the parties to meet their needs.
But are there any other, I don't know, areas where you would use technology, and how would you implement it? What are the risks? What are the benefits? Would you use it?
Which
I don't know, other tools. ChatGPT, we took a lot of, we discussed a lot about ChatGPT, but there are other technologies that can be put in place in order to aid arbitral tribunals and stakeholders in the investment state arbitration to reduce costs, or are they?
I think probably the thing that is most, and Martina also mentioned this, I think there's a few gifts the COVID pandemic gave us all, and one was more time with our families and an opportunity to reevaluate our priorities and how we should live our lives. But another one was actually using technology to our advantage in a way that really does reduce time and cost. I remember being a first-year associate and flying to The Hague for a one-day procedural order from parties from around the world, from Asia, from the US. We would never do that anymore. There's no reason to do that. No one believes that that's consistent with the expectations of our client. It's not consistent with the pledge for green arbitration. And I think we've found that at least for procedural issues, CMCs, initial case management conferences, and also hearings that deal with legal issues and we don't have fact and expert witnesses, I think online hearings have worked wonderfully. I think we've also stopped using paper, which has been a welcome event. I remember as a baby lawyer seeing the room full of binders and binders and how much money we spent on that and trees we killed for that. And so I think these technologies are widely accepted now. There's no question about them. Sometimes it becomes initially there was a real, I don't remember if everybody remembers, but there was a huge concern about due process violations if you didn't see the person, live in the hearing room. And I think we've all overcome that. And we've thought, I think if you've got a large merits hearing, especially if it's important for the parties, and I think when you have states involved in the cases, sometimes those states want to be there and they want to have their day in court before the tribunal. You're still seeing that for merits hearings. But for example, if there's one witness or two witnesses that can't come in, it's not a big deal. And there's just always a hybrid, protocol. And now we also have so many wonderful guidelines by all of the organizations on how to manage if there are technical. First of all, we have wonderful technology like Opus 2 for parties who don't want to pay for that. We have Zoom I've used, Teams I've used. There's a wide variety of platforms, and then there's also ways to deal with any glitches that come up, and how will that time be allocated, and how will that work. So I think we've done a pretty good job of making remote a lot more productive, and I think it's been a real great advance for the practice and a reduction of costs and time.
But I cannot wonder whether there are some, challenges in terms of using digital evidences and administering those evidences in this type of hearings. Not only digital evidences, but administering evidences in this type of hearings.
Yeah, I think there's two elements to that in terms of the kind of growth in digital evidence, and not only obviously the kind of impact of use of email, but also WhatsApp, video recordings, audio recordings, Teams messages, blogs, increasingly social media, but also archive files, temporary files, residual data, metadata. I think we've come a long way in terms of how both counsel and tribunals are looking at these issues. We've got increasing technology that can reduce costs in terms of just, I suppose, deduplicating large amounts of data, which is helpful. We still need a human element, I think, when you're sort of using technology to assist you to narrow a massive universe down. There's a lot, there's still a lot of disputes around that in terms of keyword searching. And actually, there's a really big, in my experience, there's quite a big human element to keyword searching, because you have to know the colloquialisms being used by the people that created the data in the first place. That's a learning curve that doesn't necessarily always work. If you just essentially leave it to the technology, you need to understand how people communicated with each other to come up with your keywords. It's quite an iterative process, because quite often what feels like a really key word can be used for double purposes, and suddenly your universe doesn't really narrow, but a lot of what you've got back is still not actually relevant to the points in dispute. So again, it's a learning curve for lawyers, I think, in terms of how to use those tools effectively to really reduce time and costs. And it isn't something you can just sort of hand over and just say, well, here's our list of 10 keywords, now generate the responsive documents to these 10 document requests. I think we could be better as counsel and tribunals in bringing these kind of issues to the fore. So when we're talking about document production, we don't leave that kind of keyword searching element to being disputed further down the line. And we can bring to the fore as well issues with the format of production of data. When we've got a lot of electronic information coming over, it's important to whether it's in native format or not. And that causes issues which could be nipped in the bud if we are a bit more forward thinking about these things. So there's a lot to be said. Obviously, digital evidence and how it's used in international arbitration, and in particular investor-state arbitration, I think is changing. Communication methods are changing. There's issues like ephemeral communication that are now being brought into arbitration, commercial arbitration, investor-state arbitration. I think we all think of ephemeral communication as being Snapchat and it's for our 15-year-old daughter to use. But actually there's ephemeral communication tools that are being marketed at government agencies like WICA. So I think that's going to be challenges for the future. Also, when we think about the kind of evidence that's being put before tribunals, particularly in expropriation cases nowadays, I think investors are getting more creative with the way they are looking at the evidence they will need to show causation and damage. So if we take some of the investors that are looking at what's happening to their assets in Ukraine, they're looking at satellite communications, they're looking at monitoring Ukrainian, Russian social media to see what people are putting out there. They're looking at the metadata in photos that they can get from complete strangers who put it on their Facebook account. And the tribunals are going to have to grapple with admissibility issues, authenticity issues, and what weight do you give this kind of evidence when actually the investor says, well, I've lost control of my asset and access to all my personnel and documents. This is what I have. So I think there's a lot of challenges in the future, and it's not only investment treaty tribunals that are having to deal with those kind of challenges. Obviously, the ICC is looking at this kind of evidence now. The European Court of Human Rights is looking at this kind of evidence, both in the Ukrainian context and more broadly. So I think that the issues for the future in terms of digital evidence are going to go way beyond kind of like, well, what does this email say? Is it produced to me in native form? Can I look at the metadata? Can I check that the attachments were really attachments at the time? Which is an issue that came up in one of the cases years ago, in the Lipanenko case. So I think tribunals are going to spend more time, not less, looking at these kind of issues. And we've already seen investment treaty tribunals listening at forensic evidence that deals with the authenticity of audio recordings, for example. And I think we can just anticipate more of that. And that comes back as well to the sophistication of tribunals to pick up on these issues and the sophistication of counsel to work out how they can use this evidence and the burdens that are going to be on them in terms of establishing why they should be used.
Thank you so much. In this complex process of analyzing all the data and information provided by the parties, establishing authenticity and relevance, do you think that there is something that can streamline the process and reduce time? Because, as you mentioned, it is a lot of work by the arbitrators to reduce time and to streamline the process in order to reduce costs. Nick?
So one of the things I wanted to pick up on was really the timing issue, and how the timing of document production may actually assist in reducing the overall cost and time of an arbitral proceeding. I think that we're used to having document production, as a separate stage that happens, basically after the close of pleadings. And I think if you look at other types of litigation, for example, competition litigation in the UK, document production is much earlier. And so parties are required, even as early as the first case management conference, to actually be on top of the document issues. So in competition litigation, often at the first case management conference, parties will be required to file a document production report where they will be required to have gone through all of their documents, understand their universe of documents, understand what they have. There'll be discussion around the key search terms that will be needed to undertake the document review. So I think we may need to learn from other disciplines and other fields of litigation to move from this kind of very separate document production phase to actually dealing with document production earlier, so that tribunals can narrow the issues, they can identify where there's missing evidence much earlier in the process, and that may have the effect of reducing the overall time and cost of the proceedings. So it's not a technological innovation. It's a procedural innovation.
I see. So that involves all actors involved in the arbitration to do something in order to reach to that result. It was a lot of discussion yesterday about using or not the document production and the efficiency of document production phase altogether, not only the cost but the delay in time. But do you think that there are other instruments that parties, the council, the tribunals have to reduce those timelines and the costs?
I guess this is not so much technology, but I think,
Exactly.
Picking a good chair who's not afraid to exercise authority and say enough is enough when parties are getting out of control. Picking a proactive chair who's going to call a CMC if the pleading, correspondence is getting out of control back and forth, and saying, hey, let's. I often do that if I'm in a commercial case and I can see the parties are just starting to escalate amongst each other. Just getting on the phone and having a quick CMC and going through the issues, because a lot of times, I think part of the problem with document production is you'll have usually very young junior lawyers are in charge of drafting those Redfern schedules, and their thought is, I don't want to miss anything or I'll get in trouble. And so if you actually have a case management conference where you have to go in and the senior partner has to look at what they actually need, you'll find that Redfern schedule is suddenly shortened to a great degree. So I think there's some interesting procedural tools that an arbitral tribunal can use to manage that. I'm also a big fan of interim cost awards. If a party is acting with guerrilla tactics, I think that's an appropriate time to either threaten them with a cost award, an interim cost award, or to issue one. The other thing I think is important is to have, I personally like to have client representatives at the first case management conference. I find that sometimes you get different responses from the lawyers. If their client is sitting next to them, all of a sudden their availability is much better and they can speed the pleading as long because they actually have the client next to them to account to. So getting the client involved early, getting a strong PO that sets the expectations for the case, getting agreement amongst the party on that. And then you can always, as an arbitrator, go back to that PO and say, look, we agreed to this. There's obviously some room for flexibility, but not throwing away the hearing and, delaying this too much. I also personally am my view is that closing oral arguments are often not super helpful. I think they can be done more appropriately in a post-hearing brief that is targeted by the tribunal. So I'd like to hear from the tribunal, what specific questions do they have after having heard all the evidence, and then give us a page limit to provide those questions and answers to them. I find that the closing is always I feel bad for the associates who are on that task of every day looking through all the transcripts and putting together this, that, and the other, in the effort to have this amazing PowerPoint on the last day, not sleeping several days. And I just don't find it that helpful. I think it's better to have the tribunal deliberate, and then once they've talked, come back to us with targeted questions that we then have a certain number of pages. And I don't think tribunals should be shy about that, about saying, I actually do not want a 500-page brief. That's not helpful. I find use of decision-making trees, like this is let's distill what is actually at stake, because there's always, especially in investor state cases, there always become these allegations that are unsubstantiated that actually don't have anything to do with the heart of the dispute. So really tailoring it down and saying, these are the issues. Make it as simple as possible, and then getting clarity on those points, I think, is very helpful. But again, that's the skill of an arbitrator, not really technology.
Let me follow up on two of those points. The 2021 Queen Mary survey of international arbitration, which is focused on commercial arbitration, but maybe has some relevance to investment treaty as well. So it asked questions, and those were directed to in-house counsel as well as arbitrators. So it asked questions about the procedural measures that in-house counsel, so clients and arbitrators, would be willing to forego in order to save costs. And the number one thing was unlimited written submissions. So page limits is something that both arbitrators and clients seem to think they would want. Maybe that's before they get to an actual case, but that's a generally expressed preference that they have. The second one was omitting oral hearings on procedural issues, which we also discussed. And the third one was limiting document production. So all of these three things came through the survey. Maybe just a point to that, I think this is something that really is case by case. And we always need to seek to strike the right balance between how much the case costs and putting forward the best possible case for the client, because at the end of the day, the counsel costs are not really the cost of the case. The cost of the case is whether you win or lose and how much. So although we, of course, focus on the cost of counsel and how much these proceedings cost, that's not really, I think, the thing that matters at the end of the day. So there may be cases where the costs are very high because there are many complicating factors, and it's just like a really, really complex matter that involves a large investment over decades and dozens of issues. And that will be an expensive case, but maybe that's not necessarily a bad thing. That's not a minus. And maybe the same way if a case is done like relatively cost effectively, that necessarily is not a good thing, conversely.
Touch here a bit at the topic of the counsel costs. Because yes, we've seen the $89 million in the UCOS case and the $27 million in counsel fees in the Lebanenko versus Turkey, but that actually may raise issues in relation to the possibility of the host state, the respondent in arbitration, to cover those costs. And is it something that can be done for both claimants and or respondents in order to ensure that these costs are kept under, I don't know, certain thresholds? Yesterday it was suggested that certain limits on counsel costs be established by the arbitral institutions. Is it something that can be done in, I don't know, investment state arbitration?
I think it's a difficult point in investor state arbitration, because what states want in theory can be quite often very different to what states want in practice when they're on the receiving end of a claim. And I think picking up on one of the points that Sarah made about kind of honing down for the tribunal, honing down the issues, I think that's really helpful. And I think page-limited post-hearing briefs is a really important point. Also, being sensible, you get your first post-hearing brief, you get a decent amount of pages to put forward your case, but your reply, pinning your reply down, and then it's up to counsel whether they want to try and just condense their case and not use it as a proper reply, or whether they want to use that 50 pages that say as a proper reply going through. But also when you're working for states, there are points where whether or not the investor has argued that that point would be determinative, let's say proving corruption, the state can't let that point go. It doesn't, it might not be something that the tribunal has picked up on and said they're interested in. There are certain points that states will need you to say something on because they are just bigger than the dispute itself. Yeah. So those points can't come in at the post-hearing stage in particular, and states are particularly keen to make sure, and it's individuals who have their head on the block in that sense, who are particularly keen that you're chasing down everything, in particular those high points like that. They can't have those findings. They can't have unhelpful things.
Because of the cost that we are not talking about today, which is the reputational cost.
Exactly. So, and I think when you come to investor-state disputes, because they are often so public, because they are often political, because they have the reputation of governments and individuals hanging on them, that's why there's that dichotomy between we want cheaper, quicker investor-state arbitration. We don't want costs to run out of control, and we're facing a big claim. It can, what essentially is being claimed is, a massive percentage of our GPD, and there's a massive reputational impact. States want to spend the money at that point. It doesn't mean that counsel should take liberties with their costs. Costs should be reasonable. You should be working with your client. If the client wants to chase down a point where they just think it's an important legal point and you don't agree, then obviously you have to have robust discussions. But I think you do have to appreciate that, particularly in the latter stages, there's that concern to make sure that you've done everything possible as a state to defend the claim. Similarly, investors, they're not going to sort of at the last minute are going to actually kind of start holding back, I think.
Would you be concerned if, I don't know, the opposing party would work only based on a contingency fee that you would learn about at the end of an investment state arbitration? Would you consider that to be, because we had the discussion yesterday, would you consider that to be a funding? Yeah. Would you require, I don't know, early disclosure, and how early? I
think it's a really interesting point, because we're certainly seeing contingency fees becoming more prevalent in investor-state arbitration, usually on the claimant side, but you can put together some kind of fee arrangement with a respondent as well. And I think one of the reasons for this is the increasing ability of firms to put in place structures behind their contingency fee that allow them to hedge some of their risk, and whether that's working with a funder or whether that's working with an insurer. I know that that's possible as well, to essentially hedge off some of your risk. And it raises really interesting questions about transparency. We've had a case where the law firm is prepared to say this case is not being third-party funded. It's fully contingent, and it's contingent on a fees and costs basis. So the investor has no skin in the game whatsoever at this point, which I think raises ethical issues. And certainly when we reflect on the nature of the pleadings, you do wonder whether the case is being put in such a way because the law firm has everything tied up in 4 years of work, and whether that encourages them to push their own boundaries of how they would deal with the evidence. And we find it misrepresentative. That brings its own costs if you're on the other side of that kind of advocacy, let's put it, because there's a big forensic exercise that you then have to go for. Your costs increase because you're having to get under literally every misrepresentation or misstatement of the evidence, and you use your 50 pages to respond to it. So I find it an interesting prospect that third-party funding becomes a focus of the rules, whereas these kind of arrangements can sit behind contingency fees, which, because they don't immediately throw up the conflicts issues that perhaps third-party funding does. There's an interesting question about whether they would fit, for example, within Rule 14, or whether actually a firm would take a decision that actually it's not a funded case, even though there's a prepaid forward contract in the background sitting there that's helping facilitate that contingency fee some way.
So can I just add, with respect to the amended exit rules, if we look at the wording that's in there, I think it covers contingency funding, just the way it's phrased, and there might be something in the working papers also to suggest that. So at least in the exit context, I think a respondent would have ground to at least make the argument that contingency funding is considered as third-party funding that needs to be disclosed. But I think the underlying question this raises is why do we require disclosure? So one obvious thing is conflicts, and there, maybe there's less of a concern if it is a law firm, but there also might be other incentives that come into play when and as Hannah said, the investor does not have skin in the game, and that again would weigh in favor of considering third-party funding to include contingency arrangements. I think we can expect to see more and more jurisprudence on that point as the new exit rules are applied by tribunals.
Thank you so much. I think that we exhausted only half of what we had to discuss, but the time we are behind the schedule with almost 20 minutes now. And I would like to thank all our speakers for their contributions and ask if there are questions on the short questions from the... Yes, please, Professor Bergman.
This is a very quick comment and then a question. On the question of post-hearing briefs and closing arguments, I think it'll be good news to you, Sarah, that I think arbitrators are finding that post-hearing briefs are far more useful to them than glossy PowerPoint and the rhetoric of which closing arguments consist. It's just well known that well-drafted post-hearing briefs with their references to the record facilitate the work of the tribunal considerably. I mean, you have before you not only what the parties thought was most significant, but you have before you what it is they relied upon specifically. So I'm seeing a trend in that direction, and I certainly advocate it. But my question when Serena asked who's disappearing from this scene, for some reason, my thoughts turned to legal experts. And I have no idea why, but it did. And so I was sitting here thinking about that. Now, I came away pretty optimistic. So I want to tell you what I was thinking, and you can tell me that I shouldn't be so optimistic. But first of all, I like to think that the source of the legal opinion matters. So artificial intelligence, even if it could amass all kinds of data, please tell me I'm correct, that the genesis, the origin of this opinion matters, and that, the briefing counsel does could cover some of that territory, there'd be something lost. And then I immediately got to thinking, well, what if the legal expert engaged in this stuff, in this recourse to artificial intelligence? And then I came away thinking, I'm not worried about that either, because we know the risk of error. We've all heard about this exercise that came up with fictional cases. So what could be worse? What could be worse for a legal expert than to submit something that is so rife with error and vulnerable? So am I correct in my optimism that, legal experts are here to stay?
George, you're always correct. No, I think that's right. I mean, I think the role of a good legal expert is to assist the tribunal independently on the questions they have. And I think what's quite helpful is when the tribunal is able to engage with that legal expert, to ask questions on the spot, to either in a hot tubbing session or independently, any doubts that you might, I typically don't put forward international law legal experts. It's usually just the domestic law that might be relevant in the dispute. But I think the value of that is having the opportunity to have dialogue with the tribunal to assist them in answering their doubts so that they can form an opinion on the merits. And so I think you can't GPT chat that. I mean, that is a person giving their opinion. Yeah, exactly. And you'll be able to tell really quickly. And we've all seen very credible experts who have given very honest answers, and they don't overstate things, and they help the tribunal and assist the tribunal, as is their job. And then we see others who, always bat for the retaining party, and that I think that you lose credibility on that. So I think it's the dialogue with the tribunal and the experts. I think they're here to stay. I don't think there's any worry that they're going anywhere.
Just one very quick thing. One thing, you said you thought internal law or domestic law would be the subject. One of the things that I'm struck by is the willingness of arbitral tribunals to engage or to hear from experts on international arbitration law. And I mean, that's most of my experience. And you think, well, if there's anybody who doesn't need expert opinion on international arbitration law, it would be the tribunal.
Yes.
But it is striking to me how many times it's not domestic law, but it's international arbitration law that is the subject matter of this. And it's a little curious.
Is this in commercial cases?
Yeah, in commercial cases, yeah, primarily. Yeah. Well, thank you.
Thank you, Professor.
Thank you very much. I have a question to Sarah and also to Peter, and it's quite a sort of provocative one. I mean, Sarah, you said before, well, the important thing is, the meeting of the mind of the tribunal. It really has to be a decision that was made by humans. But what about the reasons, What about, when for example, the tribunal came to the reason and then asked ChatGPT, now you write the award based on that presumptions. Do you think there will be tools, or maybe they are already available, where that can be tracked, whether the award was then actually written based on ChatGPT or any other AI? And do you think that in the future we might have an additional annulment ground?
God, I hope not. Does anyone want to take the AI?
Okay, so I think just the technological side of that question, I think it cannot be tracked thus far. And ChatGPT and tools like that actually are very good at imitating the sort of language that you would find in an award and the sort of reasoning you would find in an award. So, you know, in your hypothetical, I think it is like technically quite possible that if we are not there already, we will be very soon, and those questions might come up. And again, I think we will need to deal with the question, is this okay? Is this permissible? Do we care about it as long as the tribunal and the arbitrator has made a considered decision? Do we care whether a robot writes the reasoning that goes with it? If the tribunal secretary does that, yes, we've seen something about that topic.
I also don't know if it's a separate process, because I find when I sit as arbitrator and I'm writing the award, I mean, I don't think, okay, I'm going to find A, B, C, D, go. Let me just say that out. I mean, as you're writing through certain things and you're looking at the evidence again, you look at the contracts again. I mean, often what I will start doing is writing sections, not coming to a conclusion, but writing sections of the award before the hearing, so that then when I know I'm going to have questions, well, how does that work? And how does that, I mean, I think that helps focus the mind to really flesh out the issue. And if you start kind of writing or at least outlining where you think you're going, it usually raises more questions. And I find the hearing is then a wonderful time to address those questions, because you can ask Mr. X or Ms. Y why this happened or what was meant by this. Or so I think, you know, it's hard for me to think about separating out the answer from the reasoning and the decision. And I think it evolves. It's like an iterative process that you know, the award becomes what it is because of the way you're thinking about it.
Thank you so much. If there are no other questions, I would like to thank you and invite you to thank all our speakers, and then stay for our last panel, Young Romanian Arbitration Practitioners, because they have a very interesting debate on the table. Thank you very much. And I would not... I will not go down from this scene without thanking. There are no enough words to thank Rina for all her support in our event. And thank you, all of you, for traveling to Romania and for being here with us at this event. And we are looking forward to see you next year at an in-person event and online. We will see, because we actually need to have human contact and not only technical means of communications in place. Thank you.
Thank you so much.
Good afternoon, everyone. Welcome to the last panel of this conference. This panel is moderated by the young Romanian arbitration practitioners, Mihaela Apostol on the far left of this table, and myself, Violeta Saranciuc. We are representing the initiative Young Romanian Arbitration Practitioners today. If you don't know about the Young Romanian Arbitration Practitioners yet, I invite you to visit our LinkedIn page so that you can see how many wonderful initiatives we've done so far. We are established since 2021, and I want to say hello to the two co-founders of the Young Romanian Arbitration Practitioners, Iuliana Iancu and Andreea Nica. Together with them, I have established this group in 2021 as the first Romanian under 40 group. Now, it is my pleasure to make the introductions today, and our guest panelists actually don't need introductions because they're superstars anyway. But for the protocol, we will do this procedure. So in alphabetical order, we have Nata Gibradze. Nata is originally from Georgia, but she is a lawyer at Hogan Lovells in Munich. Prior to that, among other things, she worked at the Ministry of Justice in Georgia. And unlike many of us, Nata has a plan B in case the arbitration world goes wrong, because Nata can go back to a different career, to a musical career in school. Nata was part of a musical band, so they would have gigs, fans, and all that kind of stuff that we, the arbitration practitioners, would adore. Next, in alphabetical order, Johannes Landbrecht. Johannes is originally from Germany, but he practices currently practices law in Switzerland at Val d'Arvis. Previously, he practiced law at various law firms in different jurisdictions. And the career Johannes has built so far is based on the principle never say never. And the curious fact that we know about Johannes is that when people ask him why he started law for, he said that that's for everything except that he would never become a practicing attorney. So that was a very bad prediction. And then when he eventually became a practicing attorney, he said that he would be doing this because he would definitely not want to become a judge. And that's a bad prediction number 2, because now he's sitting as arbitrator often, which is basically more or less very similar. Next in alphabetical order, Cristina Milinceanu. Cristina is in the in-house legal department of the famous, world-famous energy technology company Baker Hughes. And before joining Baker Hughes, she worked as counsel, arbitration practitioner in the Italian law firm Arbit. She is based in Milan, and contrary to what appears to be a common belief or a general belief, she's not Italian, she is Romanian. And the curious fact that Cristina allowed me to share is that she's one of the representatives of what seems to be a numerous group of arbitration practitioners who were born in Botoșani. This is a city in the north of Moldova and a very well-known touristic destination for any one of you who is interested. Next in our panel is, in alphabetical order, is Melanie Riofrio-Pichet. Melanie is an arbitrator practitioner and more specifically an arbitrator based in Madrid, Spain. She has her own private practice and she has exceed arbitrator appointments. So what else does an arbitrator practitioner need? I mean, we all envy you at this table. Before having her own practice, Melanie led an arbitral institution in Madrid, and before that, she was a lawyer in an arbitrator's boutique, also in Madrid, Spain. And the curious fact about Melanie is related to her linguistical competence. And it seems that besides the fact that she speaks English, Spanish, and French, as regards French, in addition to the French, she also speaks the Quebecois French, which is very important in case if you have a linguistically complex case to have in mind. Well, that the introductions being made, we will now move on to the topic of our panel, which is the next generation arbitrators. And in essence, the next generation arbitrators, we all know and we see and we feel that the next generation arbitrator is here in the room today. And it is a stakeholder in the future of the arbitration. And when I say, and when we decided to address this topic, we didn't refer necessarily to the new generation of arbitrators, but more broadly to the new model, to the new arbitrator model. So not necessarily to age considerations, but rather to how we do it or how we're going to do it in the future. That being said, an interesting discussion that we started from when preparing this panel was putting this or the next generation arbitrator in a context and seeing what other generations there have been so far. And there were some very interesting ideas shared by Melanie. And Melanie, if you'd like to share this also with our audience today, thank you.
Yes, good afternoon, everyone. Thank you so much for the invitation to the organizers of the Bucharest Arbitration Day and, of course, YRAP. So I wanted to start with the reference to Dealing in Virtue, which is a book that was written by Yves Desalés and Brian Garth in 1996, so that's almost 30 years ago. They spoke about different generations of arbitrators. So the first generation of arbitrators they called the grand old men. Basically, these arbitrators were men of a certain age who were not specialized in the field of arbitration, but were really renowned lawyers in their own jurisdiction. Then comes the second generation, which they call the technocrats. So this generation is have arbitrators that are more technical in the procedure, that have made different courses, different trainings in arbitration, and that have dedicated almost their entire careers to arbitration. And then comes another paper written by Thomas Schulz and Robert Kovacs 10 years later, in 2006. And they identified a third generation of arbitrators that they called the managers. So in this case, what is important for the managers is managing the procedure, managing the parties, managing the co-arbitrators sometimes, managing the proceeding. Now, in this last decade, we have seen a lot of different developments in arbitration, from the way we appoint arbitrators to how we manage proceedings to even the businesses model that arbitrators are adopting nowadays. So in the following discussion, this is only to open the discussion, in the following discussion, we want to see which were these developments in arbitration and try to see whether there is a rise of a fourth generation of arbitrators.
I'm just thinking if perhaps we could go a bit more in details about the next generation and look a bit of how do you see in the future these business models and how do you see in the future arbitrator conducting their business, if we can call it a business?
Yeah. So in my point of view, when we talk about how arbitrators will run their practice, I think there are three key elements that we have to take into account. The first one is the product, or in this case, the service that they're providing. The second one is the personal branding, or how they offer this service. And the third one, if we can call it like that, is the business model. So how they structure, or which structure they will use to offer their services. So regarding the first element that I mentioned, the services, I think there is a whole new generation of mutis, that those are the professionals that come from the moot competitions. There are a lot of moot competitions now. And you can see that this generation of mutis have very sharp skills that really is helpful when you are acting as an arbitrator. So besides the strong knowledge of the law, there are some skills that I think are maybe interesting, and I'm just going to mention some of those skills. So first of all, a sharp business sense. So those arbitrators understand the business and how the business works. Second, persuasiveness, because one thing is to have good arguments, and another completely different thing is to convey persuasively those arguments. And I think this new generation is really good at persuading the arbitrators. And of course, being an arbitrator, you also have to be persuasive when you're writing an award. A third element will be the accounting and finance skills. Those are really important. If you look back 15 years ago, 10 years ago, if you look at the awards, you probably see that most of the awards in the quantum section dedicates 1 page or 2. And nowadays, you can see like really deep analysis on quantum. So it's definitely one of the skills that we see in this new generation is the accounting and finances skills. And finally, a last skills would be the digital skills. The last panel talked a lot about it, but we're going to address some of these elements about digital skills, which I think it's important to take into account for this new generation. Now, regarding the second element, which is the personal branding, very quickly, 10 years ago, again, for the visibility that we need as arbitrators, we would go to conferences and only the audience would be able to see us. Whereas today, you do have a lot of virtual conferences, so you have access to thousands and thousands of people, and without mentioning all the social media that you can use to give visibility to your profile. So I think that visibility has helped to develop the pool of arbitrators that we have, and it's definitely something that we should take into account for this new generation of arbitrators. And finally, a third point is the business model. And I think there's a trend here that's worth mentioning. In 1995, Thomas Clé, a French professor, said, and I quote, "Arbitration is not a profession, it's a mission, a temporary function." And of course, those who acted as arbitrator in those days had other jobs that provided them with steady income and social status. In my experience, and I'm going to share, I think it's important to share this experience, which is a little bit different. And I worked for an arbitrator for 10 years, and this arbitrator in Madrid specialized exclusively in arbitration. He has his own boutique of arbitration. He did only arbitration. He did only arbitration acting as an arbitrator, not as a counsel. He did only international arbitration, and on top of that, most of his cases were as president. This arbitrator was Juan Fernandez Armesto. So already 15 years ago, you already had at least one person that acted exclusively as arbitrator. And I think there is a trend growing more and more, because if you look at the Global Arbitration Review, you probably see, like 2 times per week that a solo practitioner is launching his or her own practice. So I'm going to leave it there because Nata is going to explain a little bit more about this business model that we're looking at.
I don't know if I'm supposed to actually get a question or just jump in. Hi, everyone. Mihaela, I think I'm not necessarily talking about the business model, but the reasoning behind this, right?
Yes, and maybe you could give us a bit of details if being an arbitrator in an independent practice is a better choice than being an arbitrator in a law firm. Well, it's a tough one, right?
It's a tough one. But
and of course, what are the considerations of it, if it's for business considerations or perhaps, I don't know, ethical considerations, avoiding conflict of interest.
Thank you. Yeah, as you said yourself, it's a tough question, but hi everyone, first of all, and to the organizers, of course, thank you, and to all the attendees who have stayed and not left our panel and are here still listening to us. I cannot really answer the question whether it is good to be a sole practitioner. That is something, obviously, that Melanie has experience with. I can talk about the considerations, why I understand, based on the conversations with people, and from my own experience working in a big international law firm, how does it work to be an arbitrator? Melanie is an example, for example, here, that being an arbitrator has actually become a career path that wasn't available there a long time ago. You mentioned the person you worked with 15 years ago did this, but not a lot of people did. And as you mentioned, on a daily basis, we see updates on GAR that people are going solo. I think ethical and business considerations are the two, and the third, in my view, would be the personal consideration. So let me just very quickly go through those. This is not groundbreaking what I'm saying about ethics, that if you work in a big law firm, and especially in an international law firm, the number one reason why you're not able to accept arbitrator appointments and why you might want to leave the practice in an international law firm and go solo is the conflicts of interest. Very often you get an appointment, either you already have conflict because the conflict check has come up that someone in some office has worked for one of the clients, especially in the commercial arbitration setting, where we get a lot of commercial arbitration cases are, of course, much more than investment arbitration cases, right? The second option is that some partner in whatever office in an international firm has interest in getting one of the parties that you got a request from to have a client in the future. So you already get a no from your conflicts team saying you can't go ahead, you can't accept the appointment because we're interested in this party. Obviously, if you get an appointment from smaller parties, you get a chance that you say yes, but that's where the business considerations now come in. And this is also not groundbreaking, I'm afraid. Law firms are businesses. It's all about getting revenues. It's all about the fees. And I see from the audience some people nodding. Apart from, I guess, a number of arbitrators who get enough remuneration to justify the amount of work as counsel will always be more profitable for a law firm than work as an arbitrator. So coming again to what I said, a law firm is a business. Very often you get told, very nice that you get the appointment. You either do it on your own time, and I've heard that you do it as a hobby. You don't really bill anything in the system. You do it on top of your work because they still want you to continue the counsel work. Because as counsel, you can have teams of associates in a team that help you with the work. Your hourly rate is much higher. So you have a choice to either really continue this as a hobby, which obviously takes a lot of, 100% of your time, and you have no time for any type of life outside the firm, or you decide, exactly because of those considerations, okay, maybe if I really want to focus on an arbitrator career, I would have to either join a small boutique firm where you have a chance to continue working as an arbitrator, or you go solo. And I think the third consideration is actually personal, and that's a very important one. There are people that I think have realized after a long time practice in an international law firm or any kind of law firm that they're on top of their game, they've been there for a long time, they've reached the higher ranks of the law firms, and they say, okay, now I can leave and have, so to say, a second career as an arbitrator. The second point on a personal level is that people feel that maybe their skills are better used as an arbitrator. And the third and most important is that it gives you more flexibility in life. You avoid having to have a hectic law firm life, and you can schedule your life a little better, accepting a couple of arbitrator appointments. So I think the flexibility, especially in the last years, I have a feeling that at every conference or any networking gathering, people start to talk about this a little bit more, that how important it is to get that work-life balance and how important it is to have certain flexibility that unfortunately still the law firm structures don't really allow you to do. So these are the 3 points, and we have seen a lot of examples where this actually works. It's a very risky choice to leave a law firm and decide, okay, I will go. And so I guess, Melanie, you could also enlighten us on the considerations in terms of what do you really have to have there to make that critical choice of saying, okay, what do I need to have in order to justify that I can sustain myself, so to say. But I'm not the one asking here questions, so sorry.
She's looking for the secret sauce. Don't tell her.
Right. So, is my understanding correct, or do we all agree that there is a trend in the market that arbitrators are establishing their own practices, and some of them are focusing on just practicing arbitrator work? And if so, is this something? Is this a positive development for the market on the one hand, and for the quality of arbitrations on the other hand? This is a question for all, but maybe Johannes, would you like to address this first?
Of course, thank you. Also, welcome from my side, and thank you to the organizers for the invitation and for the organization, obviously. The short answer, I think, is professionalization is always good. If someone focuses on a specific task, a specific service that comes with more experience and that hopefully comes with a better product. Maybe 2 comments of caution. One is it really a new trend? I think people have gone solo or been solo practitioners forever. Some have this as their model since time immemorial. If you think of the barristers in England, they only practice as solo practitioners, and some of them sit as arbitrators and maybe only sit as arbitrators. You had this in the old days with, or still have it today, people retiring and at some age, and then they only do arbitrator work because that's what they think is still in line with their other commitments to the travel agency or the family or something. Some retire fairly early. I mean, if you get kicked out of the partnership in the big firms in London or New York at 55, you still have a lot of years ahead of you. And in other fields, they then continue as senior counsel, off counsel, special counsel, what have you, in the M&A, private equity or IP departments. So they stay in the firm in some capacity. In arbitration, it then may make much sense to go solo because you then avoid the conflicts, but it's not really a new development. What is maybe a bit new is that people start this earlier, and like Melanie did, not at the retirement age, but a bit earlier. So that's maybe new. The other comment of caution is this a trend that will last? Because at the end, you need the number of appointments to sustain you. And if everyone is doing it, at some point, the arbitrations are not, and the number of cases are not is not exploding. So I know of a few people that do this as a branding exercise, and you explained this very well. It's a new trend in branding yourself and marketing yourself. But then behind the scenes, you realize that they do a lot of other stuff as well to maintain themselves. And then it's not that different from what we had before, like a professor moonlighting as an arbitrator or a counsel in a law firm moonlighting as an arbitrator. It's just the branding is different. They still do other stuff. They may have 3 corporate clients where they do, I don't know what, regular business. And then the only thing they brand themselves with, or the only thing that they advertise, is the arbitrator work, because the other clients they already have. And then it's not different from what we were used to having. But in general, I mean, I'm all for it if it increases the quality. And for the clients, it's probably a good development in the sense that they have a wider choice now. They have the solo practitioners, but then they come from all walks of life. It's not just the professors or the having been kicked out senior partners. It's a lot of other people as well that work as arbitration only practitioners or arbitrators only. So we will see whether the market likes this at the end of the day. I think that's the question we can't answer today.
I guess we have a representative of the market in our panel, Christina, from the in-house perspective. What is your view on this trend that, as Johannes said, younger arbitrators are starting living big law or simply establish their own arbitration practices and sometimes even focus solely on arbitrator work?
Well, hello everyone, and happy to speak on behalf of the market. No, not the case here. Speak on my own behalf and based on the experience that I've gained working in this field and now more closely with the users, let's say. So if it is a positive development, surely it is the case, right? I would mention as the first thing that it allows more diversity and more profiles to be out there shown. Now we have, as Melanie mentioned, personal branding. So it allows more people to get visible. And I think it is a reflection of how the arbitration community could respond to this call for diversity, right? Which we're seeing across all professional world. So that's one aspect. Then obviously you avoid or the idea is to have less conflict of interest, right? So that's very relevant, less double hatting, which is maybe an issue, right? And we've seen this in other industries. There had been some discussion recently about the audit industry, right? They're trying to separate a bit the consultancy side from the auditing side, right? So it is something that we should be careful and having more solo practices would definitely help in addressing this issue. Efficiency, hopefully larger pool of arbitrators to choose from, and a more competitive market, right, with perhaps better fee arrangements, right? I think there was a study recently, right, saying that very large companies more and more choose to go to smaller firms, right, that potentially charge less. This could be the case with arbitrators as well. From what I've seen in my recent experience, there is no, we mostly look at experience and then whether it is solo practice, firm, of course, conflicts of interest, but it's not really something that it's definitely welcome to having a larger pool of people to pick from.
Thank you, Christina. So there seems to be a wind of change, or at least a breeze of change in this area of the business or practice model that arbitrators engage. But what about the criteria that institutions and users look at when selecting and appointing arbitrators? Do you see that there are currently any changes in your experience? And do you envisage that there will be some changes in this regard in the next, let's say, 5 to 10 years? Nada?
Thank you. Okay, where do I start? A lot of the criteria for the selection of arbitrators for the institutions and parties are the same. Unfortunately, they're still not the same when it comes to what Christina just mentioned, which is diversity and inclusion. I'll come back to that. But and I think it's been mentioned already today and yesterday what the criteria is. It's the experience, qualification, very often the expertise in dealing with that specific industry or the type of contract. That's usually what you as a party look into when you create that list of arbitrators that you're supposed to give to your client. Availability, obviously, as an important one. Language skills, cultural and political sensitivity and background. I think it depends what kind of case you are dealing with, but very often that comes into play. So all of these that I've mentioned are, I think, for the parties and the institutions, very much the same. Earlier, I think Sarah was mentioning, and in the previous panel, there was a discussion about how do you really look for those arbitrators. It is very often based on the experience. The bigger law firms obviously have a bigger knowledge bank, let's put it that way. It's not necessarily institutionalized, but you have a chance of calling your colleagues. We get emails through, IA International, where somebody's asking, do you have experience? And then very specific questions about a particular arbitrator, or you just simply ask your colleagues and friends in the community. But what I think parties don't really do that still, and that's something that we need to think as external counsel, is the point of diversity and inclusion, because we're more risk averse. Let's be very frank. We want to recommend to our clients the arbitrators that we have seen, we have experience with. We don't really take a risk on first-time appointments, or if they don't have enough appointments. And I think that's the institutions that are really taking a step forward, where almost all major institutions, luckily, have started to very loudly mention diversity and inclusion. We've heard today, I think, Scottish Institute of Arbitration, Sepani earlier this year, directly in one of the clauses when it comes to the selection of arbitrators, has codified that they have to look into diversity and inclusion. And Christina was mentioning about the pool. The pool of arbitrators, as a result of this trend that we're discussing, is and will necessarily increase. And it will increase not only for the gender. And earlier, I think, Dalibor was mentioning that in one of the previous panels, we're not only talking about diversity inclusion in terms of gender, regional diversity. And the ARP-CE, exactly what Dalibor also mentioned, on Wednesday was launched, and you could see room full of brilliant lawyers, very experienced in arbitration as counsel, as well as arbitrators. And unfortunately, many of these lawyers do not get the benefit of being appointed in arbitrations, because even in our region, laws that are governing are from the CE, yet the arbitrators that are deciding those cases still come from, I could mention probably 4 to 5 jurisdictions. And that's a very big problem, and that is something that will need to change. And I think the institutions are the driver force of doing that, and I am ashamed myself as a party representative that we are not taking more active roles. I have had cases from the CE region where we also did not recommend an arbitrator from the CE region. Why? Because we need to give them also more visibility, and the initiatives like the ARP-CE are exactly those that give these arbitration practitioners visibility, so that parties, if they are coming from the CE region, if the law is governing whether it's Romanian. I think the statistics show that Romania has a high number of arbitrations, yet 1 or 2 arbitrators being appointed, 1 arbitrator, and that's striking. And I come from Georgia, and it's exactly the same. Georgia has appointed 0 Georgian practitioners to the ICSID. We have had no Georgian arbitrator ever sitting in any of the cases, and even in commercial cases. It's mostly Germans, Austrians, Swiss. I have nothing, obviously, about these practitioners. I myself am practicing in one of these jurisdictions, but I think there is a disparity, and I think we as parties have to work like institutions do, and do more in terms of diversity and inclusion appointments. I don't know if Juliana has a question, actually. Yeah, and I think we can also do a more interactive.
Yeah, sure.
No, go ahead.
No, go ahead, yeah.
Yeah.
I wanted to ask the panelists what they think about an unintended consequence of diversity in terms of regional diversity in arbitration. Is this leading to a fragmentation of international arbitration, where, let's say, arbitrators from, let's call them diverse backgrounds, but backgrounds other than the traditional ones that we're used to seeing, are only suitable for cases that pertain to their own jurisdictions and nothing else, whereas there's other categories of arbitrators that can apply virtually any law without any sort of limitation. Is this what we want when we're speaking about regional diversity, or maybe we should aim higher, or for something else?
I could start the answer if the panelists, anybody wants to. I think it's the second. I think we're not talking, when we're talking about regional diversity, at least what I imply is not that if you come from Romania, you can only sit in arbitration cases where the law governing is Romanian. It's making it more international and giving the same opportunity to people from all regions. There is no reason why arbitrators from certain jurisdictions can arbitrate, and we know all these names, right, can arbitrate virtually any type of dispute under any law in this world, but that doesn't apply vice versa. There is an implied prejudice, I think, here about the qualifications of people from certain jurisdictions, the backgrounds, the legal systems, but we are forgetting that many years have passed since all this started, right? There, law schools have much higher standards. There are practitioners who've been practicing international arbitration for more than 15, 20 years. There is no reason why we still get the discrimination or the inherent bias that there are certain jurisdictions and lawyers from those jurisdictions able to decide cases under other laws and not vice versa. So what I imply by regional diversity is giving people the same type of opportunity. And
a small follow-up. First of all, I think Georgia is very well represented, Nada. So, yeah. Aside from this, I think, as you pointed, I think the aspect is internationalization, to have an international background, right? That's what gives you more visibility. So, because I'm thinking of a recent case that we had in Egypt, right? We're a bit skeptical of appointing an Egyptian arbitrator for this matter that was quite international, right? So, but if that person had an international background, that obviously that would have been an easier option. So I think, that could help fight this bias, I'd say.
And just to build on that, I was thinking perhaps to enhance diversity, you need to give people the opportunity first to be arbitrators. And I'm here looking at Melanie, because we have been talking a lot about exit appointments and so on, but maybe you can talk in general about how you get your first appointments. Are there any cases that are more suitable than others? What are the steps? What can you do to arrive there?
So how did I get my first appointment? I think the fact that I was working with an arbitrator doing, acting as a secretary to tribunals helped me a lot. It really gives you a very good perspective of how arbitrators do their jobs, and you get to be working hand by hand, with the arbitrator, and you get to go to the deliberations, which are really confidential. So the fact that you are able to see how arbitrators reach decisions, how arbitrators manage the procedure. I still remember Juan Armesto just in conferences, managing the parties, sometimes difficult parties, and it's really something that you see and you learn just by looking at how it's done. And it's really practical, and it's really nice to work as a secretary, because you don't have like all the responsibility, but still you see everything. So I think that for me it was pretty much a natural step. Although for many years they would ask me, do you want to be an arbitrator? And I would say, no, I don't want to be an arbitrator. I'm not going to be able to do it. And I'm comfortable being a secretary, until I received the first appointment, which was an ICC appointment. And I just thought that they just pushed me to the pool. And of course, I couldn't say no. And once I started the case, I felt that I was pretty confident, because I felt it felt natural, and it felt that all the years that I acted as secretary, it actually taught me a lot of things. And so I felt comfortable with the first case, and that's how it started. Now, regarding the second part of your question, which is, are some cases more suitable for first appointment? I was acting as the Secretary General of the Madrid International Arbitration Center. This is a new center that was created in 2020, and we actually did everything from scratch, so it was a beautiful project. And this is where I saw the institutional perspective, and obviously I always try to find new pool of new candidates for small amount disputes. But you have to be careful with this, because the fact that a dispute has an amount that is small doesn't mean that it's not difficult. Actually, the first case that I received was tiny amount, and it was really complicated. That was the first time that I saw a case like that, because the parties were not as sophisticated as the cases with Juan Armesto. So I saw many things that at the beginning I was shocked, so you have to learn little by little, but just take into account that the fact that the amount is not very big doesn't mean that it's not a complicated case. I don't know if someone else wants to answer, and I can go back to...
Please.
Or I can go back, or I can keep...
I just wanted to comment that I think the first question, how do you do that? I think very often it's coming back to what I was saying also earlier, is you get the first appointment through institution. I got my first appointment from SEC out of nowhere. I didn't know why, but I think it's the visibility, and I come back to the visibility that we need to give visibility to people, the organizations as YRAP and many others that are doing brilliant jobs, that if you get your name in the market, and especially people from certain regions, then, you know, if the case comes up, the institutions do consider you in their pool as, you know, on sometimes complicated, but a mountain dispute is smaller. Sarah, I think you were... Yeah.
Just a quick comment. I think there's a lot of different ways to be appointed in your first one. I was very fortunate because I was appointed as chair by 2 co-arbitrators who decided that they would always appoint a female, this was quite a long time ago, so this is when this was kind of a new thing, a female first-time arbitrator. There was one lawyer in London, and I was the benefit of that. I think a lot of people were the benefit of that. The wonderful thing about that is I wasn't alone, because you're right. Sometimes those cases that you're sitting as sole arbitrator, either the respondent's not participating, or it's ad hoc, or there's all these different complicated factors that make it more challenging, or the parties aren't as sophisticated. Those actually probably aren't the best ones for you to get started on. So I would encourage those more experienced practitioners to think about that, because one thing I think a young arbitrator can really do is manage the procedure well. I know because people want to do such a good job, they hustle, they really make sure they're responsive, they're all over the detail, they're all over the procedure, and it really helps busier co-chairs out. So I would encourage those people who are sitting as arbitrator more frequently to think about appointing a first-time arbitrator as a chair. There's a lot of great options of really talented people out there. The other point I just wanted to make, Nata, because I think I had a similar view of doing arbitrator and counsel work at my first firm, which was it wasn't as lucrative, and there's always conflicts, and they'll never let you do it. I will say firms are not all the same. And what I've learned at 3 different firms now is that each firm has its own personality. And you know, my current firm, CMS, they really support allowing all of us to do a few appointments at a time. Obviously, it's not the majority of our work because, and there are conflicts, but I would say, you know, also just to encourage young people that you kind of, you know, you can have a little bit of both worlds. It is actually very valuable to serve as counsel before you sit as arbitrator, because you really understand the commerciality of things that go into the counsel's decision, how it is to work with clients, and what our different struggles and challenges are managing our own clients. And then finally, I just think if you're at the right place, you can kind of manage. I have 3 beautiful children as well, who I see a lot and love a lot and cuddle all the time. So, you know, you can have a more balanced life if you're at the right place.
Can I just comment on...
Yeah, of course. No, go ahead.
No, I think the first suggestion that you gave is amazing, like, because we don't think about it, right? Normally, in most cases, the first case that you're going to receive is as a sole arbitrator, and you're just alone by yourself. So the suggestion to have 2 co-arbitrators thinking about young people that can act as president, that's perfect, because you're not alone, and of course, they probably have a lot of experience in the procedure. And regarding the institution, I think it's really important. Most of our cases will be from the first cases from an institution, and it's really great because this institution would trust you, and that will give you some visibility in front of the parties that maybe don't know you or maybe don't know how you work. At least if you have one appointment from an institution, you have that backup saying, okay, the institution has appointed her or him. Now, what is important here too is that you have to know that the institution has appointed you. So in terms of transparency, I think it's a really good idea to publish, and that's what most of the institutions do nowadays, to publish the names of the arbitrators that are sitting in the cases.
Just a small follow-up. One thing that I think is very useful, perhaps consider mediator appointments that could give you an opportunity to get more acquainted with the parties. You don't have all the procedural, rules that you sort of restrict you, and you get to know the business more and you're more free. That I think, I was quite skeptical about mediation, as I think most of us were at some point in life, but I've seen it working. There are situations where you have to, it really, for the right case, it's really to consider. So that maybe could be an option.
I was thinking perhaps we can move to the topic of next generation of arbitrators. And I'm curious to hear from you, what do you see as, let's say, I don't know, top 3 skills that will be important in the future to distinguish yourself as a practitioner?
I think that's me, and I'm talking too much, so I'll keep it short. We've talked about it today, I think, in almost every panel. I think in addition to the already known skills and criteria, I think Sarah was addressing this in the previous panel as well, tech literacy, let's put it that way. And we're not talking about sophisticated tech skills or anywhere coming to programming, just to avoid any doubt. This is very simple, starting from what has been already discussed, that people are more used to video conferences. I unfortunately still see some arbitrators asking for bundles and then bundles again before the hearing. So that should not happen with next generation arbitrators. So I think that the tech literacy will be one. The second, in my view, would be that the arbitrators, if the trend continues, will have more specific and jurisdictional and industry experience, and will be more specialized in being able to deal with very complicated tech, ESG, construction, all of those disputes. And I think the third, for me, I think this is the hope, let's put it that way, is that next generation arbitrators will be more cost and time efficient and take a stance in a confident manner. We all probably have seen cases, and Sarah was mentioning something along these lines, where arbitrators very often are afraid to take decisions in the fear or paranoia of due process, and allow protraction and hijacking of the proceedings, instead of coming back to, we've agreed it this way, and you have to just stick with this. And what has been also discussed, putting limits to parties, whatever, we want to have a 500-page post-hearing brief, but when it's not enough, you've pled your case. So having more confidence, experience, and the mindset of, okay, we will make this more efficiently, and take a stance when things go wrong or where respondents try to kind of derail the proceedings and have I don't know, this is just my hope, how I wish the next generation arbitrators to be, but it could be that never happens. So if you want to add, these are obviously my 3, and I'm sure.
No, I'm just going to follow up on a comment, because I think those 3 elements were perfect. Just regarding the digital part, I would say that the institution plays a crucial role in that. I remember that, at the MIAC, at the Madrid Center that I was talking to you about a minute ago, we implemented a digital platform, and everything had to be administered, like all the cases were administered in this digital platform, and you would be shocked on how many calls did I have with arbitrators and with parties that didn't want to use the platform, or they did use the platform, they uploaded their documents, but they were still sending the documents through email. So it's really a change of mentality. You have to change the chip. And I think that the institutions, not only the arbitrators and the parties, have to be very committed, but also the institution has a bit of a role of guiding the parties and the arbitrators through there.
I will just...
Can I make a bit controversial comment?
Sure, go ahead.
I think all the new skills is all nice, but I think we shouldn't forget the old skills. And in particular...
Like common sense, that's for sure.
In particular, I think our generation should be a bit more patient, because experience comes from doing and witnessing stuff, and that takes time. I remember very vividly about 10, 15 years ago, and a very famous arbitrator. I don't know if I can name him by name. I will check with Juliana afterwards. She knows him very well.
But now we all guess who it is.
There's two, so you have a 50% chance of being right. He told us before the age of 55, you're not going to have an arbitrator career to speak of anyway, because that's the time it takes for you to build experience in the field, for people to get to know you. Because one thing is you know something and you learn it, and the other thing is other people trust that you can then actually perform. And that again takes time. The institutions, they try to cut corners, I think, at the moment. I see appointments in my market, one of the shamed ones, where 30-year-olds get their first arbitrator appointment that have never seen a case from A to Z, arbitration case, neither as counsel, never done any secretary work. Do we need them? I don't think so. Be they 30 years old or what, we should just be a bit more patient. I'm all for the regional diversity. That's a very good point, because you have qualified practitioners everywhere. Get them to the forefront. But that also has to be then people that have experience. There's some jurisdictions, another jurisdiction I won't mention, where I was told when I studied that you pass your bar exam or your exam at university by going to the professor, you buy the book, and then you get the pass mark, and then you go home. Do I want to appoint someone from that jurisdiction? Probably not. In this case, it doesn't matter, because they've taken themselves out of the sort of group of civilized nations, so that will not happen. But here we also need a bit of time, and I think you're doing the right thing, going to the if I may say, to the Western conferences, presenting yourselves. A lot of people from the region working in London, in Paris, in Switzerland, and that's how we in the West sort of see you. And then this interaction will develop naturally into then practitioners also from this region being appointed. And the first thing, maybe appoint your own people first. I mean, if you have someone in London that is Romania based and you have a Romanian law case, then it's for you to bring up these names, because we might not know them. And then I'm all for it.
Neither do I.
Want to comment something? I hear this.
Yeah, probably. Thanks, Johannes. I think, of course, I think we're all talking about people who have qualification, experience. We're not talking about appointing people that have no experience. I think we all presuppose, but don't say that. Exactly like you said, we shouldn't forget the old skills. But the skills that we're discussing are in addition. Sorry?
The institutions don't necessarily do it. I know of a few institutions where people go to great length to avoid institutional appointments because they say we can't trust them. There's someone falling from the sky and we've never seen them before. I'm just saying there's...
No, and I think that could happen, but I would like to avoid generalization that also, I don't know what jurisdiction you're mentioning, where one person has bought the diploma. That can probably happen everywhere. It has happened in Germany, where we, for example, realized after 5 years that one of the associates had faked German second state exam. So I wouldn't exclude that it happens, and it happens only in I don't know, the jurisdiction that you had in mind. But I think we're talking about people who are experienced, who have the necessary skill set, but they don't necessarily get the chance to be appointed because of the lack of visibility. And that's where institutions probably also make mistakes. And probably there are new appointed arbitrators who haven't done as well. But we also know very experienced arbitrators who also haven't done so well, but yet we see them being appointed over and over and over again. And on those people, we seem to not generalize it on certain categories of arbitrators, and we keep appointing them because they're famous. Yet if one person from maybe, you know, I had heard about one female arbitrator that she did bad, and then, you know, that's why I will never appoint. You know, these kind of generalizations are just dangerous. My point is, it can happen. That institution has not appointed the right person, but it can also happen to very experienced arbitrators that they just not have read anything, they didn't pay enough attention, but we shouldn't just generalize based on selected single experiences that we have had that were not So good, let's put it that way.
All right, so enough of the arbitrator's perspective, and we would like perhaps to hear from someone who knows more of the user's perspective on skills and criteria, selection criteria. I mean, I've heard that you sort of agreed to the fact that diversity can play a certain role from the user's perspective as well, but is there any other criteria that you have in mind or other skills that are important from the perspective of the users?
I'm gonna take my time, Nada, okay?
Please do, talk to
No, sorry. No, just one comment, and I think both positions have to be sort of understood together, and I think the easy way was maybe for the institutions to do some sort of scrutiny of the cases and maybe consider more straightforward cases to be appointed for, newcomers, right? Let's say non-payment cases. You do a scrutiny, and those we should all be able to handle, right? And I've seen it in from users appointing like new names for very, again, straightforward cases. You have to file because somebody is not paying somewhere in the world. So those I think would be easier to handle and somehow would be close the gap between the two positions. Now on the skills. I think I would like to focus very much on this need for industry knowledge and general awareness of the business environment in which we are all part of in various extents. I think we've seen very much that the digitalization and technology and climate discussion has taken a leap in these past years, and I think the arbitration community should come closer to that. I have seen a lot of focus internally on meeting climate goals, decarbonize, adapting technologies to all that. And I think it is a race for the big players to get market into that, and I think it's a very complex area. That I think we should all try to become more familiar with, right? And just to give you some examples, everybody talks about hydrogen, carbon capture, emissions control, and all that. These are complex technologies, right? And everybody's trying to be the first one to patent it and to do it. And I think we've all seen that we're approaching the golden age for climate litigation, right? So I think it's very important to try to be ahead of that. And I think arbitration is obviously much better placed than state courts to sort of deal with these sorts of cases. So that is one aspect that I would mention. As much, I would say, a 360 degrees approach to what is happening in the world, right? So awareness, that is one. And then ethics and ESG, right? Other names, other concepts that probably have been mentioned very frequently, right? And we've seen arbitration is exposed to what are considered unethical behaviors, right? Conflicts of interest, double hatting, but perhaps illegally obtained evidence, right? And these raise question marks, right? So I think it is very important for the arbitration community, arbitrators specifically, to understand that arbitrating unethically may impact the ESG rating of a user, right? And so as a consequence, it may also impact the choice of arbitration as a preferred dispute resolution forum, right? So I think it's important to be mindful of the risk that arbitration becomes a less ESG-friendly dispute resolution mechanism. So, and finally, I would say adaptability, right? Going back to my point that the world is changing, so I think we should be ahead. And I like the word that has been used recently. We have to be switched on, right? To be ready.
I think these are very topical subjects which we could continue for a long time, and we're very mindful that we are approaching the weekend. So I'm going to try to draw to a conclusion here, and we'll open the floor for questions if there are further questions than the one that we already addressed. But before that, I would like to mention that we had a social media competition of inviting participants to send us questions, and we selected one winner who will be interviewed by YRAP, and we're going to publish that interview to enhance exposure and hopefully help them in their careers. So the question that we selected comes from Julia Angelescu. And I'm gonna read it for the panel. The question is related to the IBA guidelines on the conflict of interest. The participant is interested to know whether, do you think that the red list, the orange and the green categories are still useful in practice at the moment, or there's a need for a change, or perhaps should institutions also step up and prepare their own guidelines in terms of conflict of interest? Brave one.
Then you help me. Okay, so I think the IBA guidelines are from 2014, right? So, I mean, it's always something that we should, like, there's arbitration is developing, and the guidelines will have to develop at some point. I know that there are some institutions that are issuing their own guidelines. For example, Club Español del Arbitraje, Spanish Club of Arbitrators, have issued this code of conduct, and they have their own guidelines. And a difference with the IBA guidelines is, for example, that you have to, there's a gap of, there's a timeline of 3 years where you have to say if you have had any cases during the last 3 years, and the Club Español de Arbitraje, in their guidelines, they say 10 years. So it's a little bit stricter. So if they have to do it, I don't know, but they are actually doing it. A lot of institutions are doing so. The MIAC is doing also that. So I'm going to leave it there, and if there's any other questions.
Thank you. Any other questions from the audience? I have a couple. Maybe we can have a microphone.
Thank you. I have a question with an intro and then a comment. I hope I'm not going to waste too much time. The question is the following, and I refer to the profile of the next generation arbitrator that somehow is the king of this panel. And here comes the intro. I don't care as a counsel appointing an arbitrator about the age, whether he's a male or a female, whether he's a solo wolf or co-managing partner in an international law firm. I care about what that arbitrator can deliver immediately for my case. And leaving aside the classical technical skills, industry expertise, legal expertise, and so on, I care about a feature that I don't know why goes under the radar. It is passion or love for what the arbitrator does. And my abrupt theory is that you can have a very good robot / no feelings arbitrator, but an outstanding arbitrator is always, must be one that loves what he or she does. My question is whether in the profile of the next generation arbitrator, this feature finds a place, or I am too old-fashioned for the profile. And so that I am not interrupting in the future, the comment. I want to publicly thank young Romanian arbitration practitioners. They have become a traditional partner for Bucharest Arbitration Days, and we are very happy for everything that you deliver, and we are sure it is going to continue and reach the threshold even further on. That was the comment, and Violeta, Mihaela, congrats for everything you did, including for this panel. And now here comes the second part of the comment, which is, I think, a request to amend the clerical error. Your name is Young Romanian Arbitration Practitioners. As you know, in the legal field, accuracy is very important. And young arbitration practitioners are, for instance, Sara Vasani, Sorina, and Philippe Cavalier, and perhaps myself. You guys are very young arbitration practitioners. The name should be VYRAP. I rest my case and thank you.
We cannot argue with that. We're going to change it to baby arbitration practitioner.
Can I just follow up on the passion point? I think the answer from my perspective would be that nobody should be doing anything they don't like. So I just assume that next generation arbitrators actually do enjoy and don't spend their whole life working in the field that they actually don't enjoy. So I hope all of us do.
A very short follow-up, that is going to save us from AI, right? Passion and personalization. So just bring on the passion.
A final remark on behalf of YRAP, and I think that the mere fact that YRAP has been involved so actively in the Romanian arbitration community stands proof that the young Romanian arbitration practitioners are passionate about what they're doing and that they're actually yet another stakeholder in the international arbitration community. So I guess however outrageously young we are, we are the present and the future, and we want to, of course, collaborate with all the other generations. So thank you. Maybe we also, as a final note, need to announce the winner of the competition.
It's Julia Angelescu.
Congratulations. We will be in contact for the interview, and we promise a very engaging material for the YRAP LinkedIn page. Thank you.
Thank you, everyone. Before the applause, I would like to highlight a couple of things that I noted during the session. So we have learned from Nata that being an arbitrator in a law firm is a very time-intense hobby. Right. From Christina that we should not overlook the benefits of mediation, correct? And from Melanie, we learned about the importance of a business model and planning ahead before starting as a solo arbitration practitioner. And from Johannes, we know that we cannot rely on his predictions.